Heidi ho. Morning. I'm up on time. Yes, I am. Alright. Alright. How you guys doing? How you doing? What's up, GB? What's up, Anita? GB, I was just thinking about you. I just realized, was 90 Day on last night? I was like, uh-oh, I missed 90 Day Fiancé. So the trial doesn't actually start for a half hour, so I'm going to, entertain you guys for a half hour. And then I'm just going to let the trial run because I got a ton of candles to make. It was the season finale yesterday? No way. No shit. It's over already? Well, I guess, yeah, because most of them got married. You fell asleep? Not me. Oh my god, I can't believe it's over. That's alright, there's 36 spin-offs. Wow, they didn't even show a lot of them though. Like the girl from France, we know nothing about. Stephanie and Harris. It's like, I don't know. They focused on the same couples every week. I can't believe it was the season finale. That's crazy. Now I want to watch the first half. Hey, Texas girl. Do I watch till the trial starts? What's up, Irish Fairy? They showed Jovi and Yara's baby girl's birth. Oh, no shit. Wow, they went really fast forward. How'd they go from nobody knew she was pregnant to all of a sudden they're showing the birth? What'd they name her? I'll watch them when I'm making candles today. I can't believe it was season finale. Mila? That's pretty. And Michael and Frico got married. That I know. That sucks, though. They don't even show the birth or anything. I mean, they don't even show a pregnancy or if her mood changed. Was she still a bitch at the end? I know Rebecca and the other one are still together. The baby's 7 months old now. He was over. Oh, no shit. Wow. Because of COVID, he couldn't get back. Mila Angelina. Trevor was shocked when he finally saw Yara. When he left, she barely had a baby bump. When he returned, she was way out. That sucks, though. He couldn't get home for 4 months. She's funny. I can't do 2 babies by myself. It's impossible. Oh, do you really?
When I have her.
You had some problems?
Yeah.
Yes, a little bit of bleeding and stuff, but
yeah, but nothing.
I kept it in control, and it was a scare for both of us.
Yeah, I mean, was it something that like when you were in the delivery room that happened, or when you came back home?
Yeah, in delivery.
Yeah, well, that's scary, but I'm glad that everything is okay. And like I said, what is that one thing about parenthood that you wish somebody told you before you had your kids? I know obviously the lack of sleep and things like that, but is there anything about feeding and things that you had no idea what to expect?
I was to know before that my nipple can broke. That's something so much crazy. Oh my goodness. I was when I first up. I mean, this little bit. Yeah, of course, I'm a little bit paranoid. I want everything the best for her. But that thing was so much hurts in the first few weeks. I was like, oh my gosh, there's just so much hurt. When nobody tell me that there's so much hurts, I will get myself ready.
Rebecca and Ziad are still together. Tarek and Hazel are still together. Mike and Natalie split up. What a shock. Julie and Brandon are still together. Andrew and Amira are not together. Jovi and Yara are still together. Stephanie has a new boyfriend named Quincy. I want to see who Quincy is. He's got 8,000 followers. Quincy is 34. He seems to have money. Wow. She's hot. What's wrong with her Instagram? What's up, Johnny? What's wrong with her Instagram? I think she's absolutely stunning. So you do follow Stephanie and OnlyFans, and he reports what's on it. Stephanie is out there big time. You said check out Amira. And she's hot. So someone, I got for my Diane people, somebody's been looking into this hardcore. I don't know her real name, but she's been sending me info on Instagram. And she's found a lot of shit. Like, a lot of shit. This is the last message I got from her. She said, I have the court records of Bob's company in Florida that the government shut down in September 2020 for tax evasion. Diane is on the company as executive assistant. He has 6 aliases. I have them all. He forwarded the mail for the company to the PA address. That's why he picks up his and Diane's mail. The Florida address is 20 minutes from where she sent Jules' package. I'll send it tomorrow if you even want it. Bob is definitely her partner. Wow. That's what I'm saying, Anita. She got a whole bunch of stuff. So the YouTube URL is 821. It's same as her old blogs and sites from a decade ago. The Babcock fraud was mostly people at home and call centers, not actual brokers. They're cons. She changed her YouTube URL when she vanished off YouTube. Isaac said her last name was in the PIC MFW shit. It was the wrong lady. It's linked to a Pinterest account, too. Just hang on to it. Her real name is DP. I have the court documents from lawsuits and the Sing Snap court documents. I'll send tomorrow at some point. Damn. Crazy.
Stated, I had to tell everybody that my Amazon store, that any money, little bit of money that's earned, it goes to me, because I cannot have it appear that I'm pushing traffic to a charity. It's against the terms of service. So the money goes to me. I am earning money. I even have
Yeah, it looks like Bob is dirty. And there's more. That live is with you. Diane made it the $1,000 Jude fundraiser. She was matching dollars. They raised almost $2,000. $4,000 would have been sent to St. Jude from Diane. The video was deleted off Playboy YouTube Analytics. The videos that made around 1,000 plus are removed from it. The fundraiser that has your name linked to it as a bet, please show everyone. It's almost $2,000. Tiffany's was $1,600. That's almost $4K alone. So her income for 3 years was only $12K. She deleted tons, and lifetime income shoes $16K. She's funneling money to someone. LA had 2 earthquakes early this morning. 3.3 isn't bad, though. Maybe Wendy walked, and that's why there was an earthquake. She got out of bed and walked outside. Boom! 4.0 earthquake. That bitch made $2,000 on my name alone. And they got a right to talk about me? Bitches, please. Please. Bitches better keep my name out of their mouth. Or I'm going to be collecting that $2,000. Why aren't you the sourceful? She made more than that. That's one. Yeah, I just mean that one stream. Everyone talks about Tiffany's 1,600. She made almost 2,000 on me in one stream. So between the both of us, that's $3,600. Show the receipts, Diane and Wendy. What was I doing? Earthquake. Yeah, over by Anaheim. In between Anaheim and Long Beach. I'm telling you, Wendy walked outside. And the whole earth shook. Yeah, it was an earthquake, but it wasn't nothing really out of it. Like, the news reporters didn't even shake. Oh, you know what? I think our mask is lifted today. Man. They extended it again. April 9th. April 9th, our mask order is lifted. Are you going to cover the Robert Durst Jinx trial later this year? It was postponed last year due to COVID. Maybe. Probably. Hey, if you had GameStop shares, I hope you got rid of them because the stock just tanked. All right, we should be starting in like 5 minutes.
Democratic strongholds like Fulton County. And remember how frustrated President Trump was with the man who runs elections in Georgia, the Secretary of State. Well,
to call an audible during, to use a sports metaphor, during the trial, to say, oh yeah, you know what, this is coming up. We didn't really know this was going to come up, or we couldn't really settle this before. Now we're going to settle it right before it comes up. And so that's what they're doing now. Rhonda?
Now, Mary Beth, if you could, and I apologize if I have to interrupt you at any moment, I'm sorry, but if you could walk us through the charges against Derek Chauvin. I think that's something that we haven't talked about at length yet, but he is up against 3 charges right now.
Rhonda, I'm really glad you asked about that. The testimony last week was so powerful that we're rightfully very focused on that testimony, and we haven't gone to the charges yet. There are indeed 3 charges against Derek Chauvin. The first is second-degree murder. Second-degree murder carries with it a charge of up to 40 years in prison, and it's unintentional murder while committing a felony. And then the second charge is third-degree murder, which would carry with it a sentence of up to 25 years, and that is perpetrating an eminently dangerous act and evincing a depraved mind. So that's the second charge. The third charge is second-degree manslaughter. Now that's a sentence of up to 10 years or up to $20,000 or both. And that is a culpable negligence creating an unreasonable risk. And so those are the 3 charges. The way that I just read them are extremely legalese. I mean, I'm reading to you literally right off the charge sheet, right? The state's charge sheet against Derek Chauvin. And so they are serious homicide charges, obviously.
And Mary Beth, I want to get your take too on today. So we are expecting at some point the chief of police to be on the stand today. He has already, before this already began, he was discussed as one of the key witnesses in all of this. So as you watch today, what will you be listening out for?
Rhonda, I'm glad you asked that, because on Friday, we ended with Zimmerman talking about what was reasonable use of force and what was, in Zimmerman's words, I believe the phrase was totally unnecessary. I have it in, yeah, it was. I have it in my notes somewhere. Totally unnecessary use of force. The reason that those are so important is because the charges that I just read to you, all of them, they're in decreasing order of severity, right? So the worst one is second-degree murder. The second worst one, we think of it as societally, morally culpable, right? The worst one is second-degree murder. The middle one is third-degree murder, and then the last one is second-degree manslaughter. But all 3 of them include 2 things, and one of them is that excessive use of force, is that that a reasonable officer would find this, what Derek Chauvin did, including the knee on the neck for more than 9 minutes, to be an excessive use of force. That's why this police testimony is so critical for the prosecution. And that's why limiting it is so crucial for the defense, because when the jury goes back to deliberate in 3 weeks or whenever, one of the things they have to decide to find Derek Chauvin guilty of anything is that it was an unnecessary use of force, that a reasonable officer, it's a reasonable officer objective standard, that a reasonable police officer would find what Derek Chauvin did to be excessive use of force. So that's one thing that all 3 of those charges have in common. And that's why the Zimmerman testimony was, to me, maybe the most damning of all of the testimony last week, because it really went to another police officer giving that frame of mind of what is reasonable and what is unreasonable, and somebody who's been on the force for many, many years. And of course, the defense tried to say, like, you've been on the force for a lot of years, so you don't really know what's going on right now. So, that's one of the things that the jury is going to weigh, is does Zimmerman really understand what a reasonable officer would do? And the testimony that's coming up right now, that's the other thing that we're going to see. So that's speaking to what is reasonable. Was what Derek Chauvin did reasonable given the circumstances? That's going to be critical with the jury.
And you mentioned Zimmerman, and I want to, for people just joining us, I want to play a clip from his testimony because it was so striking last week. Watch prosecutor Matthew Frank question Minneapolis Police Department Lieutenant Richard Zimmerman about use of force.
Based on your review of the body-worn camera videos of the incident?
Yes.
And directing your attention to that moment when Mr. Floyd is placed on the ground?
Yes.
What is your your view of that use of force during that time period?
Totally unnecessary.
What do you mean?
Well, first of all, pulling him down to the...
Okay, let's go now to the courtroom where Judge Cahill is.
A motion only to include the entirety of Mr. Chauvin's body-worn cameras in connection with this case. As the court is aware, this is a totality of the circumstances analysis based on what a reasonable police officer would have done in similar circumstances. I believe that after the way the state presented it, there was a lot more that happened after that affected certainly Mr. Chauvin's thinking, his process. He continues to investigate the original forgery. So it's showing his actions, and it's also showing what's happening with the civilians and bystanders at that same time, similar to what was happening at the time they had Mr. Floyd restrained. So I think it ultimately goes to a totality of the circumstances analysis. It shows his reactions, you can hear his voice, and I think it ultimately becomes an important piece to present to the jury. I believe that with respect to the milestone camera, Your Honor, we're reserving that at this point.
Yeah, I've reviewed all the videos that the defense provided as an offer of proof, and I think the milestone parties have to get together and figure out what is already in and what is not before we go any further. So we'll deal with that perhaps either tomorrow or Wednesday, most likely on Wednesday, because tomorrow we have to deal with the Mr. Hall's invocation of his rights. Mr. Frank, what's the state's response to this motion?
Good morning, Your Honor. Thank you. I will try to be expedient, but yet I do want to be precise and thorough. We had submitted, as you know, some of Mr. Chauvin's body-worn camera video already. There are really 4 videos that came from Mr. Chauvin's body-worn camera. Each one is labeled with a distinctive number that I believe represents the time it starts. So the first one we put in was 2011. That is essentially the drive there. We put all of that in. 2017 is the next video, and I believe we put all of that in. And 2034 we put in through the timestamp on the video of 20:36:42. So it's my understanding that the defense is asking then to put in the remainder of that video from that point forward. And just to describe a little bit what happens, then Officer King comes out and asks for an envelope. He discusses with Mr. Chauvin some information he learned from somebody in the store, presumably the manager, investigating the bill. He has the bill. and Officer Chauvin at the time confirms that there were goods and services provided. Officer King indicates that was our guy. That also obviously all presents two levels of hearsay from the store manager through then Officer King. They then continue a discussion about the car keys. Officer King talks about getting the security camera videos or noting them, and then there's a short discussion about the vehicle. So in addition to the obvious hearsay problems, I think there's also a relevance problem. The totality of circumstances, of course, is judged from the view of a reasonable police officer at the time of the force. This is all subsequent investigation that, of course, could have been done before trying to force Mr. Floyd into the back seat, but it now loses its relevance because it doesn't have any bearing on what the officers knew or believed at the time the force was used. So it is all relevant. Whether Mr. Floyd actually knowingly passed a bill is simply irrelevant to the officer's use of force. So that is why we object to the remainder of that video. The fourth video, Your Honor, is 2045. We put in we put in a short piece of that video. The remainder of that video is a conversation in which Sergeant Kluger talks to Lane and King and Mr. Chauvin with a brief rundown of what happened. It's Lane and King speaking, and Mr. Chauvin standing there not making any corrections or additions. And so obviously, again, a very real hearsay problem, and not aware of any hearsay exceptions that would allow those statements by the non-testifiers to come in. Also, to the extent, Your Honor, that it is admitted, we would argue that it's an adopted admission. So we want to be clear about that on the record. But there is an obvious hearsay problem there. It's essentially, this court has seen this in its service as a judge, that it's simply trying to get in self-serving hearsay, a defense without having to testify. It's very clearly what's being attempted here, and what's not permitted is to do that through hearsay. So we think that is irrelevant as well, and prohibited by the hearsay rule.
Let me ask you, on the 2045 video, that discussion is primarily about what happened with Mr. Floyd, the use of force. Is that correct?
Correct.
Is there anything beyond that, really, in that 2045? Or Mr. Nelson, is there anything on the 2045 tape that, beyond the discussion about what happened as far as use of force?
Yes, Your Honor. There's discussions about who's going to go to the hospital, who's going to stay behind, and things of that nature.
All right.
That's correct.
All right. As far as the 2034, you put in through 2036 and 42 seconds. Is there anything beyond that on the 2034 video that specifically relates to the use of force or dealing with Mr. Floyd?
Not that I recall, Your Honor.
All right. Okay, thank you. We're going to reserve argument and decision on the milestone camera until later, probably Wednesday, since we have another legal issue to deal with tomorrow morning. As far as the 2034 motion or 2034 video, I'm going to allow that because the defense is not really offering the defendant's statements or anybody's statement, for that matter, for the truth of the matter asserted. Therefore, it's not hearsay. It's being offered more to show it is relevant because it shows Mr. Chauvin's demeanor and his actions immediately following Mr. Floyd being removed to the hospital, and I think that is relevant for the jury to see his demeanor and what actions he took afterwards. And so the remainder of the 2034 video will be put in. On the contrary, the 2045 video will not be allowed. It is hearsay. I've reviewed it in its entirety, and it does appear that it is primarily of Officers Lane and King giving their side of the story, so to speak. It does not fall into any of the 804 exceptions for an unavailable witness to allow as hearsay. And I do not find that it was an adoptive admission by the defendant. He is there, but mere presence at a hearsay statement does not constitute an adoption of what is being said. Accordingly, the 2045 video will not be allowed.
Conversation, would those be allowed?
There were matters after the conversation, which specifically, Mr. Nelson? Why don't you go up here so we can go over that.
Again, specifically, Your Honor, after that commentary, there's additional conversation amongst the officers about who's going where, what's happening, who's going to the hospital, who's...
Any objection to that, Mr. Frank? Again, it's not really offered for the truth of the matter asserted. It doesn't seem just decisions on why some people went and why some people did not. All right, we'll allow that. Make sure it's tightly edited so that recollections that are being reported out about what happened with Mr. Floyd are not in there. All right, I think that takes care of that. We have, the jury is here, so I think we can bring them in. Just for the record, the next hearing is going to be on the record with spectators present, but we are going to go off audio and off video, so it will not be broadcast outside this courtroom. I think, and I'll make a record as to why we're doing that when we bring the jury in.
We are now in a brief break as the jury is escorted into the courtroom for today's testimony. You are watching a Washington Post special report. I'm Rhonda Colvin. With me this morning, Eugene Scott, James Homan, and Mary Beth Albright. Mary Beth, we just talked about motions, what they are. Can you translate some of what we just heard from the lawyer or from the judge?
Absolutely. So what happened is the defense has asked for all of the body cam footage that was on Derek Chauvin at the time to be allowed in. When you have a trial, only evidence that is relevant is allowed in, and only evidence that can be confirmed by somebody that it is accurate can be let in. That's why last week we had lots and lots of witnesses coming up to confirm that they took that their own cell phone videos of the death of George Floyd, because without those people, you can't let that evidence in, right? Right now, we are unsure if Derek Chauvin is going to take the stand. So we can't get Derek Chauvin to come up and say, hey, yeah, that body cam footage is correct. So right now, what the defense is saying is we should let that in just because it is so relevant to this case. And it's so important as to Derek Chauvin's state of mind that we need to let that body cam footage in without anybody authenticating it. And the prosecution is saying, look, it's not relevant. It's not relevant. They're just discussing some stuff. There's nothing really in it about George Floyd. So it's an interesting question. What Cahill has done is allowed in some of the footage, but not the rest of the footage. And the footage that he's allowed in, it sounds to me like it goes to showing Derek Chauvin's state of mind while all of this was going on, right? And that's what you heard. We discussed this before the motions hearing, and you heard the defense saying this, is that it's a totality of the circumstance situation that you need to look at, given the totality of the circumstances of what was going on. Would a reasonable officer have done what Derek Chauvin did? And so they're trying to show the totality of all of the circumstances that were happening by allowing all of the body camera footage in. One of the reasons why this is so important is that this is the kind of legal decision that might be brought up on appeal. If he is acquitted, if Derek Chauvin is acquitted, obviously that's we're a lot really far from that, but if he's convicted, then he could appeal and say, well, we should have let all of the body camera footage in, right? So this is the kind of decision that is these little decisions that work our way up the mountain, and every single one of them can be challenged in an appeal if he is convicted.
Yeah, Mary Beth, I was struck too by the fact that it seemed like really small details, like, oh, this video will show who's going to be going with whom to the hospital, and just some of the conversations surrounding very small details. So I'm glad that you broke that down for us, but I would like your take on this. Is the decision behind letting some of these videos and other evidence in also something that they may be thinking about in terms of the other officers who will be facing trial in August? If they let something in that features them and their actions, this could also hurt or help them later on.
Well, it's not supposed to be, but we know that this is being covered, right? We're live streaming it right now. We are all watching it right now. It is being watched around America. Just because it is let into, this body cam footage is allowed into the Chauvin trial does not mean that it is automatically allowed in as evidence into the other trials. And I'll stop there because I see the judge is coming in.
All right, thank you so much, Mary Beth. Let's take a listen to the courtroom.
We'll be doing this hearing entirely off the record, or on the record, but off audio and video. I'm going to ask you several questions, but first of all, I need everybody to raise your right hand. Do you swear or affirm?
Okay, it appears that the judge is swearing in the jury right now, but he also noted that this hearing is going to be off video and off audio. So that is a new detail to us right now. I think Mary Beth and James and Eugene, you're all three still with us. Eugene, what's your takeaway that now this testimony today has sort of taken a turn where we're not going to see the audio or video?
Well, I guess it's just a reminder of just how up in the air and uncertain so much of this is. You go into these trials thinking that this is what is going to happen today, and the reality is that is not finalized, and different factors can change things, and this is one of those. I think people not familiar with the process are learning quite a bit and figuring out how these things can change and ultimately have an influence on the jurors and can influence what they decide ultimately. I think very often when these trials are not well watched or publicized, you're just reading things after the fact and wondering sometimes, why did things go this way, or who played a part in this shift? Right now we're seeing who is doing what and why and how and the long-term implications of all of that.
And Mary Beth, I want to get your take in on this too. The judge has been pretty predictable so far. He's started on time, as James noted earlier, so when we saw this long delay, we knew something was up. He said that he will explain the reasons why some of this may not be heard or seen. Could you tell us about why a judge may come to this type of decision? I know we don't have details right now, so I don't want you to speculate, but what might be going through a judge's mind right now as they're deciding not to broadcast this?
So thank you for reminding all of us not to speculate. It's an important reminder because it goes to what we were talking about right before the judge came on, Rhonda, which is about the trial of the three other officers who were present when George Floyd died. You don't want to prejudice any sort of jury pool for anyone else who is going to go up and be charged for really serious crimes. And so that might be a possibility of why a judge would not want to televise something. That it could prejudice a potential jury pool. I don't know what specifically is going on, but we were just talking before the judge came on about that, and so I think that's a reasonable that it's a possibility as to why a judge would do something like this.
Right, and again, we're not speculating, we're just trying to figure out, we're waiting to hear what might be going on, what are the details so far. James, you mentioned earlier that this delay was remarkable in a sense because Judge Cahill has been on time most days and hasn't taken this long of a break that I've witnessed, and I've been watching it since the jury selection process. You know, as we've said before, James, you're from this area, you know it well. What has been your takeaway about how the judge has been handling this case so far?
Well, Rhonda, it sounded like this isn't going to be a long period where the audio and video are down. It sounded like he was saying they're going to entertain some specific motion, and then they'll resume the trial. And there could be a host of reasons why he would do that to proceed that way. One of the things that was striking, Mary Beth has broken down those motions, which I think was sort of probably more a win. It was probably a split. There was a little bit of both what the prosecution and the defense wanted there with those motions. What I think is most striking from that exchange that we did see is basically what the defense wants to do is here. I think the judge is coming back.
Video and video. The court had just conducted a Schwartz hearing with the jurors regarding a matter. The court makes the finding that there was no juror misconduct and that the jurors were credible in their responses, and accordingly, no action will be taken. All right. Anything else? Oh, we do have. Mr. Nelson, if you could make the record. Now, I will note that you made these objections before Lieutenant Zimmerman's testimony, and we said you could preserve it with an objection on the record later.
Certainly, Your Honor. Yes, Your Honor, just for the record, last Thursday we had a hearing with Sergeant Pluger outside of the presence of the jury for an offer of proof to note an objection as to Sergeant Pluger's assessment of the use of force in this particular case. I made those Friday morning in chambers. During a chambers discussion, I made those same objections with reference to the motion in limine that had been filed prior to trial to prevent every single officer from coming in and giving their 2 cents as to the reasonableness of the use of force. I made those same objections to Lieutenant Zimmerman's testimony, and I just wanted the record to be clear that that objection continued for that testimony as well.
Given their involvement with the case, Sergeant Pluger and Lieutenant Zimmerman, I did allow the state to elicit, and based on their training and experience, I did allow them for the limited opinion that the amount of restraint was, I think Lieutenant Zimmerman said uncalled for, but that it was not appropriate, and so I denied the defense motion to suppress those opinions.
And I would just only note today, Your Honor, because we have at least 3 officers that are coming in to testify. I understand that Chief Arredondo will be testifying today, and I understand that the court is permitting that per policy and his policy decision makings for employment purposes. However, there are 2 other officers that are in the train. One is the commander, Katie Blackwell, who's in charge or oversees the training. I would note that, again, she has opinions, as well as Sergeant Kerr Yang, who is in charge of the crisis intervention program. Again, now I'm concerned that what's going to happen is we're going to, and then we have use of force experts that are coming in. So I'm concerned that the state is pigeonholing expert testimony in through these officers, where I think that these officers should be just allowed to testify. These are our training materials. These are our training policies. These are what we do. So.
And I am allowing the chief's testimony that the use of force was contrary to policy. It's Lieutenant Blackwell. That opinion, Inspector Blackwell. I'm allowing that opinion, but why Kerr Yang are we crisis intervention? Are we trying to get in Mr. Floyd's state of mind through the back door here?
No, Your Honor. The proffered testimony of Sergeant Kerr Yang will just be regarding Minneapolis Police Department's crisis intervention training that they provide to officers. It's a 40-hour scenario-based training course in which paid actors come in and they go through various scenarios such that officers would be able to recognize people who are emotionally and behaviorally disturbed, and to be able to understand that some people are unable to comply with commands rather than being unwilling to comply with commands, and all goes to the reasonableness of the police officer and the actions that they take.
So Sergeant Yang is not offering any opinions per se?
He is not. He's only going to be describing the training.
And you have evidence that Mr. Chauvin took that training?
Yes, Your Honor.
Mr. Nelson?
Your Honor, that was my understanding of Sergeant Yang's testimony. It was limited to the crisis intervention program and training that officers go through. It is within the policy, that part of the de-escalation policy and things of that. And so what it would also include would be what officers are specifically trained to do to identify the difference between someone who is willfully resisting or intentionally resisting arrest versus someone who's having an emotional problem.
So just so I'm clear, there's not going to be any video shown and Sergeant Yang opining on whether this person was emotionally distressed?
That's correct, Your Honor.
All right, if it's simply a summary of the training that's provided and that Mr. Chauvin, his personnel record shows that he took that training, that's fine. Anything beyond that, including videos or opinions, I'm not going to allow.
And so, Judge, I just want to, I think this touches on something that was technically reserved during motions in limine, was the issue of which training materials would be admitted, because Ms. Blackwell, Inspector Blackwell, both parties intend to introduce training records that the Minneapolis Police Department has prepared. Both sides have intended to introduce those. There has not been a kind of a determination, I think, as to does the state or the defense need to specifically prove that Officer Chauvin experienced that direct training, or is this just the general policies and training materials of the Minneapolis Police Department? And that's what we had tried to work out, and it's not that we haven't. I just think the conversation got on the back burner.
Well, I'll just give you my thoughts and see if this answers any questions you have about it. My analysis of this is, we have said Mr. Floyd's state of mind is not relevant. It's the defendant's state of mind, his knowledge and his intent. And part of his knowledge is based on training he's received. So a summary of the crisis intervention training he has received is appropriate. We're not getting into, I suppressed the psychiatrist's testimony about what was Mr. Floyd's, was that truly anxiety or whatever. I'm not going to let a trainer say, look at the video and give those kind of answers. But evidence regarding what Mr. Chauvin knew, what he had been trained on, which goes to intent and knowledge on the May 25th, 2020, are all relevant and would be allowed. So I guess what am I missing here, Mr. Nelson, that still needs to be clarified?
Well, I think we get into some problems is in terms of how a connection between had Mr. Chauvin actually gone through this specific PowerPoint presentation, right? So the way that and this goes to how the disclosures were initially given to me, and then how they were subsequently.
Well, why don't you switch places here?
Thank you, Your Honor. So it gets into certain issues. So Officer Chauvin, a 19-year veteran with the Minneapolis Police Department, has completed 844 some odd hours of training. As the court is aware from our continuing education, I go on the CLE and I report I attended this all-day long seminar, but within that all-day long seminar there's 5 to 6, 7 different presentations. I think that that's ultimately what we see here is we look at Mr. Chauvin's what are called workforce director training records, and it says he attended the 2020 use of force phase 1 defensive tactics presentation. Now, what does that consist of? Has been virtually impossible to reconstruct, and it goes to primarily how it was originally disclosed to the defense, how it was disclosed from the police department to the BCA, from the BCA to the defense, and then that formed the basis of my earlier motion and earlier proceedings to get a copy of that BCA drive. So when I originally received these training materials, for example, these training materials are 20 to 30,000 pages in PDF format. And you can look at some PDF of a PowerPoint presentation, and it says use of force academy, whatever the topic is. No frame of reference as to when this was given, who, there's no title, there's no dates, there's no information, who taught this course, who attended this course. And some of that information contains very important statements on the part of the Minneapolis Police Department. When I receive the BCA drive much later, and I look at them in their native formats, the reason I wasn't seeing the titles of these presentations or the dates of these presentations is because that's how they were saved on the drive. So it would say 2018 Phase 1 Defensive Tactics, right? So you know that this is now the training material from 2018 from the Defensive Tactics course, or it will say 2018 Crisis Intervention Training, whatever, 2018 Human Factors of Force Training. So the dates and titles of these courses were given on that drive. Now again, you can look and you can see in his workforce director training or his workforce director program that he got credits for this 8-hour day. But again, which presentations were given on that particular day, you can't, there's literally no way to put this together. And I don't think that the state would disagree with that.
Well, let's see if they do. Mr. Slisher, can you tie a specific training module to the date that Mr. Chauvin actually attended?
Your Honor, what we can do is first show the workforce director training, which memorializes what particular trainings, in-service trainings, the defendant has attended, and the titles of those different trainings.
Okay.
Then what we can do is have the trainer specifically talk about the materials and curriculum that they've developed for those blocks of training. And
for those dates.
On those dates, for that. So for example, if it's going to be the fall in service, there was a PowerPoint presentation that was developed from the curriculum from that fall in service, and they can say that PowerPoint training was in fact presented. And these materials, they get recycled from year to year. There's nothing markedly different, in my view, from one to the other. They cover the same generalized concepts. And so, from a foundational standpoint, I think it's pretty clear that the training, the content, was imparted on, in this particular class, and that the defendant attended that class.
Well, it seems that a necessary foundation, I think you'd agree, would be this is the training provided on this date that the defendant's records show he attended. Even if it's embedded with 8 hours of other training, I think that would make it relevant. If you have training, but you cannot connect it to a training that Mr. Chauvin was at, it's hard to say then that you've laid the foundation for it. But it sounds like you've got the foundation. Am I correct?
Yeah, I think it's pretty clear, Your Honor.
Now, as far as the other issues Mr. Nelson's identified, that seems to be more weight. It goes to weight, and you can cross-examine on it and say, this was a 3-slide PowerPoint in the midst of 8 hours of training on other topics. And that's pure, absolutely fine because it goes to the weight, the evidence, as opposed to its admissibility. All right, Mr. Nelson, one last comment?
Yeah, I guess, Your Honor, I'm not objecting to the admissibility of this training. The question becomes, I think, and I don't think that it's as easy as presented, it's because even some of the things that they've said that they intended to introduce, which are that are clearly from the academy, from the police academy, they're not from in-service records, but it contains the information that may have been a part of some other training. That's where we. So case in point, there's a PowerPoint presentation from the Minneapolis Police Academy about nerve manipulation and basically joint manipulation, nerve endings, and how to gain compliance through pressing or depressing someone's nerves. It's clearly a training material from the police academy from 2017 or 2018. Officer Chauvin was not in the police academy in 2018, but ultimately it's part of their training. Now, where did that come from? When was it presented to him? I don't know, and I don't think it could ever. There is no other record of that type of training. So there are training materials. I think there's two levels. If the Minneapolis Police Department comes in and says, we never train our officers to do X, right, and insert X, but there are training materials that contradict that testimony, that undermine that testimony. I'm not questioning the foundation for these records. These records exist. They all came from the Minneapolis Police Department. But whether or not I need to show that Mr. Chauvin had that specific training, I think is one question.
Well, let me stop you there. It seems like there are two levels here, and I think the foundation for any of this training material is, at one level, if it's certain training, defendant has been exposed to, he's been part of that training, so he has certain knowledge based on that training, that certainly seems admissible. If it's training that was provided by MPD, but there's no indication Mr. Chauvin took it, or this is not the version that he was trained on, that does not seem relevant at all. The only way I could see training that he had not attended, which might be relevant, is to impeach, for example, and I don't know if this is true or not. I just note that Lieutenant Zimmerman said in his 40 years, roughly, on the Minneapolis Police Department, he had use of force training every year. He was never trained to do X. And if you have use of force training that impeaches that statement, I think that's appropriate impeachment. But aside from that, I don't see why testimony that the defendant has not been a part of should be admissible at all.
And that was kind of the concern that I had and had raised in terms of why I thought it was important that each side identify those training materials that needed to be or were intended to be introduced. Because, again, I agree with the court's analysis. It's an impeachment question on one hand. If as Lieutenant Zimmerman says, we were never trained to put our knees on the neck, but there's a Minneapolis Police Department policy that says otherwise, and there's ample training materials that would contradict that statement. That's impeachment of testimony, and certainly should be admissible for those purposes. Now,
yeah, had he not said that, for example, I don't think it would be admissible, because again, this is training that the defendant didn't have, and unless you can show he had that training, it's not admissible from either side.
And I think that goes to sort of some of the problems why I raised you can't have every single officer come in and say this was or wasn't a reasonable use of force, because the training he had may be different than the training that Zimmerman had.
Right. And so we've got so far opinions from Sergeant Pluger and from Lieutenant Zimmerman on use of force. We're going to hear from the commander or the then commander of the training unit about it. Beyond that, I think we have an expert witness from the state and an expert witness from the defense. Is that correct?
Two expert witnesses from the state on use of force, Your Honor.
All right. We are getting to the point of being cumulative. We're not asking every officer because that's cumulative, but also even having two seems like it might be cumulative, but I'll deal with that later. It just seems like, we said early on in the motions in limine, you're not going to be able to ask every officer, what would you have done differently? And we're not going to go through that. I've given you pretty good leeway that the sergeant who was involved in the case and the lieutenant who was involved in the case, a lieutenant who's been a peace officer for roughly 40 years, gave his opinion. Now you're going to have the training unit and the 2 experts. That's it. We're done with it, with asking other officers about the use of force. And Sergeant Yang, you can ask about what the training is on crisis intervention if the defendant had that training.
And so this is where, again, I don't know if the state is intending to call any, so Inspector Blackwell, she's the kind of the top dog in the training unit, but then there are the actual use of force instructors, right? It's the people who teach these trainings, and at least 2 of whom have been repeatedly interviewed by the state. I don't know if they're intending to call the actual trainers as well, which just puts, like, you know, if Commander Blackwell, she's not teaching, as far as I can tell, these classes. She's not the one administering them, but she's maintaining the record, she's maintaining the training. She's a foundational witness to get these records in. I would have expected the state to introduce the actual training people, but maybe that's not what they intend to do.
Is the state intending on asking Inspector Blackwell for an opinion regarding the use of force in this case?
No, Your Honor. The state is going to be calling Inspector Blackwell to describe the training facility, the curriculum, how it's developed, how it's set up, how it's administered. She will offer the opinion, or I guess it's not an opinion, it's a fact, that MPD does not train its officers to place a knee on a subject's neck and restrain them in that position for as long as happened. She'll do that, but mainly go through the records and describe the curriculum and the facility and the trainers, how it's staffed, and then the individual trainers will impart the knowledge from the various disciplines. We have, you know, Carrie Yang, who we mentioned, on crisis intervention and procedural justice training. We have the use of force trainer, probably Johnny Mersel. I don't know that I need to have both Mersel and Schoonover testify on the defensive tactics side of it. And then the medical training that the officers receive from Officer McKenzie. And those are our trainers. And then we'll go into more of a practitioner level expert, Jody Steger. And then at some later time, the academic expert will testify, but not immediately.
Yeah, my main concern, obviously, the medical training they received. So again, what did Mr. Chauvin know? What it was his training? What was his experience up to that date? All relevant. When we start getting into the opinions, how many use of force opinions do we have? It's cumulative, I think, possibly already. But I think as you go through each of those, it's got to be talking about training that the defendant received. Not just, here's trainings we had. Because if he didn't take the training, it doesn't go to his intent or knowledge.
Understood, Your Honor. The workforce records specify what, you know, right, in-service training the defendant has attended, and then we have the curriculum, the materials that were presented, you know, during those training blocks.
And crisis intervention training seems to be relevant to this case. Use of force training is relevant to this case. Medical training is relevant to this case. So all those summaries of the training that the defendant received, according to his records and what the curriculum is, that's, I think, all admissible. I think when we start getting into opinions about use of force, I think we should visit about that before we start blurting out opinions. We've already had several, and I think we need to go tread carefully because of whether their opinion is something that is the appropriate topic even for expert testimony, because some of this stuff is within the jury's knowledge and they should be able to do without an expert. So, but I think let's just kind of go with that for now.
Your Honor, if I may, just as to the cumulative discussion, just to add to that, foreseeing Mr. Nelson being an able defense attorney, I would anticipate if I were to just simply try to prove my case with experts, he would say, the state hired some experts to say this was unreasonable. but what do the people who actually do the work say?
Well,
right?
and I think we've gotten 2 of those already.
And that's the reason. I'm just, I need to cover the appropriateness of the use of force really from every angle to give the full picture of the reasonable officer. I understand at some point enough is enough.
Well, let me be a little more clear. I think you have the right to somebody who's actually done the defensive tactics, use of force training, whatever, to give their opinion about this case. But not everybody, not every trainer. You can take one who's done the training, knows the curriculum that Mr. Chauvin actually participated in, and give an opinion there. But I think then we're done with the MPD people who can give an opinion regarding defensive tactics and use of force. So, does that make a little more sense?
It does, Your Honor. I think that was my plan.
Okay, good. Always good to have a plan that's consistent with the court's rulings.
And I guess the court will let me know if you feel I'm.
Yeah, let's just go sidebar if we have to in the
Yes.
midst of all this, because as we know, everything's fluid. So, all right, we'll get the jury.
Yes. We are now in another brief break. We expect the trial of Derek Chauvin to resume soon. This is a Washington Post special report. I'm Rhonda Colvin. With me this morning, Eugene Scott, James Homan, and Mary Beth Albright. Mary Beth, it seemed as if there was a lot of explanation about what should be used today, a lot of groundwork that they needed to lay out today. Can you explain what the defense attorney's objection was about?
Yes, and I love the judge's Cahill's comment on the way out. Everything is fluid. I mean, this is what motions trials are all about. There are 2 big things that I took away from all of that discussion about the motions. Number 1, how much use of force testimony is the judge going to allow in? At what point does it get what is known legally as cumulative? That it is too much of the same thing over and over. And these people, as you remember, are not being qualified as experts. Qualifying someone as an expert, you can be an expert, but to be qualified as an expert in a court of law is a totally different thing. We're going to see that later in the week when we bring in people who are physicians to talk about George Floyd's cause of death. But number 2, what I think is really interesting is talking about George Floyd's state of mind. The judge was really clear that George Floyd's state of mind cannot be discussed at this trial. He even went as far as to reference the fact that he suppressed a psychiatrist's testimony talking about what George Floyd's state of mind was at the time. Was it medical duress? Was he in some sort of, medical distress? Or was he resisting arrest? I mean, that's a big legal question to be answered. And so the judge said very specifically, I don't want somebody who's coming in to talk about police training to be shown a video and to be asked, hey, so what does it look like George Floyd was doing at this point? That's not okay. He's not okay with that. And so again, all of the evidence is about what you can allow in that's going to help the jury make a decision, but not going to prejudice them too much for one side or the other.
James, I'd like your take on what we just saw, all of this groundwork being laid about what can be used today. Do you think that Nelson and the defense would have spent so much time trying to figure out what should be said, what shouldn't be said in this proceeding today if they weren't perhaps thinking about last week and how compelling it was?
Well, yeah, today, that what we saw was about more than today. It was really getting at the rest of the prosecution's case. And I think the defense is nervous about just having, 10 different law enforcement people stand up and say, yeah, that was wrong. That was, what we saw from the lieutenant last week, to your point, just hearing that over and over. That's why you kept hearing the term cumulative, as Mary Beth just explained what that means. I think that we got a actually pretty good preview of where the defense is going, and also where you'll see the cross-examination from Nelson with some of these training officers that are going to be on the stand, which is that, this was an 8-hour course. Are you sure he got this particular PowerPoint? That is a good argument that you can't put up a PowerPoint presentation and you have to be able to show that Derek Chauvin himself saw that PowerPoint presentation.
All right, it looks like we're back to the courtroom.
Good morning, Your Honor.
Go ahead.
Counsel, ladies and gentlemen. The state calls Dr. Bradford Langenfeld trial.
stand right behind the chair. Raise your right hand. You swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth. Thank you. Have a seat, please. And before you begin, a couple things. If you feel comfortable taking the mask off, we'd prefer you do that, but
sure.
As a doctor, I can tell you I've had both my shots. That helps. But we'd like you to state your full name, spelling each of your name.
Sure. So Dr. Bradford Wankede Langenfeld, Bradford, Wankhedlangenfeld.
Mr. Blackwell.
And we can just call you Dr. Langenfeld.
That's fine.
Dr. Langenfeld, did you provide emergency care to the body, to George Floyd, after he was taken to Hennepin County on the evening of May 25th?
I did.
Just by way of introduction, are you the physician who officially pronounced him dead that night?
That is correct, yes.
Were you one of the physicians who tried to save his life?
Sustained.
Did you administer care to George Floyd on May 25th, 2020?
Yes.
What were you trying to do?
We were trying to resuscitate Mr. Floyd.
To save his life?
Correct.
So why don't we learn a little bit about your background, Dr. Langenfeld. Where are you currently employed?
Currently I'm working at Grand Itasca Clinic and Hospital. It's up in Grand Rapids, Minnesota. It's my primary practice. And I also work in Waconia, Minnesota at Ridgeview Medical Center.
And Waconia is in Carver County here?
That's correct.
Grand Rapids is several hours driving away from here.
That's correct.
Why Grand Rapids?
I was born there. It's my hometown.
It's also the hometown of Judy Garland, isn't it?
It is, yes.
Are you licensed in emergency medicine?
I have a Minnesota State medical license and I practice emergency medicine.
Would you tell the ladies and gentlemen of the jury what is emergency medicine as a practice for a doctor?
It's a very broad practice, but primarily involves taking care of patients suffering from critical ailments. Oh, sure. Critical ailments such as strokes, heart attacks, car accidents, other emergencies such as that, but also less emergent conditions, sore throats, urinary tract infections, things like that.
When were you first licensed?
May of 2020.
Would you tell the ladies and gentlemen of the jury a little bit about your educational background?
So I attended medical school at the University of Minnesota Twin Cities and then residency training at Hennepin County Medical Center.
And when did you finish your residency then?
Last summer.
Have you ever had any occasion to testify in a court before?
No, I have not.
This is the first time?
That's correct.
Let's go to Monday, May 25th, 2020, last year, Memorial Day. Do you recall whether you were working that evening?
I was, yes.
Where were you?
I was in the emergency department.
At the Hennepin County Medical Center?
That's correct.
And what was your position or title there?
I was one of the senior residents. We're involved with direct patient care, including both critical care and overseeing some of the junior residents.
Do you recall what time your shift began and ended?
It began at about 1 p.m. that day and ended at approximately 11 p.m.
And as a senior resident, what was your role?
My role was primarily direct patient care. I work underneath attending physicians as a resident.
Did you also oversee any other residents?
Yes.
Which residents would you have overseen?
More junior residents earlier in their residency training.
Now, in terms of was care administered to George Floyd on May 25th
By yourself?
Yes.
Yeah. Who was the person primarily responsible then for George Floyd's care in the Hennepin County Medical Center Emergency Department?
I provided the majority of direct patient care under supervision of Dr. Ashley Strobel, who was my attending physician at the time.
Were you the primary decision maker?
I was.
Were you the person responsible for much of the direct patient care?
Yes.
When Mr. Floyd's when Mr. Floyd was brought in, would you describe it as an emergency situation?
Yes, absolutely.
What was his condition in terms of his cardiac condition?
He was in cardiac arrest.
And does cardiac arrest mean that he had had a heart attack, or what does that mean?
Not necessarily.
What does cardiac arrest technically mean?
Cardiac arrest is defined as sudden cessation of blood flow to all the tissues of the body when the heart stops pumping, typically as evidenced by absence of a carotid pulse.
So in lay people's terms, if we were to say cardiac arrest means the heart stopped, would that be accurate?
Yes.
What was your immediate objective when Mr. Floyd comes in and he's in cardiac arrest? What were you immediately trying to do?
Find a way to get the heart to pump on its own again. The primary goal in cases such as this is to achieve ROSC, which means return of spontaneous circulation. And part of that process involves trying to identify the cause of the arrest to see if there's any reversible causes, and continuing CPR and other life-saving measures.
And time is of the essence?
Yes.
How did you first learn that Mr. Floyd was being transported to the emergency department at Hennepin County Medical Center?
I received we call it a Zip-It page. It's basically a EMS notification.
Now first tell us what EMS is.
Emergency Medical Services.
And a Zip-It, is it essentially a text type message, or how would you describe a Zip-It?
It's sort of like a encrypted text.
What time did the Zip-It come in?
I don't recall exactly. Maybe around 8:50 p.m.
What information was provided to you for his care and treatment by Zip-It?
The information was that it was a 30-year-old unidentified male who was in cardiac arrest, and that's as much as I can recall at this time, yeah.
Do you recall whether any information was given to you as to what may have happened to him ahead of time, before he got there, to explain the cardiac arrest?
Not at the time, not before he got there.
Did you know at the time he arrived that the patient was in fact George Floyd?
I did not.
So you learned that at some point later, that it was George Floyd?
Yes.
Did you also know at the time that there was a video or any videos that depicted what had happened to Mr. Floyd before he was transported to the Hennepin County Medical Center on May 25th?
No.
Grounds? Overruled.
You can answer. Were you aware of the existence of any videos as to what may have happened before he arrived at Hennepin County Medical Center on May 25th?
No.
Did you subsequently learn about videos?
Yes.
Were you able to evaluate your assessments about George Floyd in light of the videos?
Yes.
We'll talk about those a little bit later. So when you received this Zip-It, what did you do in response to it?
We prepared a bay in our stabilization room, which is essentially a large room with a lot of critical care resources. We sort of prepped a team and got ready to take care of the patient when he arrived.
Do you recall roughly what time Mr. Floyd would have arrived in the emergency room?
approximately 8:55 p.m.
And when he arrived, then had CPR been started?
Yes.
Any mechanical devices or other things being used to help to stabilize it?
Yes, there was a Lucas CPR device, which is basically a mechanical device that sits across the body with something that almost looks like a plunger and pushes against the chest to provide CPR or chest compressions.
So this Lucas device then was on Mr. Floyd when he arrived in at the hospital.
Correct.
Did you ever observe at any point in time that his heart was beating on its own?
Not to a degree sufficient to sustain life.
Do you recall who brought Mr. Floyd into the emergency department?
I do recall 2 paramedics and possibly 1 or 2 other people, but I don't remember exactly.
Do you recall whether there were any police officers there also?
I don't personally recall that, no.
Did the paramedics who arrived at the emergency department give you a report?
They did.
Do you recall what they said for purposes of treating Mr. Floyd?
I do. The report they gave us is that they were called to a scene of someone who was suffering from medical emergency. As I recall, and this is what I was told at the time, they were initially called for a lower type of acuity event of facial trauma, and then that was upgraded to an individual in distress. They reported that on their arrival, the individual did not have a pulse and CPR was started. They placed an eye gel, which is a supraglottic airway device. It's basically
a super what?
Supraglottic airway device. It's just a sort of a tube that goes down into the throat and can ventilate the lungs. And then they gave medications, including epinephrine and sodium bicarbonate, to try to resuscitate Mr. Floyd as CPR was ongoing.
Did they tell you that Mr. Floyd was in police custody?
They did mention that he was being detained at the time.
Now, did you recognize either one of the paramedics who came in?
I did. I did recognize both of them, and I worked with one of them several times before.
Derek Smith, did you know a Derek Smith?
I believe so, yes.
And do you recall having worked with a Derek Smith before?
I do.
How often?
Several times throughout the course of my training.
When the paramedics bring a patient in to the emergency department, is it standard protocol for them to tell you why they are bringing the patient in? What's the emergency?
Yes.
In what the paramedics told you when they brought in Mr. Floyd, did they also then give you information when they brought Mr. Floyd in?
They did. They essentially gave the report that I just told you. Yes.
Did they say to you, for purposes of caring or giving treatment to Mr. Floyd, that they felt he had suffered a drug overdose?
Not in the information they gave, no.
Did they tell you in the information they gave that they felt that Mr. Floyd had had a heart attack?
No.
Did you receive any information or indication from the paramedics when they brought Mr. Floyd in that anyone had attempted CPR on Mr. Floyd at the scene on May 25th, 2020?
Overruled.
I did not receive a report that Mr. Floyd had received bystander CPR, no.
Did you receive a report that he had received CPR from any of the officers who may have been on the scene on May 25th, 2020?
No.
Is the administration of CPR right away important for you to know when you're dealing with a patient who has suffered cardiac arrest? Is it important for you to know about that?
It is, in the sense that it informs the likelihood of survival.
And what do you mean by that, Dr. Langenfeld?
It's well known that any amount of time that a patient spends in cardiac arrest without immediate CPR markedly decreases the chance of a good outcome. Approximately 10 to 15% decrease in survival for every minute that CPR is not administered.
Did the paramedics then tell you anything about the care that they had administered to Mr. Floyd?
Yes.
Can you tell us what they told you?
That they had started CPR and placed that airway device and started bagging the patient, as in providing breaths, and then administering those drugs. Yes.
And so when you talk about bagging the patient, could you describe what that is?
Yeah, it's called a BVM, or a bag valve mask. It's essentially a device that's hooked up to oxygen on flow to simulate giving a breath, or mouth to mouth, as it might be more better understood. But yeah.
Did the paramedics start something that's referred to as the ACLS algorithm?
Yes.
Would you tell the ladies and gentlemen of the jury, what is the ACLS algorithm?
So ACLS stands for Advanced Cardiac Life Support. It's basically a standardized way of taking care of patients in cardiac arrest.
And so these are protocols, or sort of a checklist process you go through when somebody shows up in cardiac arrest?
Correct. It's a little broader than that, but a big part of it is for folks in cardiac arrest, yes.
Is it to help you to determine why the person might be in cardiac arrest so you know how to treat them?
Yes.
Have the paramedics tried to resuscitate Mr. Floyd?
Yes.
Do you recall how long?
The report we received was for approximately 30 minutes.
Now, you had mentioned to us just a moment ago that they had administered epinephrine and sodium bicarbonate. Would you tell the ladies and gentlemen of the jury, what are those administered for?
Epinephrine is colloquially known as adrenaline. It's a drug that has been studied extensively and is part of the standard protocol for ACLS. The evidence on it is somewhat controversial, but it is part of the standard protocol. Sodium bicarbonate is a medication that may provide some buffering of the acidic environment in the blood that occurs during cardiac arrest, and that is perhaps a more controversial medication than epinephrine.
Did the paramedics tell you whether they had checked Mr. Floyd's heart function?
Yes.
Well, let me ask that a different way. I want to talk to you about two different kind of heart functions and see if you can describe what they are to the jury and how or if they relate to Mr. Floyd. The first one we refer to as PEA. Do you know what PEA refers to?
Yes. So PEA refers to pulseless electrical activity. It's basically a situation where someone is in cardiac arrest. They do not have a pulse, as we previously discussed, and they do have some electrical activity on the monitor. And that suggests certain underlying causes that are known to be more common. The most common cause of someone being in PEA arrest, the most common causes are hypovolemia, either from typically bleeding or from hypoxia or low oxygen.
So we'll talk about those in more detail. But was Mr. Floyd in PEA status, pulseless electrical activity, when you saw him on May 25th?
He was, yes.
And there is another term I'd like to talk about and have you explain to the jury, asystole, I think it's called. Am I pronouncing that right, by the way?
Asystole, yeah.
Yes. Would you spell that for ladies and gentlemen of the jury?
Asystole.
And what is that, Dr. Langenfeld?
It's probably best known as flatlining, where there's no cardiac activity on the cardiac monitor and the patient is in cardiac arrest.
And so was Mr. Floyd in asystole status also when his body was brought into Hennepin County Emergency Department on May 25th?
At some point, yes, there was report that at some point he was felt to be in asystole prior to arrival.
And was he, asystole meaning flatline, was there any point in time during your treatment of care on May 25th that Mr. Floyd was anything other than flatlined during your care and treatment of him?
There were times, for the majority of his time in our emergency department, he was in PEA arrest. Ultimately, that did devolve into asystole.
Is pulseless electrical activity, PEA arrest, asystole, are those conditions of the heart where you can simply apply a shock and potentially bring the patient back?
No.
What are what we refer to as shockable rhythms? Is there such a thing as a shockable rhythm?
So typically these are thought of as either ventricular tachycardia or ventricular fibrillation, which are basically abnormal rhythms of the heart that are more commonly associated with cardiac arrest, specifically from a heart attack. And they are rhythms that you can administer electricity to and shock a patient back into a normal rhythm.
But Mr. Floyd didn't have ventricular fibrillation or ventricular tachycardia.
Correct.
Because his heart wasn't pumping.
Yes, because he did, yes. In both situations, it's a little more complicated than that, but yes, he was not in VFib or VT as we commonly call them.
Do you recall, were there still handcuffs on Mr. Floyd when he was brought into the emergency department?
I don't specifically recall if they were on when he immediately arrived, but it would be unlikely because he had the Lucas CPR device on, and I recall his hands being at his sides.
Do you recall with his hands at his sides whether there were indentations or marks on his wrist?
At the end of the case, yes, after he was declared dead.
What did you observe in that regard?
I'm sorry, can you?
In terms of any indentations on his wrist or markings on his wrist?
I inferred that it was from handcuffs.
So let's talk about then the care you then provided once the paramedics have brought Mr. Floyd to the emergency department. What did you do?
So immediately on arrival, we took report from the paramedics. Mr. Floyd, as we knew him at the time only as an unidentified individual, was transferred over to the bed in the emergency department. As I recall, multiple things typically will happen simultaneously in these cases, but we achieved additional access. I placed intraosseous line in his bone in his leg.
Would you tell the ladies and gentlemen of the jury what interosseous
It's
means?
basically a type of IV that goes in through the bone and injects fluid or medications directly into the bone marrow, essentially. It's a type of access that's easier to achieve in someone who's in cardiac arrest.
And did you also go through the advanced cardiac life support protocols?
Yes, so simultaneous to that and obtaining blood draw and continuing chest compressions, etc. It went through various different things that could be causing this. Commonly in the ACLS protocol, these are thought of as the H's and T's, specifically with regard to the PEAA systole algorithm.
Well, let's, if we could, take a look at the H's and the T's.
Sure.
So, Brett, if you could pull up, I think, 900. I'm showing you what's marked as Exhibit 900 for illustrative purposes.
Sidebar.
Yes. All right, you are watching a Washington Post special report. We now are in a sidebar right now while they question Dr. Langenfeld. He was the doctor who pronounced George Floyd dead. He's also giving some medical analysis of the moments after he saw Mr. Floyd. This, of course, is a sidebar done over headsets. This is a COVID precaution. All right, we'll listen back in. Oh, all right, it looks like they aren't quite done with that sidebar. I was explaining that the headsets are due to COVID precautions. The courtroom earlier, a few months ago, made some determinations as to how they were going to handle this entire trial during the pandemic. So this is one of the protocols that they developed, is that they would play white noise and put on headsets and confer with each other using that as a sidebar. James, I believe you are still with me. What are your takeaways so far from the doctor's testimony?
You know, this is about preempting the defense argument that it was a drug overdose, that George Floyd would have died because of the amount of opioid and fentanyl in his system, which is to, you know, basically lay out everything that was happening with cardiac arrest, with what we heard just then with seeing the imprints from the handcuffs on his mind. The prosecution wants to remind the jury as much as possible that George Floyd was handcuffed during those 9.5 minutes he was on the ground. And basically, if you're listening to this series of questions from the prosecutor, they're trying to establish that George Floyd didn't really have a chance. By the time that he got there, he was already essentially dead. And I thought one of the most interesting sort of sound bites from the first part of this young doctor's testimony was that there's a 10 to 15% decline in the chance of survival for every minute that CPR is not given. And basically this gets to the idea, you know, what would a reasonable officer do? And clearly what the prosecution is trying to show is a reasonable officer, when the suspect stopped responding, would stop restraining him and start trying to resuscitate him, and that did not happen in this case. So some of this is kind of moving into the chain of evidence, basically, for what happened to Floyd's body. But you know, a pretty straight shooter. This is an emergency medical doctor who said there at the top that he's never testified in court before. You know, he's someone who you know, is clearly a young doctor, clearly knows medicine, but seems uncomfortable, but is giving quick, I think, helpful answers for the prosecution, which is why we've seen so many objections from the defense attorney, Eric Nelson.
Right, and that's a good point too, that all of these witnesses weren't people who woke up that day thinking that they would be a part of such a widely watched trial proceeding a year later. I also noticed that line too about if you don't administer CPR earlier enough, it does decrease the chances that a person will survive. James, this is also getting into the crux of the argument by the defense of how George Floyd died. They're building their defense on George Floyd was in poor health with pre-existing conditions and drug use, and that is why he died, not the knee on the neck. But hearing from yet another person who attended on the scene or after, in the aftermath, we're hearing more details that seems to undermine that defense strategy.
Yeah, so we're going to still hear from toxicologists. We're going to hear from the medical examiner, who actually did the autopsy on Floyd and wrote the cause of death. This is the guy who was at the ER working the night shift, drew the short straw to work on the night of Memorial Day. He didn't, as he just said, know who George Floyd was. He just knew that there was a man who was brought in. They didn't know his name. And one of the things that the prosecutor asked that was also striking was he in a place where he could, that was shockable. Normally if you're having someone, you could kind of like, the prosecutor asked the various shockable things you can do to sort of resuscitate someone, and went through the different medications that would be given to someone. One of the medications that they gave George Floyd was basically a stimulant to try to get him to come
sorry,
to.
James. We'll get back to that point. Let's go back to the courtroom.
Dr. Langenfeld, going back to Exhibit 900, on the H's and the T's, which were part of the protocols for advanced cardiac life support. Could you briefly explain to the jurors what the H's and T's are?
So these are common reversible causes of cardiac arrest in individuals, typically in PEA or asystole cardiac arrest. A lot of these etiologies are perhaps best evaluated through an ultrasound-based approach, but I can go through all of these. So hypovolemia, typically hemorrhage or bleeding, so we would think of that more in a traumatic cardiac arrest. Hypoxia, low oxygen, again, those being the two most common causes of PEA asystole arrest. Hydrogen ions, acidosis can be from any number of causes, but essentially where the pH in the blood gets so low that the heart cannot function. Hyperkalemia is low or high potassium, it being a very important electrolyte for proper cardiac function, and disturbances on the extreme can lead to cardiac arrest. Hypothermia, very cold. Toxins, there's a lot of different toxins that can cause cardiac arrest.
And that's from poisons to potentially drugs.
Correct. Tamponade specifically refers to fluid around the heart that can prevent the heart from filling and then lead to the heart stopping. Tension pneumothorax is air around the lung, between the lung and the chest wall, that essentially expands to the point where it prevents blood flow from returning to the heart, and therefore leading to cardiac arrest. Cardiac thrombosis specifically can refer to a heart attack or a ruptured plaque in one of the coronary arteries of the heart. And then pulmonary thrombosis or pulmonary embolism is a blood clot in the pulmonary arteries that prevents blood from flowing from one side to the other of the heart, and therefore leading to the heart no longer functioning.
You mentioned ultrasound. What is the role of ultrasound in studying or trying to assess the cause of cardiac arrest?
Ultrasound can be used to evaluate many of these different causes. I think people would be most familiar with ultrasound from movies where they look at the baby using an ultrasound device or a small probe on the abdomen, but it's the same technology. So we can look at the heart directly and see if there's fluid around the heart, for example. We can evaluate for a large right ventricle that might be suggestive of a pulmonary thrombosis due to increased strain on that side of the heart. We can look for evidence of hemorrhage, hypovolemia, by looking in the abdomen to see if there's any bleeding or bleeding elsewhere. We can look for evidence of tension pneumothorax. For example, we can evaluate for what's called sliding signs on both sides of the chest that would suggest that the lungs are up and are there's no air between the lung and the chest wall, so we can
That
use
the
it
lungs-
to.
That the lungs are properly inflated then.
Exactly, yep. So we can use it to evaluate for a large number of these etiologies.
So you went through the protocols of the H's and the T's. Did you have any kind of leading theories for treatment purposes as to what the most likely causes were for Mr. Floyd's cardiac arrest?
I felt that I was able to determine that some etiologies or causes were less likely based on the information that I had both from the paramedics and also the information I was able to obtain from my exam and ultrasound, etc. At the time, based on all the information I had, I thought it was less likely that the patient had suffered from, for example, cardiac tamponade. There was no fluid around the heart, tension pneumothorax. We can discuss that briefly. At one point in the case, I was concerned that he may have developed a tension pneumothorax, but I felt it was unlikely. We did, in fact, perform bilateral finger thoracostomies where we entered the chest.
Let's ask another question.
I'll ask another question. You were explaining to the jury that you thought it was not likely a cardiac tamponade. Then you're explaining why you thought that tension pneumothorax was not likely.
Correct.
And could you, in plain English, help the jurors to understand how you might have eliminated that?
We essentially used a scalpel to cut into the chest and create a hole between the chest and the potential space around the lungs. We did not appreciate any large gush of air that might suggest that there was air in that potential space.
Was there anything that you looked at to determine whether or not the cardiac arrest was likely or unlikely to be related to Mr. Floyd having had a heart attack?
A lot of that is based on the history that we received from paramedics. There was no report that, for example, the patient complained of chest pain or was clutching his chest at any point or having any other symptoms to suggest a heart attack. That information was absent. Also, the fact that he was in PEAA systole, as I was told on the initial rhythm check, further decreases the likelihood of that possibility. At the time, it was not completely possible to rule that out, but I felt that it was less likely based on the information that was available to us.
Did the ultrasound play any role in the question of whether or not he did or did not, or was likely not to have had a heart attack?
No, not especially in this case, no. Did not.
Did you consider the possibility of toxins, for example, being responsible for Mr. Floyd's cardiac arrest, including potentially drugs?
In the sense that it might have informed our care, yes. I didn't, there was again no report that this patient had, for example, overdosed on a specific medication such as calcium channel blocker or any other medication for which there might be a very specific antidote. And so in that sense, I didn't feel that there was a specific toxin that we could give a medication for that would readily reverse his arrest.
And what about then hypoxia?
So hypoxia being, again, one of the most common causes of PEAA asystole just in general. I did then, as I'd mentioned, use the ultrasound to look in the abdomen and did not see any evidence of hemorrhage. There was no obvious significant external trauma that would have suggested that he suffered anything that could produce bleeding sufficient to lead to a cardiac arrest. And so, based on the history that was available to me, I felt that hypoxia was one of the more likely possibilities.
And hypoxia as an explanation for his cardiac arrest, meaning oxygen insufficiency.
Correct.
Did you have any other leading theories as to why Mr. Floyd's heart may have stopped other than oxygen deficiency?
Yes. I also considered an acidosis. In particular, excited delirium, which is a controversial diagnosis, but it was in the differential in this case.
And were you able to make any assessments about so-called excited delirium based on your examination of Mr. Floyd?
Again, the patient had been in cardiac arrest for 30 minutes. It can be difficult based on the examination. Certainly there was no report that the patient was ever very sweaty, which is often the case when thinking about excited delirium. There was no report that the patient had ever been, that Mr. Floyd had ever been extremely agitated. In my experience, seeing a lot of cases of mental health crises or drug use leading to severe agitated states, that is almost always reported by paramedics. And so the absence of that information was telling, and that I didn't have any reason to believe that that was the case here.
So when how long was Mr. Floyd in your care in the emergency department?
Approximately 30 minutes.
And at the end of the 30 minutes, did you pronounce him formally dead?
Yes.
At the time you pronounced him dead, was he still in some degree in PEA or asystole in terms of describing his heart?
I think it's probably best to think of these as sort of a spectrum where PEA is some degree of electrical activity still running through the heart, but the heart's not pumping. And then eventually that will devolve into asystole, where both the heart is not pumping and then the electrical activity stops as well. And so at the end of the case, Mr. Floyd was still in PEA, but there was virtually no cardiac activity. And at that point, in the absence of any apparent reversible cause, and because Mr. Floyd had been in arrest for, by this time, 60 minutes, I determined that the likelihood of any meaningful outcome was far below 1%, and that we would not be able to resuscitate Mr. Floyd, and so I then pronounced him dead.
And doctor, was your leading theory then for the cause of Mr. Floyd's cardiac arrest oxygen deficiency?
That was one of the more likely possibilities. I felt that at the time, based on the information I had, it was more likely than the other possibilities.
And doctor, is there another name for death by oxygen deficiency?
Asphyxia is a commonly understood term.
Thank you, Dr. Langenfeld. No further questions.
Mr. Nelson. Yep. It's 9 o'clock, so we're going to take our 20-minute mid-morning break. Thank you.
Yes. All right, you are watching a Washington Post special report. Judge Cahill has called a morning break for the jury and the trial. I'm Rhonda Colvin. My guest.
Well, damn, the judge had some good timing. Okay, so a couple things I noticed out of that. Notice how he kept saying at that time. Well, what about now? Why don't you speak about what you saw after the fact, not at that time? Because you've had plenty of time. And he kept saying that, but he kept saying that he was in cardiac arrest for an hour. So if he was in cardiac arrest, he was going to die anyway. That had nothing to do with the knee on his neck. So correct me if I'm wrong. But with the asphyxia as I say it, he was already in cardiac arrest. And this doctor, or whoever he is, kept saying at that time, he went with what he had at that time. But things changed after that time. So what do you have now? That's why I think the defense is going to destroy him. It's just my guess. I could be wrong, but I do. I think defense is going to absolutely destroy him. I don't know. What do you guys think? I got my cigarettes. Hold on. Looks like from the beginning to the end, it would add up to an hour. But that's what I'm saying, Johnny. Add it up. He was only on his... That's true too, Samara. But that's not going to put him in jail. But the point is, from his own testimony, he didn't kill him. He didn't have the heart attack because of Chauvin. He was having a heart attack prior. I agree, he won't stand up. No. Paramedics didn't give the doctor any info as to what transpired before. He was... That's what I'm saying. The doctor keeps saying, at that time, this is the only information I had. But that's what I'm saying. I want to hear now. I want to hear, okay, so at that time, but what about after the fact? Did you do an autopsy after the fact? Because like I said, if he would... Chauvin had his knee on him for 9 minutes. But he was in cardiac arrest for an hour. I totally agree, Johnny. He couldn't breathe. It was probably a very horrible death. Because he was, couldn't breathe. He was having a heart attack before the knee went on his neck. And if that's the case, Chauvin didn't kill him. Chauvin may have made a bad call by not administering stuff. See, that's what I'm hoping for, Julie, because according to that guy, Chauvin didn't kill him. Let's hear what the experts say. Let's weigh in with the experts.
Police use of force that this type of delirium has been recently used as a way to explain that someone was put in handcuffs and they were so hysterical that that's what led to their demise. However, this doctor, Dr. Langenfeld, said that that was not a part of his diagnosis in terms of how George...
And although I agree with you, Julie, it could have contributed to it, Chauvin wouldn't have known that. And if that's how he was trained as a police officer, the real line is, if he wasn't having a heart attack, this would be my defense. If he wasn't having a heart attack, would he still be dead? And if the answer is no, then Chauvin did not kill him. All right, how long was it? I don't know how long it was in the back of the ambulance. But in Minnesota, the state only had to prove the knee was substantial. Yeah, but if he was already having a heart attack, the knee wasn't a substantial factor. The doctor stated 60 minutes, equally the time the paramedics treated him to when he made the call of deceased. No, that can't be right because he was dead. He was DOA. He was dead on arrival. So that doesn't add up either. He had no pulse. He was dead on arrival. And he wasn't in... Yeah, they said he was dead on arrival. They were just trying to revive him. But they said, now correct me if I'm wrong, but I thought they said that he was having a heart attack for 60 minutes prior to getting to the hospital. But Irish Eyes, according to the defense, that's how he was trained. Okay, like I said, I wasn't listening to some of that testimony, but then I grabbed my headset and I decided to listen to it, so I heard like the second half. All right, let's hear what Opie over here has to weigh in. Welcome to my expert.
Of electricity in his body, but not oxygen. Anyway, after half an hour, more than an hour after the paramedics had initially taken Floyd into their custody, he calls him dead, which is not a call any doctor makes lightly. Then the body goes to the medical examiner. So it makes sense that we're following that chain, and the medical examiner is going to be more helpful for the defense, frankly. We're going to hear the cross-examination from Eric Nelson in a few minutes, and I assume he'll kind of highlight what Dr. Langenfeld doesn't know. And, Dr. Langenfeld only knows what he was presented with by the EMTs and what he saw. He didn't do the autopsy. Ultimately, the medical examiner is going to say some uncomfortable things for the prosecution about just how much fentanyl and other drugs George Floyd had in his system. And then we'll hear from experts about whether that was a toxic amount or what have you. But the drug side of things isn't part of what Dr. Langenfeld saw. So you want to introduce him first. This is how the jury's starting the week, and then you can ease in to some of the dicier, grayer toxicology back and forth.
Yeah, one of the things that struck me about...
Let me just tell you, from 12:41 to, from 10:41 to 10:43, that's a whole 2 minutes. Opie blinked once. How do you blink once in 2 minutes? That is a long time. Hey, Stop Animal, that's a long ass time to not blink. Opie doesn't blink. If you really watch him, he doesn't blink. I think he's on meth. 2 minutes. Try going 2 minutes without blinking. And talking, no less. I bet you can't. They blink. Opie doesn't blink. Eugene Scott. Well, he doesn't look like a Eugene. We're going to call him Fred. All right, let's hear what Fred has to weigh in.
And the need for care, then the officers appear to be based on the video that we have seen. And so the fact that there didn't appear to be any effort to administer CPR from law enforcement despite placing a knee on his neck for more than 9 minutes is of great concern and something that I imagine prosecutors are going to...
This is Fred, and Opie's the white dude. I call him Opie. I don't know why, I just do. These are my news reporters.
genuinely concerned about the well-being of the individual that was in their care,
Big time.
would have done or ignored. And it appears that is exactly what happened, despite how much pain.
We like Fred. Look at that tie. Gotta love Fred and his purple tie. There's Opie. Opie's in the green tie.
About force, but also about how they're attending medically to people that are under their care.
Clock it. He's not going to blink. Watch.
I think that is part of why we're hearing from the doctor before we hear from the training officers. And, remember from an hour ago when the judge was listening to the motions about what the training officers are going to be able to talk about. Not just
see,
the
Opie doesn't
training,
blink.
but the person who teaches critical response training and the person who teaches, basically use of force training. All of those are going to talk about duty to care. When you use force, what are you supposed to do right after you use force? The critical response training, which Derek Chauvin received, we're going to hear from the person who teaches that, and they're going to testify that you have to be very mindful and attentive to whether someone is resisting arrest because of basically what their motive is. Are they unable to not resist arrest because they're in such an agitated state? So hearing from Dr. Langenfeld, I think, is sort of a good foundational witness to then hear from the police training officials who will talk about what officers are taught to do. And certainly officers are taught what we heard from Lieutenant Zimmerman on Friday, which is someone's in your custody, they're in your care, you are responsible for them once you take them into custody. Once they're in handcuffs, you do inherit some duty to care. And, I think it's one of those things where when you watch the 9.5-minute video, at a certain point, it just becomes harder and harder for the defense to justify Chauvin's behavior. At the beginning, they're trying to get control of this guy who's not getting in the squad car, but then his knee continues to be on that neck. And that's why it's significant to hear from the doctor who says he died because he couldn't breathe anymore. He died of asphyxia. And, it's all about establishing that no reasonable officer, as the prosecution would argue, would have kept his knee on Floyd's neck past, the 2-minute mark, essentially, in that video.
Yeah, and James, you made an interesting point there that this is certainly not the only testimony that we have had or will have today. We are awaiting Katie Blackwell, who has overseen some officer training there in Minneapolis. There's also going to be another officer who's able to talk about crisis training. And then, of course, we are awaiting the Chief of Police, Madera Arredondo, who will also be a very key witness. He's someone that a lot of people, observers there in Minneapolis, as well as the world, have been waiting to hear from because he is expected not to mince words, as one of the lead prosecutors has said, that he's going to be very clear that Chauvin used excessive force.
Didn't the judge say he didn't want all these cops? I mean, didn't they just talk about this morning? I thought the judge was pretty clear.
Virtually no cardiac activity, and at that point, in the absence of any apparent reversible cause, and because Mr. Floyd had been in arrest for, by this time, 60 minutes. I determined that the likelihood of any meaningful outcome was far below 1%, and that we would not be able to resuscitate Mr. Floyd, and so I then pronounced him dead.
And doctor, was your leading theory then for the cause of Mr. Floyd's cardiac arrest oxygen deficiency?
That was one of the more likely possibilities. I felt that at the time, based on the information I had, it was more likely than the other possibilities.
And doctor, is there another name for death by oxygen deficiency?
Asphyxia is a commonly understood term.
All right, there's the doctor that we just heard from, and that last comment right before they went on break, explaining that he had simply a lack of oxygen, Mr. Floyd. Eugene, one of the things that's standing out to me is that he, of course, this doctor is giving a lot of medical analysis, a lot of medical terms, but he's also sort of supporting what we heard last week. We heard from an off-duty firefighter who said that she was calling out, asking them if she could help because she felt like Mr. Floyd needed his pulse taken. You had other people on the scene also calling out, asking for that as well. Let's remind people about what we experienced last week. We saw all of these eyewitnesses. Anyone stand out to you, or anyone's words come back to you right now as we see this trial move forward?
Well, another witness that we heard from last week that reinforced what you just noted and what we just heard, that the interaction between Derek Chauvin and George Floyd was concerning, and so concerning, was the dispatcher, the police dispatcher who called 911 on Derek Chauvin because she was concerned about how much in duress he was, given how long he had been under the knee of Chauvin, wanting to figure out if there was a way to get someone to help him or to interfere, or if someone should be caring for him or treating him in a way that was different from how he was being handled, because just from an from observation, should I say, it appeared that he was having a very difficult time, and that his life was in jeopardy of ending, given the situation he was in. There also didn't appear to be any factors that were very obvious to the dispatcher that required that type of treatment or that type of interaction with Derek Chauvin, and I think that is what was alarming to her as well as the firefighter, and it appears from this testimony that what they were observing as something to be concerned about was valid.
And James, to you, we're hearing from professionals, of course, police officers as well as somebody from the medical community give a lot of technical detail, but are there any witnesses, eyewitnesses and lay people from last week that you heard from, where you're thinking about the words that they set up last week and how we're sort of hearing the support of that now?
Yeah, Don Williams, the mixed martial arts fighter, the one who was the loudest during that video, the one he called the police bums 14 times. He said he made eye contact with Chauvin when he said that he had George Floyd in a blood choke. And the words I will never forget from his testimony were that he had just been fishing that day with his son. It was Memorial Day. They'd been fishing. They'd just brought the fish home and filleted them. And he went to get some fresh air, get a drink at Cup Foods. And he said that when he looked at George Floyd, he saw George Floyd's eyes bulging out and rolling up back into his head, just like the fish in the bag that he had caught that afternoon. And that was vivid imagery that surely the jury will remember, and that very much anecdotally then tracks with what we just heard from Dr. Langenfeld.
So this trial marks the first time in Minnesota history that a judge has authorized cameras to show a full criminal trial. Hennepin County District Court Judge Peter Cahill said he agreed to allow the cameras because of intense public interest in the case and coronavirus restrictions that have limited courtroom access. Not only is the situation abnormal, it is in fact quite unique, Cahill said at the time. How are the cameras in the courtroom adding to the pressure and the attention on this moment, Eugene?
Well, I think when you look at them as we're observing, one of the things that I think really adds to the tension is when there's breaks and the judges and the lawyers congregate amongst themselves to discuss some factor. Now, the reality is, even if there wasn't corona, it's not like we would be able to hear what was happening in those moments and have insight into what's being discussed. But there's some real concern and real fear, I think, from quite a few people who were protesting or expressing their outrage that something could happen in this case that would benefit Chauvin and therefore justice not be served towards George Floyd. There's real tension and real expectation, real hope that this case would be different, would lead to a different outcome considering how much attention it got. And I think you have eyes glued on this court case, this trial, should I say, from people watching, trying to see what could happen. Is there anything to be hopeful for, or will this be very similar to so many of the past incidents we've observed?
Yeah, and James, that question to you as well. I mean, this is being globally watched, and if we remember to last summer, the case of George Floyd's killing just reverberated across the world. So something at the magnitude of what we are witnessing, Cahill says that is why these courtroom cameras have been allowed. How do you think that they've been affecting the proceedings so far?
Clearly, everyone is aware that they're on camera, and the judge has noted to the jury that they will never be videotaped. I think that there actually has not been grandstanding that you sometimes might expect when the camera comes on. It's not a normal size room. It's not a traditional courtroom as you think of it. You kind of look, there's not that many people in the room. There's a very small press pool that's rotating in and out. So I think that the COVID precautions shape the awkwardness of, it almost, this sounds weird, but it feels like a mock trial, where like, the law student competition where they're doing a mock trial, just because it's not the traditional courtroom with the jury and the jury box and, and everything like that. So I think that sort of changes the dynamic. Certainly, I think one of the key reason that Judge Cahill allowed these cameras to take in almost everything is because he wants people to realize that they're getting a fair trial.
We're getting back into the trial. Thank you.
We do.
Hey, Mr. Blackwell, I forgot to plug in my headset, so it's a Monday. And just a reminder, Doctor, you are still under oath. Mr. Nelson.
Good morning, Doctor.
Good morning.
Thank you for being here today. I have a few follow-up questions for you, kind of picking up right where we left off. You were discussing hypoxia kind of being consistent with asphyxiation, right?
Correct.
Hypoxia is the lack of oxygen to the brain, correct?
Correct.
Right. And there are many things that cause hypoxia that would still be considered asphyxiation, agreed?
Correct.
Drug use, certain drugs can cause hypoxia, agreed?
Yes.
Specifically fentanyl?
That's correct.
How about methamphetamine?
It can.
Combination of the two?
Yes.
All right. Now, you testified about certain things that happened during your care of Mr. Floyd. You were running all sorts of different tests. You used the
ultrasound.
Ultrasound.
Yep.
Thank you. Used the ultrasound. You took some blood samples as well.
Correct.
And you took some blood gas samples as well. Correct.
Correct. From the blood samples. Yes.
Right. So can you explain what the blood gas samples are?
So the blood gas samples are analyzing different parts of the blood, specifically looking at the pH or how acidic or basic the blood is, looking at the amount of oxygen in the blood, the amount of carbon dioxide, the amount of bicarbonate.
Okay. And carbon dioxide levels in this case were pretty high, weren't they?
Correct.
Do you recall what the carbon dioxide level was in the blood gas sample you initially took?
I believe the initial blood gas sample I took was a venous blood gas sample, which is less preferable as opposed to an arterial blood gas sample. At the time, I believed it was a venous sample, and I believe the CO2 level in that sample was around 100.
Okay. A little over 100, perhaps?
Yeah.
And that indicates an exceptionally high carbon dioxide level. Agreed?
Yes.
What would the average, for a healthy person, and you did a blood gas sample, what would you expect the CO2 or carbon dioxide level to be?
For a healthy individual without any sort of lung disease, you would expect somewhere between 35 and 45.
Okay. And so Mr. Floyd's carbon dioxide level was more than 2 times what you would normally expect.
Correct.
Now, the reason that you're doing these blood gas samples is in part to help you analyze and figure out courses of care. Agreed?
Yes.
And that's the carbon dioxide number that we're talking about is essentially, that would be indicative of a person who is not eliminating the carbon dioxide, right? For it to go that way?
Correct. For it to be high in the blood, that means that they are therefore not eliminating it through ventilation or breathing.
And that points to a possible respiratory problem, right?
It can, yes.
And that increase in a carbon dioxide from a 35 to 45 to over 100, that takes some period of time in order to climb that high.
Yes, it can happen relatively quickly depending on how severe the ventilation problem is, but
it could take 30, 40, even an hour to climb that high.
It could take that long. It could take much less time, yes.
The use of fentanyl, do you know that to attribute to high carbon dioxide levels?
It can cause high carbon dioxide levels because it depresses the ventilation or the breathing.
So when someone ingests fentanyl, it can cause them to feel very sleepy because of an increased carbon dioxide level. Agreed?
Correct.
And that's one of the reasons ultimately that fentanyl is so dangerous, because it suppresses the respiratory system. Agreed?
The primary reason it is so dangerous, yeah.
Now, you testified that when the paramedics gave their report to you, they did not give you any reference as to potential drug use, correct?
Correct.
They did not tell you that they had administered Narcan or naloxone during their care, correct?
Correct.
And during the course of your care of Mr. Floyd, you did not administer Narcan or naloxone, did you?
No.
And when you talk about those drugs that are immediately able to reverse the effects, that's what that does. Narcan reverses the effects of fentanyl toxicity. Agreed?
Correct.
When someone has a high carbon dioxide level, that causes that person to have a sensation of shortness of breath. Agreed?
Yes.
And that can happen to a person even without stress complicating their body, right? That respiratory, that feeling of an inability to breathe.
Yes.
Are you familiar with the impact of taking certain narcotics interrectally? Rectally?
Yes.
And that ultimately can provide a more powerful or rapid onset of an impact, right?
Yes.
Simply because a person has a history of chronic opiate abuse, does that mean that fentanyl can't kill them?
No.
When someone is hyperventilating, anxious and hyperventilating, they're actually decreasing their CO2 by doing that, correct?
Correct.
some of the considerations that you have to take also would be the potential occlusion of a coronary artery, right?
Yes, in cases of cardiac arrest, yes.
And someone who has greater than a 75% occlusion of the right coronary artery, that poses a particular risk of fatal ventricular cardiac arrhythmia, does it not?
Objection, Your Honor. May we approach?
Yes. So another sidebar right now that was just called while they are questioning, the defense lawyer Eric Nelson is questioning Mr. Langenfeld, who is a doctor there in Minneapolis, and he pronounced George Floyd dead. So as we learned earlier from our colleague Mary Beth Albright, who explained motions, and when motions are determined, what can and cannot be asked, and sidebars are also an extension of that, where they need to further discuss perhaps a question that was asked or a question that one of the lawyers wants to ask. So we're just right now in the beginning phases of the defense attorneys questioning this doctor, Dr. Langenfeld, who is giving information about pronouncing George Floyd dead, and as well as it seems the direction they're going in right now is seeing about this doctor's analysis on drug use, and if anything had been administered or discussed about George Floyd's drug use, and could that have been a part of the equation there. So sometimes these sidebars take a few minutes, sometimes they take a little bit longer, but I'd like to remind everyone who's watching that this is all a part of coronavirus attentiveness, that this courtroom has put this procedure in where they all wear headsets to discuss instead of gathering together. And you also see there that there are partitions set apart between the defendant, Mr. Chauvin, and his lawyer there, Eric Nelson. So it looks like they're getting back up, and we'll listen in.
Questions withdrawn. Ask a new question.
Only a physician can declare a person dead, correct?
Depends where you're practicing.
In the state of Minnesota?
Yes.
A paramedic can't declare a person dead?
No, not without consultation with a physician.
So, based on your treatment, again, of Mr. Floyd, based on these tests that you did, had an elevated CO2 level, correct?
Yes.
And that CO2 level was considered to be exceptionally high, correct?
Correct.
And you did not, in the course of your consideration, provide naloxone or Narcan?
No.
Okay. And it would be, is it fair to say that the administration of Narcan, if you do not have opiates in your system, is a safe procedure?
Yes.
And if you do have opiates in your system, the administration of Narcan could be life-changing, life-saving?
Yes, not in this case.
Prior to the, but again, the paramedics also, based on your information, did not administer Narcan?
Correct. Can I make a clarification?
I'm good.
No.
There's no question.
If they wish.
I'm sorry?
I said the state can clarify and redirect if they wish.
And you would agree that Mr. Floyd arrived at HCMC at approximately 8:53, if we have seen evidence previously?
That sounds correct. Yeah.
I have no further questions, Your Honor.
Okay. Mr. Blackwell.
Thank you, Your Honor. For starters, Dr. Langenfeld, there was an answer you wanted to clarify. Please do so.
Only to state that Narcan, administering Narcan to someone who potentially suffered a fentanyl overdose, once that individual is in cardiac arrest, the administration of Narcan would provide no benefit.
And Mr. Floyd was obviously in cardiac arrest.
Correct.
You were asked questions just now about whether fentanyl works by causing someone to feel very sleepy. Remember that discussion?
Yes.
Did the paramedics tell you that Mr. Floyd was ever asleep or sleepy or anything that sounds like sleep?
The report that I received was that the patient, Mr. Floyd, was unresponsive on their arrival and did not have a pulse. And so there was no report that he had been sleepy or difficult to arouse per se.
You asked quite a number of questions about the carbon dioxide content in the blood gases. First off, if a person is suffering from hypoxia, that is oxygen deficiency, is that an explanation for a heightened carbon dioxide content in the blood?
It can be in severe cases.
In this case, do you find that the carbon dioxide reading for Mr. Floyd is really all that significant?
I felt that it was weak evidence in support of what I was thinking at the time. What's difficult in cases of cardiac arrest is once someone has been in cardiac arrest for an extended period of time, essentially the blood gas that I obtained could be consistent with cardiac arrest from any number of causes. You expect the pH to be low. During cardiac, I'll provide a little bit of explanation on that. During cardiac arrest, there's no blood flow to the tissues, therefore there's no oxygen getting to the tissues. Therefore, the cells will die. They'll release hydrogen ions, which lower the pH, creating an acidic environment. They'll release lactate, which complicates that further. Because the person's heart has stopped from whatever cause, they'll no longer be breathing either. And so you would expect that their CO2 to be high. Again, it can vary a little bit depending on the cause, but in my estimation, the blood gas in this case wasn't very strong evidence for one cause over another as far as the etiology of the arrest.
And it was simply consistent with the fact of cardiac arrest?
Correct.
The fact that the heart had stopped?
Correct. And I felt that the high CO2 may have suggested a respiratory cause.
Now, you were asked questions about somebody administering narcotics interrectally. Remember those questions?
Yes.
Did you get any indication that Mr. Floyd had administered narcotics interrectally?
I had no information to suggest that.
Dr. Langenfeld, thank you.
Anything further? Thank you, Doctor. You may step down. Mr. Slisher.
Thank you, Your Honor. Your Honor, the state calls Chief Madeira Arredondo.
You swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
I do, sir.
Proceed. And before you begin, if you could give us your full name, spelling each of your names.
Yes, Your Honor. Madera Arredondo. First name is spelled Medaria. Last name is Arradondo.
Mr. Slisher.
Thank you, Your Honor. Sir, what is your current role?
My current role is Chief of the Minneapolis Police Department.
How long have you held that position?
For approximately 3 years.
And as Chief of the Minneapolis Police Department, are you responsible for overseeing the operations of the entire Minneapolis Police Department?
Yes, I am.
And that's the highest ranking role at the Minneapolis Police Department, is that correct?
That is correct.
Now, sir, I'd like you to first share a little bit about yourself with us. How old are you?
54 years old.
In what city do you live?
Twin Cities.
Where are you from originally?
Minneapolis.
Where did you go to high school?
The Minneapolis Roosevelt High School.
All right. And have you ever lived outside of the Twin Cities, Minneapolis area?
I went away for college for a couple of years in Michigan, yes.
Where in Michigan did you go?
It was Hancock, Michigan.
Which school?
Which is now called Finlandia University. I'm sorry, Your Honor, Finlandia University.
And what is the highest level of education you've attained?
I received my master's degree.
What degree did you receive in Hancock, Michigan?
That degree was a criminal justice degree.
After you completed your college studies, you returned to the Twin Cities area?
That is correct.
And is that when you first joined the Minneapolis Police Department?
Prior to that, I had worked as a community service officer at the Minneapolis St. Paul Airport Police Department.
What years did you do that?
I believe that was from 1987 to 1989.
And then in 1989, did you join the Minneapolis Police Department?
I did.
In what capacity?
I started my career as a Minneapolis police cadet and then was hired as a Minneapolis police officer that year.
And Chief, why did you decide to become a police officer?
I've been very fortunate to come from a city of very resilient, very welcoming, proud people here in the city of Minneapolis. And my dear parents taught all of my siblings and me about the service of love. And so I've been very fortunate to then eventually join the Minneapolis Police Department and give back to the very community, the very city that embraced me and has been so good to me.
You familiar with the motto of the Minneapolis Police Department?
Yes, I am.
What is it?
And that is to protect with courage and to serve with compassion.
And what does that motto mean?
We are oftentimes the first face of government that our communities will see. And we will oftentimes meet them at their worst moments. And so the badge that I wear and that members of the Minneapolis Police Department wear, it means a lot because the first time that we interact with our community members may be the only time that they have an interaction. And so that has to count for something. And so, so it's very important for us to make sure that we're meeting our community in that space, treating them with dignity, being their guardians, and representing and all of the men and women that came before us who served so proudly on this department.
Sometimes you have to protect with courage and you have to use force. Is that correct?
At times, yes. As a police officer, you will have to use force.
Sometimes serving with compassion means to understand when force is not required.
Stand, rephrase.
What does it mean to then serve with compassion?
To serve with compassion, to me, means to understand and authentically accept that we see our neighbor as ourselves. We value one another. We see our community as necessary for our existence. And so that's what serving with compassion means to me.
Now, you've told us a little bit about your educational background. I'd like you to share with all of us a little bit more about your specific law enforcement training. You mentioned the academy. Is that where you received your law enforcement specific training?
Yes, it is.
Please describe how that training occurred.
I was a member of the first Minneapolis Police Cadet Program, and along with many other candidates, we received training, both academic training on the laws of the state of Minnesota. We received training as it relates to everything from driving and defensive tactics, community relations, and so we also, there's post requirements of Minnesota Post Officer Standards and Training to receive our license. There was a test that we had to take then. There was also scenario-based training as well, to grade and assess how we performed during that training in the academy. And so that was part of that important training that I received along with my candidates at the academy.
And that was the very first Minneapolis Police Academy?
That is correct.
And a trainee at the academy is that trainee referred to as a cadet?
That is correct.
At your employment, you've been continuously employed as a in the Minneapolis Police Department since, was that 1989?
That is correct, sir.
Has the academy changed since you first were a cadet back in 1989?
It has, and while I certainly believe that at the time back in 1989 that training was important, like any police department, we should not be monolithic. Our communities are not monolithic. Our training should evolve. We should be focused on what our national best practices, and so the training that our recruits and cadets get today, and rightfully so, is far better than the training that I received those years ago.
Well, we'll circle back to that a little bit later. You also mentioned that you take post credits, is that right?
Yes, that is correct.
And POST stands for Peace Officer Standards and Training?
That is correct.
What is the requirement for post training? How many courses are you required to take in a given period?
Yeah, every sworn peace officer in the state of Minnesota receives their license through the POST, Peace Officer Standards and Training Board, and so POST will change up what some of those requirements are from time to time, but some of the ones that I think of right now would be crisis intervention training. There's certainly defensive tactics training. There's now a form of procedural justice training that is required, and so Minneapolis police officers receive that mandated training, but we're also very fortunate that we're able to receive additional training above and beyond what is required of the post board.
And you personally participate in this training in order to maintain your post license?
That is correct.
Chief, you began your career in 1989. You're now the chief of the police department. Fair to say you've had many roles within that department. Is that correct?
That is correct.
At this time, I'd like to publish Exhibit 209, if I may. And we'll leave that up, if we may, while you testify. What was the first position you held within the department after you completed your academy training?
I was sworn in as a Minneapolis police officer.
Now, we've heard that term sworn officer before. Can you please explain to the jury what that means?
Sworn officer, after you complete the required educational requirements, and certainly after you complete your performance measures at the academy, then you are eventually sworn in at a location, and traditionally our city clerk has been there, and you take an oath, and you're sworn in as an official member of the Minneapolis Police Department, but also as a City of Minneapolis employee, and you start your employment with the city then.
And what were your duties then as a sworn police officer, that rank for the City of Minneapolis?
Primary duties was to be a 911 responder, to work in a geographical area of the City of Minneapolis, in a district, at a precinct, and respond to 911 calls on a given shift.
Are those also called calls for service?
That is correct.
And as a patrol officer at that time, well, how long did you remain a patrol officer?
Approximately 5 years or so.
And can you tell the jury what geographic district you served as a patrol officer?
Yes, I served for a short time in the 3rd Precinct, and then I think the bulk of that time in the Minneapolis 4th Precinct, which is located in North Minneapolis.
During that time period, that 5 years as a patrol officer, did you ever have occasion to arrest a suspect?
Yes, I did.
How about a non-compliant suspect?
Yes.
You've had to place handcuffs on someone who was not compliant?
That is correct, yes.
Approximately, would you care to guess how many times?
I'm sure several. I'm sure several. Yes.
This is something that's a fairly regular occurrence as a police officer, as a patrol officer. Is that right?
That is correct.
You've had to be in situations where you've had to use force. Is that right?
That is correct.
Have you also been in situations where you've had to de-escalate or talk someone into compliance?
Yes.
And is that a regular part of your job as a patrol officer?
Yes, it is.
Even from 1989 to approximately 1994?
Yes.
Then after serving this period of time as a patrol officer, what was your next position at MPD?
And I believe in 1997, I was then promoted to the rank of sergeant in the Minneapolis Police Department.
And what do you have to do to be promoted to the rank of sergeant? What are the requirements?
It is a civil service test that you take, and you have to successfully pass that and receive a grade from that. And I'm trying to recall if there was an assessment center that was also part of that testing process. But there is a number of years that you have to at least have served as a police officer before you can take the sergeant's test and promotion.
And what is the role of a sergeant in the Minneapolis Police Department?
Sergeant's role, and I've often said it is the most influential role in the police department.
How so?
It's most influential because you have the most proximity to the men and women who are out there serving in the community. You're there for them at the roll calls. You are a mentor. You give them guidance. They are going to see you far often than they would ever see the chief of police, for example. And you set the tone and the attitude. And so that's really a very significant role within the Minneapolis Police Department.
That's a first-line supervisory position, correct?
Yes, it is.
And sergeants or people with that rank within MPD would serve in a variety of jobs or functions. Is that correct?
That is correct.
And how did you serve as a sergeant when you were first promoted?
I served as a investigator with the property crimes unit at that time.
How many people approximately did you supervise?
At that time, I did not supervise any. I worked as a detective or investigator alongside other detectives.
Okay. How long did you hold that position?
Approximately 2 years.
And after that?
Then I served as a sergeant in our Minneapolis Police Department Internal Affairs Unit.
Describe what a sergeant in internal affairs does.
Sergeant in Internal Affairs is responsible for investigating cases of misconduct involving Minneapolis Police Department employees. And fact-finding, preparing reports, and ultimately submitting those to their supervisor.
Can those investigations include inappropriate uses of force or excessive force?
Yes, they can.
And have you ever evaluated an excessive force case in internal affairs context?
I believe I have, yes.
How long did you serve as a sergeant in internal affairs?
I served in that position about 2 years as well.
And then what did you do?
Then I was promoted to the rank of lieutenant.
Now, what was required of you to promote to lieutenant?
That also required taking a civil service exam, and I believe certainly at that time an assessment, going through an assessment center, which comprised of scenarios and different type of performance measures for that position.
Is it true that a lieutenant is it's a higher level of management above the first line sergeants?
Yes, our lieutenants are considered managers within the organization.
And what were your duties then as a lieutenant?
I served for a time as overseeing at that time, the federal mediation agreement that the Minneapolis Police Department had entered into with the Unity Community Mediation Team. And I also served time as a 4th Precinct lieutenant on the night shift.
Okay. And what is lieutenant in the 4th Precinct night shift? What do you do?
You have a team of sergeants and a team of officers on a shift. That particular shift worked the night hours in North Minneapolis, and really there as a lieutenant there to support the mission of the precinct inspector, who is kind of like the chief of that precinct, but also then to support your officers on the shift as well. Yes.
And how long did you hold that position?
That was probably about 2 years as well.
Seeing a pattern here. What happened after that?
After that, I was appointed to the rank of commander.
And what does a commander do?
Commander now, unlike the previous civil service positions, a commander now is appointed specifically by the chief of police, and it is a higher position, and the commander is usually in charge of a division. And so at that time, I was appointed to commander of the internal affairs division.
And so you're now back to internal affairs, but more or less overseeing the entire operation?
That is correct.
And how long did you hold that position?
About 2 years.
Okay. Yeah. And after that?
Then I was appointed as the 1st Precinct inspector. And so that was a position in charge of the downtown precinct or 1st Precinct. And that was a patrol function, so that was mainly patrol-related functions, even though we do have great civilian teams who work on things such as crime prevention and others, but I was appointed to 1st Precinct inspector.
And what does the inspector do at that level?
The inspector at that level is really driving the work of the precinct, monitoring and working on trying to reduce crime in that precinct, working with its stakeholders, its neighborhood associations, its business community, making sure that whether it's investigative or patrol in the precinct, that they have the resources and things that they need, interfacing with the city council members of that particular ward. And so that is really a lot of the work that a precinct inspector does.
And does the precinct inspector then supervise, maybe not at the ground level, but is responsible for the supervision of all of the different positions underneath the inspector?
That is correct.
All right. And how long were you in that position?
About 2 years.
Yes. Okay. And after that?
Then I was appointed to be deputy chief of staff.
And what does a deputy chief do?
Deputy chief at that time was a unique role in that I was really chief of staff for the chief of police. A lot of work helping to support our department initiatives, reaching out to elected officials, community stakeholders, boosting up programs, grants that the department had received, and really carrying out the mission of the chief of police.
And from there?
After about 2 years, I was appointed to assistant chief of the Minneapolis Police Department.
And by whom were you appointed?
Then it was former Chief Janae Harteau.
And what did you do as the assistant chief?
That was really overseeing the day-to-day operations of the Minneapolis Police Department, and again, also supporting the chief.
And for approximately how long?
That may have been a little shorter, about a year or so, I think.
You've broken the pattern.
Yes. Yes.
And now, of course, you're the chief of police. How were you selected, or who selected you to be the chief of police?
Well, I served in an acting or an interim capacity, then under Mayor Betsy Hodges, and then after that term ended, then Mayor Fry of the city of Minneapolis appointed me as chief of police.
You may take that exhibit down. So you've had certainly, it seems, every rank available within the Minneapolis Police Department and a variety of roles. Is that right?
That is correct.
And as such, are you familiar generally with the day-to-day operations, I guess from the patrol level all the way up to the level you are now?
That is correct.
What I'd like you to do at this time is provide us with a little bit more information, sort of an overview of the Minneapolis Police Department and how it serves the city of Minneapolis. MPD's jurisdiction is within the geographic limits of Minneapolis, is that right?
Yes.
And what's the approximate geographic area that you have jurisdiction over?
Well, to the north, we border Brooklyn Park, Brooklyn Center. To the south of Ridgefield, to our east, just right up against the River St. Paul, and to the west, Golden Valley. And so it's a pretty large area.
Would you agree that's about 58 square miles, give or take?
Yes.
And are you aware of the current population of Minneapolis?
Roughly about 30,000.
How many sworn officers work for the Minneapolis Police Department?
Currently, around 700.
And as the chief, are you generally familiar with the officers who work for you? It's a lot of people.
It's a lot of people, and so it can be taxing to try to. We've got a lot of people that work in different areas, but I have a pretty good understanding of where folks are throughout the organization. Yes.
As we go on, I'll be asking you if you recognize some of the names of different people we may have met to this point. But at this time, up until May 26, 2020, an individual named Derek Chauvin was a Minneapolis police officer. Is that right?
That is correct.
And are you aware of who this person is?
I am.
Do you recognize this person in the courtroom today?
I do.
Would you please point to him and describe what he's wearing?
Yes. Mr. Chauvin's right there. He appears to be wearing a navy blue suit with a light blue tie and white shirt.
Thank you, Your Honor. May the record reflect that the witness has identified the defendant. So I'd like you to please describe for the jury how MPD is structured to deploy law enforcement services to about 420,000 people over a 58 square mile area, 24 hours a day, every day. Administratively, how is the department organized?
Administratively, we are broken down into bureaus. And so, as I may have mentioned, you have the chief of police that really leads the organization and its mission and vision and goals. And then we have an assistant chief that oversees the day-to-day operations. After that, there are 3 deputy chiefs. And we have a deputy chief of patrol. The deputy chief of patrol is responsible for the 5 geographical precincts throughout the city of Minneapolis. We also have a deputy chief of professional standards. And that deputy chief oversees really 2 main functions, and that is our training for our entire department, as well as the internal affairs portion of our department. And then we have a deputy chief, the 3rd one, of investigations. So all of the employees who work, whether it's homicide unit, robbery, assault, that deputy chief oversees the investigations bureau. And we also have commanders who oversee these divisions. As I mentioned, they're above the civil service rank. They're appointed, and they serve in different divisions. And the precincts, as I mentioned, there's 5 geographical areas. We have 5 precinct inspectors, and they are like the chiefs of police for those precincts. Yes.
And so by my count, there were 3 bureaus. You have investigations, patrol, and professional standards. Is that right?
That is correct.
And the investigations bureau has a number of individual units within the bureau, correct?
That is correct.
For example, what type of units are within investigations?
Yeah, investigations bureau has homicide, assault, robbery, crimes against children. There are several different investigative units.
So within the investigative bureau, you mentioned homicide. That's where Lieutenant Zimmerman would work. Is that right?
That is correct.
Okay. And the patrol bureau, that provides services such as 911 response, like you did when you were a patrol officer. Is that right?
That's correct.
Crime prevention, traffic control, emergency services, all within the patrol bureau?
Yes.
And in individuals, sorry. And within the patrol bureau, in order to provide those patrol services over the geographic area, we've heard about precincts. Is that right?
Yes.
And if we could publish Exhibit 269. Looking at Exhibits 269, is this the geographic area of your jurisdiction?
Yes, it is.
And then can you just use 269 to describe the precincts and what they are and what purpose they serve?
Yes, this exhibit outlines the 5 geographical precincts, and this also lets our community know which precinct, based on where they happen to live, which precinct their residence or business is a part of. And so you're able to see from this map here, Sector 1 or Precinct 1 kind of is in the center there. It covers downtown Cedar Riverside area. The number 4 at the top left-hand corner would be our North Minneapolis precinct. And then second precinct, number 2, covers southeast, northeast Minneapolis. And then 5th precinct covers southwest Minneapolis near the lakes area. And then the 3rd precinct covers our southeast Minneapolis area.
And focusing specifically on the 3rd precinct, I see it's divided further into these sectors. Is that right?
That is correct.
And that's for the purposes of being able to deploy patrol services, correct?
Yes.
Within the various precincts, this is primarily a tool for dispersing patrol officers, correct?
Yes.
But there are also investigative functions within the precincts as well, correct?
Yes.
That would be specifically assigned to that precinct?
Yes.
Okay. But professional standards, that would cover all of the precincts. Is that right?
Yes.
Okay. If we could publish 268, I'd like to focus specifically on the 3rd precinct. Oh, it's a little hard to see, but you can see the, that's much better. Thank you. You can see the different colors. It appears the sectors that we looked at in the previous exhibit are listed here. And if you take a look at Sector 1, that would be represented as 310 on the Exhibit 268. Is that right?
Yes.
And then Sector 2 would be Exhibit 320?
Yes.
All right. And we won't go through each of the sectors, but the purpose of these sectors, again, is to further distinguish different geographic areas within the 3rd precinct or any precinct, so we'd be able to have, say, dispatchers deploy law enforcement resources there. Is that right?
That is correct.
Dispatchers like Jenna Scurry, for example, could send a car to a particular location based on the different sectors that are within this precinct map. Is that right?
That is correct, yes.
And a Professional Standards Bureau, you can take that down, please. The Professional Standards Bureau, what does a Professional Standards Bureau do?
One of the functions is training. We have a commander, again, that is one of the appointed ranks, who oversees the training division, and they're responsible for making sure that not only are our officers in compliance with our mandated post-board educational requirements every year, but also really looking to make sure that we continue to evolve and that we're staying on top of necessary training that's important for us, that has a benefit to our communities that we serve. And so that's a core piece to what our Professional Standards Training Division does.
And so within Professional Standards, you have the training services, and that's staffed at the, I guess it's at the commander level, led at the commander level.
That is correct.
And who is the current commander of the training division?
The current commander for the Minneapolis Training Division is Commander Darcy Horn.
Last year, who was your commander?
Last year, she's now Inspector Katie Blackwell, but she was Commander Katie Blackwell last year when she led our training.
And she would have been the training commander on May 25, 2020, is that right?
That is correct.
Okay. There's other divisions within Professional Standards. I think you mentioned Internal Affairs, but there's also an Administrative Services division, is that right?
Yes.
And what does the Administrative Services division do?
Administrative Services Division can deal with everything from grants, different types of programs that the City of Minneapolis is embarking upon, employee personnel matters as well.
Also, business software and equipment.
Technology, business software, yes.
Body cameras, milestone cameras.
Yes.
And we met Jeff Rugel, and that's where he works, is that right?
Yes, Lieutenant Rugel is part of that. Yes.
I'd like to talk to you a little bit about the Minneapolis Police Department and reacting to calls for service. The role of the Minneapolis Police Department is generally to serve the community's law enforcement needs, is that right?
That's correct.
And most requests for service come in through the 911 system, is that right?
Yes.
You respond, or officers respond to different calls for service. Could you please describe the types of calls for service Minneapolis Police Department commonly responds to?
Calls for service can absolutely range from everything from tenant trouble to a loud party dispute to domestic assault to shooting and to even homicide. So it can really range from a wide variety of types of calls.
People will call to report a crime and request assistance. Is that
yes.
right? Well, people also call to report, just general emergencies.
Yes, they can.
What type of emergencies?
Medical emergencies. They can request calls for service for that. Oftentimes we have community who are calling because it may be 3 o'clock in the morning and they don't know of any other service or who will respond, but they will call us for those types of situations as well.
And I suppose what constitutes an emergency is in the eye of the caller somewhat?
That's correct, yes.
But nonetheless, MPD responds.
Yes.
Do you know approximately how many calls for service the Minneapolis Police Department receives annually?
It's usually a couple of 100,000, and then we also have officers that we categorized as self-initiated activity. So that could mean an officer happens to be driving through a neighborhood and sees something and reports out on their radio that they're going to look into it. So it's a combination, but it's a lot of calls.
And generally, people don't call the police department to say, hey, everything's going great, just wanted you to know. They have something that they want you to do.
Exactly, yes.
It sounds then like it's fair to say there's more to policing than just going out and arresting people. You provide a broad spectrum of policing services to the community.
Yeah, I would actually say that the actual law enforcement part is probably pretty small compared to most of the types of calls our officers are being called to address and deal with. Yeah.
So we've touched on police training, your own personal police training, and how police training is dispensed, I guess, through the Professional Standards Bureau. I'd like you to describe that a little bit further. Are you generally familiar with the types of training that the Minneapolis Police Department provides its officers?
Yes, I am.
Where does this training take place?
We have a large facility located in North Minneapolis, which we call our Special Operations Center, and that is where the vast majority of our required training takes place.
Is the Special Operations Center then a dedicated building only for training purposes?
It's primarily dedicated for training purposes, yes.
And I think you testified it's supervised by a commander. I'd like you to tell the jury a little bit about when now currently training begins for a Minneapolis police officer who's hired on to the department.
For a new officer who's hired onto the department, that first initial orientation to our training begins at the academy. And that again is overseen by the commander of the training unit. And we actually have a class currently in place now at the academy, at the SOC. And so that first initial indoctrination to our academy occurs during that first part of the training at the academy.
Fair to say that the training that's provided to Minneapolis police officers can be generally divided into two categories: pre-service training and post-service training. Is that right?
Yes.
And the pre-service training would include the academy that you just talked about. Is that right?
That is correct.
And then post-service training is the continuing education that you testified about previously. Is that right?
Yes.
So let's again focus on the academy training. How many cadets do you generally have at a given time per class?
Well, it's usually been a mixture of recruit classes and a cadet class. I would say that we average in terms of recruit class numbers around 30. Cadets might be 20 to 25.
So now I'm going to ask you to just define some terms a little and explain to the jury the difference between a recruit and a cadet.
Recruits are typically individuals who've already been laser focused on a career. Being a Minneapolis police officer is what I wanted to do. They typically have already at least their 2-year criminal justice or law enforcement degree. Most have completed their required skills training. Cadet was really created to capture diversity of candidates. And so the cadet might have individuals who may have had a psychology degree, but it's really streamlining them in. It's a little lengthier process, but it's really getting them on board so that they meet the state requirements, the post requirements to get to be hired. And so the cadet program is a wonderful way for us to capture diversity within our police department. And so, but they both, once their programs are finished, they're both classes, whether you're a recruit or cadet, you are ready to successfully become a Minneapolis police officer.
Do you also take lateral candidates?
Yes, lateral candidates. We certainly have had hirings of laterals in the years past, yes.
And do those individuals also go through a similar training as a recruit?
Yes, the laterals can. It's usually much smaller in length of time just because laterals are individuals who've already served as police officers, perhaps in another jurisdiction or another part of the state, or out of state, actually.
We'll get a more detailed description from another witness, but just at a very high level, can you describe what the trainees do at the academy during this pre-service training?
Trainees at the academy during pre-service, it's their first indoctrination into this world of being a police officer. So they're being taught about city and statutory laws. They're being trained on procedural justice and critical thinking, defensive tactics. They're having community members come in and speak to them about different aspects, whether it relates to things in our cultures within our city. Technology is a huge piece to that. Learning how to write reports on our computers. They're really getting that basic indoctrination into the Minneapolis Police Department.
As far as the methodology, is it typically classroom delivery? Do you also have practical application? How does that work?
Yeah, it's a layered approach. It's both the practical academic studying, examinations that occur, but it's also scenario based. And so there's scenarios that they will go through, and whether that's crisis intervention training or other aspects. So it's a layered approach to the training.
And in this pre-service training, then, once the officer or candidate has completed the pre-service training, what's the next phase before becoming a fully functioning police officer?
Once they complete that training, they're making sure, obviously, that they've met the requirement for the licensure for the Minnesota Post Board, and then ultimately they're going to get sworn in and hired on as Minneapolis police officers.
Are you familiar with a program called the Field Training Program, or FTO?
Yes, I am.
Is that part of the pre-service training?
That would be, yes.
Can you just give us a general description of what the FTO, or Field Training Program, is?
The Minneapolis Field Training Officer Program is really, once the recruit has gone through that series of pre-service training, it's now teaming them up with a mentor, basically. And they're being gauged and judged on certain performance measures. And it takes course over a period of several months, usually about 5 months. And they're given instruction. They're seeing how well they are able to handle certain types of situations, calls. And they're also having feedback, not only from their FTO, but they're also having conversations with the supervisors in the training bureau, and seeing how they're doing. They're assessing their progression. In the event a candidate is not progressing, they're making sure that there's support mechanisms for that. Where do they need extra help? And yes, at times we have candidates that don't successfully complete it, and so. But that's really getting them to the point where they can ultimately be really on their own and be able to function on their own as a sworn Minneapolis police officer.
Okay. And so once they've completed the field training program, and I think, as you know, per your testimony thus far, the training doesn't stop there. You have post requirements that you have to fulfill every year in your post-service training. Is that right?
That is correct.
And is that delivered through a series of in-service trainings that occur at the same training facility you mentioned?
Yes.
Is that training optional? Can an officer go somewhere else to get their post credits and skip the in-service, or is that training required?
That training is required annually.
Do you have to take it?
Yes, I do.
What type of training is provided in the post-service training?
Some of the training that is provided in the annual training can be critical incident training, CIT training.
CIT is crisis intervention training?
Crisis intervention training, thank you. Yes, crisis intervention training, defensive tactics, basic CPR or first aid. Those are some of the types of training that is required annually. Yeah.
Even though they've already ostensibly been trained on all of these things before, you're still doing the same training annually?
That is correct.
Why is that?
A lot of that is just to reemphasize the importance of the training itself, muscle memory, because all of our department members are being taught the same thing. We may have officers that are working in a patrol capacity one year, and the next year they may be in investigations, but they may be called to assist upon. And so it's making sure that all of us have that basic necessary core fundamental training to better help serve our communities.
So if you could give the jury kind of an idea of the amount of time that is spent training your officers.
It's a lot. We put a lot of time, energy, and resources into our training. I believe last year, the Minneapolis Police Department, in terms of our mandatory in-service training and leadership training, we probably spent about $8.5 million. In our pre-service and in-service training, that was probably about $4.5 million. So training is absolutely vitally essential to us as a department.
And officers are paid while they're being trained, is that correct?
Yes, they are.
And would it be fair to say that part of the objective of training is to impart Minneapolis Police Departmental policies onto the officers so that they know what those policies are and are able to apply them?
Yes, it's important through training that we're reemphasizing not only our policies but really our values as a police department and what our community expects of us. It's to help our officers, and it's also to help our communities at the same time.
As a former patrol officer who's used force, put handcuffs on people, I mean, you understand the reality of what policing is like when you're actually on duty. Is that right?
That is correct.
You also testified that you've participated and continue to participate in the training that's been provided by MPD and has continued to be provided. Is that right?
Yes, that is correct.
Is this training practical and useful?
Yes, it is.
Why do you say that?
Our officers are being called, particularly patrol officers, are being called to, again, respond in a way to our community's needs. And it's hundreds of thousands of calls that they respond to. And, we are a very interesting profession in that to some professions, your body of work matters. And to an extent within the Minneapolis Police Department, our body of work matters, but it's more internally. But to our communities, for the most part, your body of work doesn't hold as much value. We don't have the luxury of being able to go up to a community member for the first time and say, those 99 calls I was on before went really well. Trust me on this one. We don't have the luxury of doing that. Our communities are going, no, what have you done for me lately? This interaction, I'm going to grade you on how you treat me during this call, during this interaction. And so we have to make each engagement with our community count. And so the training is very important because for many in our communities, the first time that they encounter a Minneapolis police officer may be the only time in their life they do. And so that singular incident matters.
Aside from the usefulness of it to the community, what about the usefulness of it from a practical standpoint to the patrol officer out on the street? Is this training practical, or is it more aspirational?
No, it's very practical, and as I had mentioned earlier, it's so important that we evolve as a police department and meet our communities where they are. And I'll give a couple examples if you don't mind. We've talked a lot about within the department that we know that our communities suffer at times and go through trauma. So it's very important for our men and women to have training as it relates to how we respond in those moments. What resources can we provide for community? But one of the things that we have not talked about in this profession, and sadly, is the impacts of trauma on our own officers. And so wellness, we do a great deal of training and work on officer wellness because we need to make sure that our officers are well when they're interacting with our communities in that regard. I will also tell you a few years ago, We were hearing from members of our transgender community and how they had felt police have played a role in their lives, and not always good, quite frankly. And so we were able to, through conversation, through discussion, through meetings, being very authentic, we were able to sit and craft a policy based upon members of our transgender, gender nonconforming community really guiding that. And we had the first policy ever in that. And so, again, it's so important that we as a police agency continue to evolve, continue to place value on all of our community members. And so that's very important.
Now, speaking of Minneapolis police policies, you're aware that the police department has a fairly extensive policy and procedure manual. It's pretty thick, correct?
Yes.
And is it important then for policies and procedures to be in a written form so that officers can understand what the expectations are?
Yes, it is.
And those are public documents so that the public, they're also able to see what the expectations of the police officers are, correct?
That is correct.
As the chief of police and being employed by MPD as long as you have, I take it you're familiar with the Minneapolis Police Department policy and procedure manuals and all the content contained inside?
Yes.
You in fact created some of these policies?
That is correct.
Are Minneapolis police officers required to be familiar with the various written policies?
Yes, we are.
And there's a policy requiring them to be familiar with the policies, correct?
Yes, that is correct.
All right. So if you would please publish Exhibit 207. If you would highlight Section 1-103. This is the policy about the policy, and it requires that the MPD employees shall be provided instructions on how to access the policy and procedure manual. Is that right?
That is correct.
And they're accountable for knowing how and where to access, and for knowing the contents of the manual. Is that right?
That is correct.
And they're also required to sign a receipt acknowledging their responsibility for knowing the contents of the manual, correct?
Yes.
Because the first policy manual that you would receive as a patrol officer might not be 30 years later what you're going to be looking at, correct?
Yes.
So the policies are changing, but they're published, they're public, and the officers are required to know what they are and to sign something saying that they will continue to review them. Is that right?
It's preliminary, overruled.
Yes.
All right. Well, if you could take that one down, please. At this time, asked to just display to the witness Exhibit 274 for identification. Sir, do you recognize this the general form here of being an electronic version of the MPD policy and procedure manual acknowledgement?
Yes, I do.
This is an example of an acknowledgement form that a Minneapolis Police Department employee patrol officer would sign upon being hired. Is that right?
Yes.
Just indicating that they're aware that there are written policies and committing to reviewing them and accessing them. Is that right?
Yes.
At this time, I'm going to offer Exhibit 274.
274 is received.
All right, if we could then publish Exhibit 274 to the jury. And you see this is, again, one of the forms that was signed by a particular officer upon hire. And if you could please highlight the name. And that's signed by Derek Chauvin, Derek Chauvin, badge 1087, December 28, 2001. Is that correct?
Yes.
If you could take that down, please. Minneapolis Police Department has a code of ethics, is that right?
Yes.
And the code of ethics is contained within the policy manual. Forgive me, we're going to be talking a lot about the policy manual. I kind of marched through some of these, but the code of ethics, if you could please display Exhibit 215, page 2, and if you could highlight 5-10201. And as the Code of Ethics provides in the policy manual, law enforcement officers' fundamental duty to serve mankind and safeguard lives and property, and to protect the innocent against deception and the weak against oppression and intimidation. Is that right?
That is correct.
And if you could take that down, Minneapolis Police Department also has a professional policing policy, is that right?
Yes.
At a high level, can you describe what professional policing means in this context?
Yes, our Minneapolis Police Department professional policing, it's really about treating people with dignity and respect, above all else, at the highest level. It's that we see each other as necessary, we value one another, and it's really treating people with the dignity and respect they deserve.
If we could display then Exhibit 215, and drawing your attention to page 4, section 5-104.01. Sir, is this the professional policing policy?
Yes, it is.
And could you read the first bullet, please?
The first bullet reads, "Be courteous, respectful, polite, and professional."
And if you would then also read the third bullet.
Ensure that the length of any detention is no longer than necessary to take appropriate action for the known or suspected offense.
And you can take that down, please. Sir, fair to say that law enforcement generally has changed a lot since you started back in 1989, is that right?
That is correct.
1989, you didn't have body-worn cameras, correct?
That is correct.
And nor did you have sort of the ability for civilians, bystanders, to video or record conduct of police officers, right?
We did not.
Because we didn't have smartphones.
That's true.
And now we do.
Yes.
And as you indicated, the policies and culture of the police department has to change with the times, is that right?
Yes.
And so in terms of understanding that sometimes bystanders do use their smartphones to take video images of police officers, has the Minneapolis Police Department imparted any training or constructed any policies to prepare officers for people recording them?
Yes, we have. We've imparted policy that really is informing officers that individuals under their First Amendment rights, they have the absolute First Amendment right to record through cell phone video or other types of video officers interacting or engaging with a community member, with the exception that they cannot obstruct the activity of the officers, but they absolutely have the right, barring that, to record us performing our duties.
And what does obstruct mean in this context?
Obstruct would mean interfering, doing something where you are physically placing yourself in a position where you're prohibiting the officers for carrying out their lawful duties. But barring that, individuals have the right to record our engagement with our community.
Well, Chief, you'd have to acknowledge that a patrol officer may find it irritating to have a civilian recording their activities. True?
Very true.
Is that obstruction?
It is not.
At this time, I'd like to display to the witness only Exhibit 273, and if I may step away for a moment. And at this time, I will offer Exhibit 273.
Any objection?
No objection.
273 is received.
If you would publish 273, and I'd like to draw your attention to section 9-202. And again, this is the public recording of police activities, providing employees guidance with dealing with members of the public, recording them. Is that right?
Yes, it is.
And generally, this informs officers that unless you're being obstructed, people get to record you.
Yes.
Even if you don't like it.
That is correct.
And how long has this been policy of MPD?
Since May of 2016.
All right. Thank you. You can take that down. Sir, are you familiar with the concept of de-escalation?
Yes.
What is de-escalation?
De-escalation is providing a knowledge base or skills, in this case for officers, to really focus on time, options, and resources. It's really primarily trying to provide an opportunity to stabilize a situation, to de-escalate it, and what the goal is having a safe and peaceful outcome. And so there's tools associated with that, but that's really the goal of de-escalation: time, options, and resources, so that we can stabilize a situation peacefully and safely.
When you think of de-escalation, are you thinking of it as the sort of the opposite of using force, or is it a part of using force?
We teach it as both.
And when you started with the department back in 1989, was there an emphasis on de-escalation?
It was not mentioned. It's not heard of back then.
Okay. When did de-escalation start becoming more of a topic of conversation in law enforcement communities?
I think that right around late 90s, 2000, I think that when we were when there was attention, not only in Minneapolis, but in departments across the country, and incidents particularly involving police encounters with those who were suffering from mental illness, we really started to see a lot of work on that. Here locally, the Barbara Schneider Foundation, there was a very tragic incident in Minneapolis many years ago that involved the death of a community member. But when we started, that was really what kind of culminated for our department, de-escalation. And even when you heard departments starting to talk about other tools like tasers, all of these types of things, it was around that time frame that I think our department really started getting a lot more education, awareness, and training as it relates to de-escalation.
What about just, even if you weren't taught de-escalation formally when you started back in 1989, as a practical matter in practice, is that something that's been employed by experienced police officers for a long time now?
Yes, it has.
What about in your own experience when you were on patrol? Did you use de-escalation techniques?
Yes, quite a bit. Yes.
And did you find them to be effective, a way to maybe talk somebody down from a situation rather than needing to use force?
Yes, and with the primary goal is that you want to keep yourself safe as an officer, and you also want to keep the community safe. And so a lot of it hinged on communication and listening and verbal skills. And so if you could talk your way out of a situation to de-escalate where it didn't have to result in physical force, those were things you certainly utilized, and you were always in a better position to look upon someone that you worked with who had that skill set to do that.
But if you can't talk somebody out of the situation, if you can't de-escalate, you can't, right? And you have to then use a different method.
That is true.
Okay. And so it really comes to what's reasonable at the time. Is that right?
Yes.
Does Minneapolis Police Department currently have a de-escalation policy?
We do.
And at this time, if I can display Exhibit 219. You have this one, okay. I think it is admitted, I just want to make sure you have it. Okay. Yes, if we could publish Exhibit 219. And then Minneapolis Police Department Policy 5-304, threatening the use of force and de-escalation. This is the policy, and it's a policy as it existed on May 25, 2020. Is that right?
That is correct.
If we could highlight the first paragraph A, threatening the use of force. Okay. And I'd like you, sir, to please just read into the record the paragraph that you see here. All the way up until, I guess, the first sentence. We'll make you read the whole thing.
As an alternative and/or the precursor to the actual use of force, MPD officers shall consider verbally announcing their intent to use force, including displaying an authorized weapon as a threat of force when reasonable under the circumstances.
And I guess, is it an either-or alternative? Is it like you either de-escalate or use force, and once you start using force, you just give up on de-escalation?
The goal is to resolve the situation as safely as possible. So you want to always have de-escalation layered into those actions of using force.
And if you could take that down and highlight paragraph B, de-escalation. In accordance with the policy, officers, the language here is mandatory when reasonable, whenever reasonable, shall use de-escalation tactics to gain voluntary compliance. Is that right?
Yes.
And to seek to avoid or to minimize the use of physical force, correct?
Yes.
And seeking to minimize physical force, that can be happening while physical force is being employed, can't it?
Yes.
An officer can be using physical force, and during the course of that, still maintain attempts to de-escalate and defuse the situation.
Yes.
Okay. And if you could clear that, please. And as part of a de-escalation, the policy indicates the officers are supposed to do what?
Attempt to slow down or stabilize the situation so that more time, options, and resources are available.
When you talk about more time, options, and resources, could options and resources include, for example, using other officers who may be at the scene?
Yes.
Or calling for backup?
Yes. Actually, it can also include seeking community's help in a situation as well.
And in employing de-escalation techniques, in accordance with the policy, the officer is required to consider a number of factors regarding the subject. Is that right?
Yes.
And we're assuming here that the subject is non-compliant. You run into people who, maybe don't want to comply with police officers. but you can also run into people who just for some reason are unable to do so at that moment. Is that right?
Yes.
And officers are required to consider, and if you could highlight B and the bullets that come underneath. The officers under the Minneapolis de-escalation policy are required to consider whether the subject's lack of compliance is a deliberate attempt to resist or an inability. Is that right?
Yes.
And if you could read, first, the first bullet is medical conditions, correct?
Yes.
We have mental impairment, developmental disability, physical limitation. Some of you may just be physically unable to comply, correct?
Yes.
Language barrier. The city of Minneapolis has a variety of people who speak a variety of different languages. Someone just may not understand you, right?
That is correct.
And if you're not considering that, perhaps the situation could escalate into something greater than it would need to be.
Yes.
The last two bullets, first, could you read the second to the last bullet?
Yes. One of the other considerations officers should take into account is the influence of drug or alcohol use.
How so?
We know the research says that people can react differently when they're under the use of alcohol or drugs. And so you trying to give verbal commands, if someone's under the use of alcohol or drugs or you're doing force, it may have a different reaction to them. So that should be something that you should be considering.
And 12:30. Sir, drug or alcohol use, in this context is being required that the officer consider to determine if de-escalation is appropriate. It can be true that some people who are under the influence of drugs or alcohol can become dangerous, correct?
That is correct.
But isn't it also true that some people react completely different and they are not necessarily dangerous if they're under the influence of alcohol or drugs?
That is correct.
In fact, they may not be more dangerous, they may actually be more vulnerable.
True.
And it's important that the officer considers that when determining whether to go the route of force or continued force or de-escalation. Fair?
Yes.
Behavioral crisis is the last bullet I'd like you to discuss. What do you mean by behavioral crisis?
Behavioral crisis, of all the bullets, sometimes that is probably the one that our men and women experience in our communities most. If someone loses a job, that can trigger a behavioral crisis. If someone loses a loved one, that can trigger a behavioral crisis. If someone has themselves got the worst diagnosis from their doctor that day, that can trigger a behavioral crisis. And so we want our folks to take all of those things into consideration. When I talk about meeting our community where they are, that's probably the one that we need to really focus on. Yeah.
And as you testified earlier, the police just don't get to meet people on their very best day, do they?
No, they don't.
And the behavioral crisis, as the kind you've described here, can in fact be a barrier to compliance. Would cause an inability to comply, even if not, an intentional inability to comply. That's fair.
Let's go to list lead,
Yeah.
please.
Yeah.
Thank you.
And so the purpose of the listing a behavioral crisis as a point of consideration for a law enforcement officer is what?
Again, it's recognizing that when we get the call from our communities, it may not often be their best day, and they may be experiencing something that is very traumatic. But we're going to respond, but we have to take that into consideration because, as I mentioned again, we may be the first and last time they have an interaction with a Minneapolis police officer, and so we have to make it count. It matters.
Would this be a good time to stop before I go in the next line? I'm sorry, I was trying to push it to the time limit. So.
All right, members of the jury, we'll take our lunch break, come back at 1:30. Chief, you may step down.
A remarkable moment in Minneapolis as the city's chief of police takes the witness stand in the trial of Derek Chauvin. You are watching a Washington Post special report. I'm Rhonda Colvin. With me now, Eugene Scott, reporter for The Fix, and James Homan, Washington Post columnist. So this is the first part of this key witness that we've been waiting for, Chief Arredondo there in Minneapolis. We learned at the top the prosecution wanted to set up that he is a longtime officer. He started on the force in 1989. He is the first black person in that role, and he sort of worked himself up the ranks. We listened to that over and over again, learning about his entire resume. But now we're really getting into somewhat of his perspective on use of force, his perspective on de-escalation. And you're sort of hearing, they're not asking direct questions yet about Chauvin, but it seems like they're teeing up for that to happen perhaps after this lunch break. So Eugene, what are your takeaways right now from what we've heard from this witness?
There was quite a bit, and I was referencing some notes I was able to take, and one of the things I found to be very interesting was how they pretty much had the chief just lay out repeatedly in so many different ways of all of the ways that he believes that perhaps Chauvin went against the police department's policies and how he handled George Floyd. He seemed to imply that there were just quite a few numbers or points that were missed or glossed over or just mishandled perhaps in terms of how he interacted with Floyd and how that perhaps led to the ultimate result, which was Floyd's death. And so it appears that it wasn't a matter of whether or not Chauvin just violated a policy by using a knee and using it for so long. There seemed to be multiple steps he could have taken or handled differently that he did not, that ultimately led to Floyd's death.
Yeah, and James, jump in here. What's been your read of the police chief's testimony so far?
It's been really interesting how the prosecution, Rhonda, has tried to preempt a lot of the defense arguments. So obviously everything Eugene said, and we've walked through the code of conduct, the code of de-escalation, all the stuff that someone like Officer Chauvin should have been expected to do. One of the things the defense plans to say, and we saw that during the motions this morning before the trial got underway, is to argue, well, you know, Derek Chauvin has been on the force for 19 years. Things have changed, you know, in the early 2000s when he became an officer, they didn't teach all the stuff that they do now to new recruits. And so you saw the prosecutor say, even you, Chief, the head of the police department, who's been in the force since the late 80s, have to take this annual training in which they emphasize a lot of this stuff. Even you, Chief, have to sign this document saying that you understand this code of conduct, that you have an obligation to serve with compassion, which is the motto of the police force, but you also have an obligation when you're interacting with someone that you're arresting to recognize that they may be under the influence of drugs and alcohol or in emotional distress, and you are trained and have certified that you have an obligation to adjust your response accordingly. They also preempted the argument that, you know, that the angry crowd got in Derek Chauvin's head that he had tunnel vision, which is the words that Eric Nelson used last week, by saying, you know, are people allowed to use camera phones to record what's going on? And the chief said, yeah, they have an absolute First Amendment right unless they're obstructing law enforcement. And then the prosecutor said, well, what does it mean to obstruct law enforcement? Is annoying the officers or yelling at them enough? And he said, no, that's not the standard. So it was striking in some of this, you know, throat clearing ahead of getting into the nuts and bolts of what Chauvin did, that they really got out front of a lot of what we can expect Eric Nelson to hit hard on either later this afternoon or tomorrow.
Yeah, and one of the things that struck me during that portion about de-escalation tactics is the police chief, when the prosecutor was asking him what are some of the tactics that you can use to de-escalate, he listed some of them, but then he added on his own, it could also mean involving the community's help to bring the temperature down. And that, of course, reminded me of last week. Eugene, does he seem to be supporting all the things we heard last week from these witnesses who said they wanted to help? and were kept back?
It certainly seems that way, and he spent quite a bit of time communicating what he felt is the responsibility of law enforcement to interact with the community even before you get to this point, to form a positive relationship, to let them know that you're there. I believe he said exactly, seeing your neighbor as yourself, which communicates some level of equality, or not the superiority, inferiority complex, or should I say, tone that so many law enforcement and Black Americans just battle with very often when they are interacting with one another. And so he talked about the necessary role that having a healthy relationship with the community could play before you get to this point, and therefore you'd have the power and the background to be able to bring in the community to help bring a situation, de-escalate a situation down. I think one of the things that was also memorable was his noting that officers are trained in CPR. And when you think back to the testimony of the doctor who pronounced Floyd dead, he talked about the importance of CPR and getting it performed as quickly as possible, which is not something we saw here, which is something that medical experts suggest could have saved Floyd's life.
And Eugene, you have provided a great segue for a clip that we want to play now. This trial is unprecedented in many ways, and one of the most anticipated moments when the current police chief took the stand as a witness for the prosecution this morning. Listen to the Chief of Police Department Chief Mandara Arredondo talk about the mission of his department.
To protect with courage and to serve with compassion.
And what does that motto mean?
We are oftentimes the first face of government that our communities will see. And we will oftentimes meet them at their worst moments. And so the badge that I wear and that members of the Minneapolis Police Department wear, it means a lot because the first time that we interact with our community members may be the only time that they have an interaction. And so that has to count for something. And so, so it's very important for us to make sure that we're meeting our community in that space, treating them with dignity, being their guardians, and representing and all of the men and women that came before us who served so proudly on this department.
And the police chief, James, he spent a lot of this early time of his testimony sort of discussing what the approach should be and the ideals that they hold dear. Even though it's Chauvin on trial, sometimes in these cases it also appears as if that police department or that city is on trial. Has it been striking to you at all, James, that the police chief seems to be using some of this time to express his vision for the police department and what they want to do and some of the progress they have made?
Yeah, it hasn't surprised me. I mean, this is his main task as chief, is to re-earn the trust of the community, to have people feel confidence that law enforcement is there for them. And you're right, Rhonda, that's a really good observation about how this was a lot of aspirational. You know, he walked us through the brass tacks of what the policy says, and he read aloud, key paragraphs from the formal policies and the thick rule book. But right after that clip we just saw, he said, we see our neighbors as ourselves. Our communities are not monolithic. And in fact, the prosecutor let him speak, for a solid minute about how they've worked with the transgender community and gender nonconforming folks to evolve their policy and to be part of the community. So he's trying, his audience is the jury. This is a criminal trial. There's one of his former officers who he fired, who's on trial for murder. But his audience is also the city of Minneapolis. And so a lot of this is educational in explaining, the city gets hundreds of thousands of calls for service a year. He said the minority of them, a relatively small percentage of them, are actually related to law enforcement. And I thought what he said about the standard that you can't look at someone's body of work I thought that was a really interesting observation from someone who's been with the force since 1989, which is, you may have done everything right the previous 99 calls, but if you're the person who's getting responded to with that 100th call, you don't care about how the officers treated the other 99 people. You care about how you're treated, and it may be your only interaction with law enforcement. So the prosecution is certainly letting him sort of elaborate. This is the head of the department who's been chosen by the mayor. And it does feel like he's thinking about more than just the jury. He's thinking about the city.
Yeah, and it's important too to look at his background. So he has been on the force since 1989, and he became chief a few years ago. The person before him resigned over a police shooting that happened there. Some people may remember it because it did get national attention, where a Somali-American officer in Minneapolis shot an Australian-American woman who had called and said she had heard what she thought was a sexual assault in the alley behind her home, and she was killed when that officer shot her when he arrived on the scene. So this police chief is very aware that eyes are watching him locally as well as globally, and a lot of what he is saying is his approach overall about policing, and potentially also using this as a platform to show people that now that this is under his jurisdiction, he wants to make some changes. Eugene, have you been struck at all by his demeanor? He seems fairly calm. He seems just like an officer who's there to tell the story about this department, and eventually we assume he will get to specifics on Chauvin's character at the scene.
It's a reminder that police chiefs have the ability to play multiple roles. He's certainly the chief of a department and the top people manager of that organization, but he also comes off as a spokesperson, a community relations person who seems to be very mindful and aware of the reputation that his job and his department hold right now, considering how many eyes have been on them over the past nearly year. To his point that this might be your first interaction with that particular officer, and you need to be mindful of how you are moving and speaking and communicating with the person. Last May was most people's first interaction with the Minneapolis Police Department. And so I think what he's trying to do is communicate, hey, this introduction that you had is not representative of the department as a whole, and certainly not according to our policies, and more importantly, perhaps not in line with as the chief's vision for how we will interact with the people we were, charged to serve.
Thank you for that point, Eugene. Joining us now is our colleague, Stephen Rich. Stephen, you are the database editor for the investigations unit at the Washington Post. Can you tell our viewers what that job entails?
So my job is I work as an investigative reporter, largely pulling data for any number of things. One of my areas of specialty in recent years has been on policing in general, doing stories about police shootings, homicide solve rates, and what it takes to fire a police officer.
All right, and Stephen, you also were part of the team that looked at how officers who are found to be a part of some sort of misconduct are often rehired on the job even after they've been fired and that misconduct has been made public. For people who may not be familiar with that project and should go to the Post to review it and look at it, it's a great project, but could you describe some of the cases that you followed that were, to you, perhaps stunning examples of how officers' misconduct doesn't always mean that they don't have a job anymore?
Yeah, I mean, so in the vast majority of cases where a police officer shoots and kills someone, there are no charges. In most of the cases, charges are barely even considered. And some of that is just because there are so many guns in this country that the people that police often shoot at are people who are firing back at them. But we have seen many cases where police officers fire on people who don't have weapons, who aren't facing the police officers, who witnesses say weren't threatening police officers, and there are never charges brought. There are plenty of cases where that's the case until a video comes out. I mean, we saw it with the Walter Scott case years ago in South Carolina, where a man who was running away from police, there weren't charges filed until after a bystander video came out that completely disputed the police's version of events. And that's ultimately one of the problems with charging police in many situations, is that there's often two people who know what happened in one of these situations, and one of them is dead. And so oftentimes the person who is relied on to give the story is the police officer who shot and killed someone. And oftentimes they get to review evidence prior to giving a statement.
Now, what are the reasons why officers who have either shot someone or been involved in misconduct, what's the reason that they often can get their job back?
Police unions in this country are very, very strong, and so we found in an investigation about 4 years ago that a large percentage of police officers who get fired end up being forced to be rehired through the arbitration process. And some of the reasons are as simple as the police department didn't investigate and fire them fast enough. And so because the contract says they had to do it within 90 days and it happened in 91 days, the police officer automatically gets their job back. And in many of these cases, it's for things that they've done before. So we saw a guy in Texas who got fired for basically telling subjects that people that he had arrested that he would uncuff them and let them go if they would fight him, like physically fight him. He got fired for that and rehired. Shortly thereafter, he did the exact same thing, got fired for it and rehired for it again, because the first time the firing didn't take, the second time it couldn't take either. And so what we see is that it is very difficult to fire a police officer and keep them fired, because union contracts can often be very specific.
Yeah, and I want to bring James Homan and Eugene in on this too. So Stephen's discussing, how it seems to not stop someone's career if they're an officer if they are found to have been part of some misconduct. So James, I remember when we were here last Monday and the family of George Floyd and the lawyers for the civil lawyers, Ben Crump, were there, and they were saying that, this is, of course, this is coming to trial, but we should brace ourselves that they're going to discuss George Floyd's character, and potentially we don't know what's going to happen with this verdict, so brace yourselves. What is your thought that this case is important in terms of the fact that it got to trial already?
Yeah, well, and Stephen has done such important work because, in our whole team, to show that this isn't one isolated incident where one cop did something wrong. That this is the database work that he and his team have done has shown kind of the systemic nature of this, where so often that is what there's one side that you hear, and so often officers don't get prosecuted because of really strong police unions that protect them, and also they usually the person that's interacting with police doesn't have a completely clean record. This is not the first trial where someone defending a police officer has cited the person's drug use. In fact, that's sort of the go-to norm. That's why the chief's testimony, Rhonda, is so significant, because one of the things he explained was he was a patrol officer early in his career. He worked for Internal Affairs, which is the group within the police department that reviews allegations of misconduct. And he said that one, he himself has had people resist arrest, and that he said it's a regular occurrence for suspects to resist arrest when police are trying to take them into custody. What's not a regular occurrence is people dying. It's not necessary. And in fact, it doesn't happen that often where someone dies when they're taken into police custody, as happened in the instance of George Floyd. And so this is not a normal thing. This isn't, this helps the prosecution make their case that what happened to George Floyd was not following procedure and general principles and the specific training that Officer Chauvin received.
And Stephen, back to you for a last question. I was reading over the weekend that even if Chauvin is found guilty, he still is set to earn about $50,000 a year from his pension plan, even though he's been fired, and if he goes to prison, he will still get that pension. I know that's not something you have covered specifically, but from your reporting, was it stunning to you to find how well insulated police officers are from misconduct?
Yeah, I mean, we've seen it over and over again, and we know that police officers have a lot of protections. Even the ones that are fired or suspended, they're often suspended with pay. And the investigations, they can take years. And if at the end of that time, even when they do find that there was misconduct, they're still being paid for all of the time that they weren't actually doing anything. And so it's really not surprising at this point that police officers, even in this extreme, still benefit in some way, whether it's the pension, whether it's like if he's found not guilty, it seems very likely that he could get his job back. But you know, what we see is that police officers, no matter what they do, there's always sort of some layer there. And part of that is because there's not an overarching system in this country that prevents what, you know, some people may refer to as the bad apples from getting jobs in other police departments. I mean, if you just looking really quickly at the case of Tamir Rice, the officer in that case, his initial police department said he was unfit to carry a gun, and he very simply went to another department, and then the shooting happened. And so we've seen that there's like police officers, if they lose a job, even when they do lose a job, getting another job isn't particularly difficult for most of them.
Thank you so much, Stephen, for explaining your reporting, and thank you for joining us today.
Thanks for having me.
Eugene, Stephen brings up an excellent point that has sort of been an underlying theme here as we've talked about this trial, is that police unions are hard to beat, they are hard to confront. But this particular police chief, we do know that he has said that he wants to stop negotiations and contract discussions with that local union there in Minneapolis. So does he strike you as someone who does want to see progress as much as he can while he's in the role of police chief?
Well, he certainly seems to be giving that impression. Those closer to the ground activists who are more familiar with the police department in Minneapolis have raised some concern about the level of its commitment, considering that many of them have seen other issues come from the Minneapolis Police Department that have raised concern. But he's certainly trying to communicate to the public that this is not something that he wants tolerated in his department, or to become common, or to excuse and dismiss as something that was appropriate or necessary considering everything that happened. The relationship between law enforcement and community is so on trial in this moment, and I think that's something that he is trying to make the case for, that it is something he's been concerned and passionate about for years, and that this incident was a violation of that, and the work and effort that the police department has tried to put into making sure that this was a community where all people felt safe. So it'll be really interesting seeing going forward what role the outcome of this trial has in negotiations and just the future of what policing looks like in Minneapolis.
All right. Mark Berman, national reporter, joins us now. Mark, the testimony of the chief of police today was one of the most anticipated moments of this trial. How do you think the chief is doing as a witness?
It's clear that he's taking this obviously very seriously, as one might imagine. This is not a very common thing, as has been discussed already on this program. It's not common for a police chief to testify against an officer on trial. And somewhat strangely, this chief has actually done it twice. This is the second time in a couple of years since he took on this role that he's actually testified against one, in the trial, I should say, of one of his own officers.
Yeah, and we should discuss that rarity. Thank you very much for bringing that up, that not only is it rare for an officer to be brought to trial, it's very rare to even see a chief be testifying against one of his own. So thank you for bringing that up. Has there been a moment today that stood out to you specifically?
So far, nothing has jumped out except for the fact that it's just the idea of seeing a chief in uniform on the stand. Obviously, so far, they've gone through a lot of his history, his experience, how he came to be in his position. But just the idea of seeing a uniformed chief on the stand is so far the thing that struck me the most, just because of just the sheer unusualness of it.
Right, and Mark, you've spent a lot of time writing and reporting on the jury selection process. Has there been a moment over the last few days since we last spoke to you that has stood out to you and how it might be playing to this jury?
You know, that's interesting. It's what we have from the pool reports. So the people in the courtroom, obviously, who are seeing how the jurors are responding to this. Sometimes the jurors are taking sort of very aggressive notes, very focused, very keyed in, and it's not clear yet exactly what exactly is going to be resonating with them. But what we've seen so far, I mean, the two key themes have been witnesses discussing how painful, how traumatic this has been. That's obviously been very difficult testimony for the people on the jury to hear. And then since then, the policing testimony, which is essentially decades of police experience on the stand talking about how they view this.
And you've covered cases before, of course. How does the prosecution of a non-police officer compare to that of a police officer?
Well, honestly, the thing that defense attorneys and prosecutors have said is that it's essentially just entirely different. It's a whole different ballgame for them. The idea being, when you're prosecuting a police officer, they say there's just a much higher bar. They have a lot of legal leeway to use force. And for defense attorneys, they say there's a lot of scrutiny. And in cases such as this one, where there can be video footage, or there can be a controversy, it can be very difficult, they say, because the public outrage sort of suffuses the situation.
And you mentioned video. Does the amount of video evidence in the case of George Floyd change any of the odds?
That's unclear, but a few experts I've spoken to have said that one thing that makes this trial, this case, unusual in the context, one of the things that makes it unusual compared to other prosecutions of police officers, they say, is that video and the fact that it's not a quick clip, it's so extended. What we often see in some of these shooting cases in particular, what will happen is the case will, when it goes to trial, the defense will argue that there were things that happened before the camera started rolling and after it stopped. And so they'll say that clip, however controversial, is not the full story, which is also what the officer's defense attorney is arguing here. He's saying that those 9 minutes and 29 seconds is not the entire universe of the case. But what the experts say they've seen so far from this video is that it offers such a wider scene, such a longer scene. The footage is so much more than we've seen in some of these other cases that it stands out as something very striking for essentially the jurors to have to digest.
And I want to bring James Homan in on this too. So Mark is telling us about the presence of video and what that could mean in the eventual verdict. Has it stood out to you that we seem to keep uncovering more video? Like, we just thought it was that viral video at first, but all last week we saw body cam, we saw inside the ambulance, and today, this morning, over motions, there was even discussion about even more video being entered. So James, has that stood out to you that we keep seeing extended video of this?
Yeah, Rhonda, it's such a feature of this case, and it really is. I mean, we wouldn't have had the reaction we did last summer, and we wouldn't have had the national reckoning if not for the video from the bystanders. It is remarkable how much video we still have actually not seen that we know exists. And one of the reasons the motions this morning were so interesting is that what the defense wants to do is introduce the body camera footage from right after the officers, the George Floyd's taken away, and the officers are talking to one another and sort of explaining what happened. And the prosecution does not want that video admitted because the other three officers are not going to testify for Fifth Amendment non-self-incrimination reasons, which is their right, at their colleague's trial. And so the prosecution said, what you're doing by letting the video play is you're letting them tell their side of the story, which is hearsay, without giving us the opportunity to be able to cross-examine them and to actually get what really happened. And the judge basically gave a split decision and limited what exactly the jury will be able to see from that body camera footage that was taken after George Floyd was driven away in the ambulance. And so there's a lot of sensitivity. One of the things that will be fascinating to see when the defense gets to make their case is, are we going to see the full, from that poll camera that we've seen so many images from, including the officer sitting on Floyd, are we going to see the 15-minute wind up to when that happened? I assume we will, of George Floyd resisting arrest, which is what prompted the police.
Sorry, guys, I've been working. Rhonda, I've been playing chemist. I gotta work, girlfriend. What's up, Capone? So, I'm wondering, should I shut down till 2:30 or you guys want to converse with each other? You guys tell me. I'll leave it running. I don't really care. You guys just tell me what you want to do. All right, nobody's answering. No, I'm working. I had to make like 7 lipsticks. I'm still doing it. All right, so I'm going to let this run. I'll be back.
Officers in America, and you report on so many departments nationwide. How closely are all of those departments watching this trial?
I think it's fair to say that a lot of them are watching it very closely. There's several reasons for that. Obviously, one is simply that, policing, what I've been told many times year after year by officers all over the country, current and former, is that they sort of view an issue for policing is never local, right? They say anything that affects policing in one part of the country affects the entirety of the profession. So the argument tends to be that if there's a controversy involving one, if there's a scandal involving one, other departments are watching, they're aware, they're watching for potential protests in their area. And one key thing here is obviously that the outcome of this trial could lead possibly, as I think James was saying earlier, could lead to possibly some protests, some unrest in the streets of Minneapolis and other places. If there's not, for example, a conviction, it's expected that there will be protests and unrest in Minneapolis and other cities. And so police are watching that for, at the very least for that reason. Then the other thing experts say they're also curious about is if there is a conviction in this case, they wonder how that could resonate with other officers around the country. Will they see something like this and then think twice about this use of force or that, or how will it affect sort of how they approach their day-to-day jobs? Because, as mentioned, police are not charged all that often, and being convicted of murder for police is obviously very rare.
Thank you so much for those points, Mark. Thanks for joining us. Eugene, going back to this, the thought of how much video has come out, I'm wondering from your perspective, you've written about the Black Lives Matter movement and how it was propelled by young activists from its beginning, back in, back during Trayvon Martin. It wasn't just something that came up with George Floyd, it goes way back. I'm wondering what you think about if this trial wasn't as visual as it is, whether it be the viral video or whether it be all of this body cam video that we're seeing, do you think that young people would be watching this case as much?
It's hard to believe that anyone would be watching this case as much if this trial was not as visual as it was. I spoke with quite a few conservatives last summer, people from demographic groups that historically have sided with law enforcement, or at the very least have just really doubted and questioned Black Lives Matter and other activists and their depiction of law enforcement when it comes to their interactions with Black Americans. But that video, those videos going viral as they did at the time that they did, in part due to the recordings made by so many of these young people, definitely changed popular opinion. We saw, I believe, last June in Pew Research Center said that more than 65% of Americans were sympathetic or sided with Black Lives Matter in terms of their desire to call attention to police violence against Black people. And so we know the power that images have and that recordings have in terms of putting forth a narrative and providing some context and helping affirm and confirm the accuracy of the stories that so many young Black people have been telling about police since the Black Lives Matter movement began, and even years before.
Yeah, and James, I'd like to hear your perspective on that too. If we didn't have all of the visuals that we have of this case, do you think that it would have ignited what it did with young people?
Yeah, Rhonda, it's really interesting because you think about what the takeaway from this whole proceeding is going to be. And it obviously depends to a large degree on the outcome of the trial, right? If there's a conviction or not a conviction, people will take different things from it. But I think it cuts both ways in the sense that if there is a conviction, police officers will behave differently. And maybe some people will be less inclined to become officers, but it's probably a good thing for police who might misuse force to behave differently. So similarly, if there is a conviction, I think a lot of young people will see that the system worked in their view, and that that there was justice, and that there was a trial, and that there was due process, and that law enforcement officers who break the law will be held accountable. That in the cliche but true statement, no one is above the law in America. And so a lot of it, in terms of the impact on young people, whether they go into law enforcement, whether they go to the streets, really depends on what this group of 12 jurors decides to do.
Yeah, I also want to talk about something that stood out to me in the police chief's comments before they took this lunch break. And just to let people know who are following this with us, the jury and the courtroom right now, they're on a lunch break. But one of the things the police chief said is, one of the reasons officers need to be aware of the entire situation is that some people are going through a behavioral crisis. And he talked about it could be a loss of a loved one that triggers a behavioral crisis. It could also be the loss of a job. And I couldn't help but think George Floyd fit both of those. He had recently lost his mother, and he says that in one of the body cam videos that we saw last week. He told them, look, I just lost my mother. And then he had also lost his job. His girlfriend, Courtney Ross, who testified last week, said that he had not been working because of COVID. He was a security guard at a local establishment, and they had to close because of the closures to do with the coronavirus. So, James and Eugene, do you think that this police chief, we talked about how he's sort of being this public spokesperson for his department, but is it also that he's being a spokesperson for all of the great police officers who are out there who do believe in this sense of community policing and being more in tune with the people that you are working with in the community? And Eugene, I'll start with you.
Well, certainly, and I believe, as you noted, he started off his talk a bit about the mental well-being of law enforcement, who are often traumatized by their own work and who far less often are getting treatment for that. As we've talked about repeatedly since covering this trial, of the role of mental health on victims, on witnesses, and now on law enforcement. It's what he's trying to advocate for. And I would not be surprised if we saw more conversations about mental health when we look at police reform, when you hear lawmakers entertaining what they believe needs to be done to make law enforcement better stewards of the communities that they are serving, being more attuned to their own mental health. And so I think one of the things that the chief wants to make clear is that these individuals are not villains who are often looking to cause trouble and cause harm or end lives, but very much human beings who are juggling so many very different things, like the rest of us, and juggling so many very different things, like the rest of us, and struggling sometimes trying to figure out what the best decisions are when they find themselves in very difficult situations.
Yeah, and James, I'd like you to weigh in on that as well. Is this police chief also sort of a spokesperson for, other communities and other departments?
Yeah, what he was a spokesperson for is the need for law enforcement to evolve. Every industry, every job changes as the world changes. And he noted that, not just because there's now cameras, is everyone always on, but that, he said, thank goodness we've changed and evolved our training since I took over about what's acceptable and what's not acceptable. And on specifically the issue of mental illness, which is so important, he cited a specific case that prompted in the early 2000s, and I remember this well because I lived there then, a mentally ill person who was killed by police, absolutely tragic, which is the same word that the chief used. And that caused a series of reforms, similar to how, in a different way, George Floyd's death has led to a series of reforms and codifying things into law and into practice statewide and locally. And so the police have to evolve with the time, and as circumstances change, as our understanding of mental illness has changed, the training has evolved, and the expectations for how officers deal with people have evolved. Same thing with drug use. There's just a very different understanding of how to deal with an intoxicated person than there was 25 years ago from a law enforcement perspective. And so that, I think, it is what the chief is trying to communicate, is that the police department is evolving with the times, that we're not trying to police in the way that we did in 1989 or even 1999 or 2009. And so I think that is part of, to your great point, him reassuring the community that the police are adjusting with the times. Same thing with talking about how they created a new transgender policy, something, that wasn't a big issue 10 years ago, but now they take seriously. And that is very, very important for rebuilding community trust.
Yeah, James, you raise a point that is related to something I was thinking about after last week when we heard Eric Nelson, the lead defense lawyer, question Courtney Ross, the woman who was George Floyd's girlfriend, and he extensively questioned her about her past drug use. She discussed being what she called a classic case of opioid addiction. She and George Floyd had chronic pain issues, and they became addicted to opioids. And I was thinking about how, their case, the defense's case, is sort of the center of it is this idea that George Floyd overdosed on opioids, and that's what really happened. But I was wondering, and Eugene, I'll pose this to you first, I was wondering what you thought about how that would play to a jury, because we have had a bit of a social awakening on opioid use. And over the last few years, we've seen that addiction across the country and in so many communities, whether they were affluent or rural communities, and we have a little bit more understanding of it. So I was wondering if you had any takeaways from her testimony last week and how it might play to a jury that has more understanding about that issue.
Well, that is one of the things I think that a lot of people will be paying attention to. Because as you've noted, the past few years, we have seen the conversation change quite a bit in terms of how we discuss substance abuse, specifically related to opioids and addiction. But one of the main complaints is that much of that conversation has centered white working class individuals who are struggling with drug addiction. Not so much black people in urban centers, even though we have data showing that the black communities, urban communities, are struggling with these addictions at rates that are higher than what we are seeing in some of these white working class spaces. And the sympathy has not been reflective of that. But there could be, as we move forward, conversations happening in this trial that help humanize Floyd in ways that, in the past we just haven't seen people who are addicts discussed. And that could move some people to view him differently, especially considering the challenges he experienced growing up, which we've reported at length here in the Washington Post, that can lead to trauma and a desire to medicate that trauma and pain through drugs. And so I do think this could move jurors in ways that perhaps, 10, certainly 20 years ago, we didn't see happening when it came to individuals who were viewed as addicts.
Yeah, thanks for that, Eugene. National reporter Abigail Houseloner joins me now. Abby, good morning, or good afternoon rather, to you. What did we learn today about the condition that George Floyd was in when he arrived at the hospital?
Well, today we heard obviously lengthy testimony from the physician who oversaw Mr. Floyd's treatment once he arrived in the emergency department that night. And he was asked by prosecution to really walk through the details of Mr. Floyd's condition when he came in. And that included sort of the key component of that was that he was in cardiac arrest when he arrived. And not only that, but a specific kind of cardiac arrest that the physician, Dr. Langenfeld, sort of associated with specific, or most typically, asphyxiation, so being deprived of oxygen, or traumatic bleeding, such as internal bleeding or traumatic injury. and not typically associated with a heart attack.
A key part of this trial is George Floyd's cause of death, of course, as you laid out there. Let's listen to a clip where prosecutor Jerry Blackwell questioned Dr. Bradford Langenfeld, the doctor who pronounced the death of George Floyd.
Mr. Floyd was still in PEA, but there was virtually no cardiac activity. And at that point, in the absence of any apparent reversible cause, and because Mr. Floyd had been in arrest for, by this time, 60 minutes, I determined that the likelihood of any meaningful outcome was far below 1%, and that we would not be able to resuscitate Mr. Floyd, and so I then pronounced him dead.
And doctor, was your leading theory then for the cause of Mr. Floyd's cardiac arrest oxygen deficiency?
That was one of the more likely possibilities. I felt that at the time, based on the information I had, it was more likely than the other possibilities.
And doctor, is there another name for death by oxygen deficiency?
Asphyxia is a commonly understood term.
All right, and that was Dr. Langenfeld, who pronounced George Floyd had died, and he testified earlier this morning. Abby, what did Dr. Langenfeld say about signs of excited delirium, and why is that important here?
Right. Well, Dr. Langenfeld was asked about this concept of excited delirium and whether that was one of the considerations that he took, that he considered that as a possible cause of death. And he noted first that that's a controversial cause of death. He mentioned that a couple of times. What excited delirium means essentially is, someone being in a really agitated state. It tends to be caused by either some sort of acute mental crisis or acute drug use. And there are certain signs of it. Dr. Langenfeld, interestingly, mentioned that in his experience as an emergency room physician, paramedics almost always mention that they, signs of excited delirium being present in a patient, when they bring that person in, and that this was not the case this time with Floyd, that they never mentioned any excited delirium, that the doctor, did not see, any of the telltale signs like, sweating, or other things that could have caused it, and that there was just no indication that he was extremely agitated. And the reason why this is so important is that, the defense would certainly benefit in their argument, if there was an indication of excited delirium, because that would lend itself to their argument that Mr. Floyd died as the result of drug use or a drug overdose, as opposed to being asphyxiated or deprived of air because of the knee on his neck.
The defense attorney asked to Dr. Langenfeld about fentanyl and whether anyone administered Narcan. Why is George Floyd's drug use a focus of the defense?
Right. Well, I think the defense is hoping to make, to characterize drug use or the presence of drugs in Mr. Floyd's system as a possible or quite possible cause of death, because if that were the case, obviously that would remove blame from Officer Chauvin's actions. So that is why the defense is hoping to portray drugs as having a leading role in his death in this case.
Now, Abby, I know you've been following today's testimonies. Has there been anything that stood out to you this morning or in the early part of the afternoon, specifically when we've heard from the chief of police there? Anything that stood out to you?
Well, we've heard so far, a really lengthy testimony from the chief of police that actually, as my colleagues mentioned, a little while ago, really hasn't yet gotten into Officer Chauvin and his thinking and his actions that night. What they've been doing so far, what prosecutors have done so far, is really helped lay the foundation of this police chief's background, of his extensive training, of his extensive experience in Minneapolis and in all of the different sectors of the police force. And then also, of course, as my colleagues mentioned, the extensiveness and details of police training and how that might, or how that conflicts with the behavior that we see in these videos from that night.
All right, thank you so much, Abby, for joining us today. I'm going back to James and Eugene here for a moment. James, I know that you're familiar with the lay of the land there in Minneapolis. This police chief, who we will expect to hear from when we return from this lunch break, it also has to deal with potentially what might happen either way this verdict goes. And he also is dealing with what's happening at what's called George Floyd Square, the intersection there where Cup Foods is, and there's a gas station. It's really become sort of a community hub, but you've mentioned to us before that there's been an absence of police presence there.
Yeah, it's essentially a no-go zone for officers. They don't want to escalate. That's been a strategic decision to leave that area. The closest police precinct was actually set ablaze and burned to the ground during the riots last year. A lot of folks from the suburbs are not going into Minneapolis because they're frankly afraid. There is a palpable sense of fear. The crime has skyrocketed in Minneapolis since last summer. The police, partly because they're angry that they feel like they've been singled out, have really pulled back on being aggressive about law enforcement. The economy's in rough shape, so those things combined have sort of emboldened criminal elements to be more aggressive. So it's a scary time in the Twin Cities, and everyone is on edge about potential violence depending on the verdict, and you could have a scenario where maybe Chauvin is convicted of some but not all, including second-degree murder. He doesn't get convicted, perhaps it's a higher standard, and that could still mean that there is mass street action that turns into violence. A lot of business owners very concerned. This could become a dominant political feature in a state that is already very divided between urban and rural Minnesota. The population is split about evenly, and rural and urban Minnesota have often conflicting priorities and interests.
All right, you are watching a Washington Post special report for a landmark day in the trial of Derek Chauvin. One of the most anticipated witnesses, Minneapolis Police Chief Arredondo, will be back in the witness stand just ahead.
Sometimes you have to see to believe. Sometimes waiting isn't an option. When the news is breaking, watch with the newsroom of the Washington Post. We explain what's happening and why it matters. Thank you for choosing to watch the headlines as they're being written with our journalists. You can subscribe with a special offer, an entire year of the Washington Post for $29. Go to WashingtonPost.com/watch. Subscribing through that link lets everyone here, from the front lines to the control room, know that you care about our continued efforts to inform the public, protect the First Amendment, and foster a healthy democracy. We could not do this without you.
We are watching the Hennepin County Courthouse in Minneapolis, Minnesota, where the city's chief of police will resume his testimony momentarily. Eugene, what are you expecting from the cross-examination of this key witness?
Well, I think what we would like to see more of is just an explanation of what it is that is the norm for the police department, and why perhaps sometimes people violate norms, and why they think that the systems that have been put in place perhaps would lead to behaviors or actions that aren't affirmed or ordained even by the police department. That's not something we've heard him talk much about, as much as we've heard him explain what the policies are and what they aren't. And he may not do that, but he certainly has, I think in some ways, tried to communicate some of the challenges that law enforcement find themselves in pretty often that can make their jobs very difficult. And so perhaps providing some more context as to why law enforcement perhaps may feel the need to act out of the norm would, I think, perhaps give some type of insight into why Chauvin behaved the way that he did.
And James, we learned from the chief of police before the lunch period that a lot of training, a lot of resources go into becoming a police officer there in Minneapolis. So when he gets into specifics after this lunch break, what are some things that you're going to be listening to?
Yeah, what I'm going to be listening for is just how far he goes. There was a lot of sparring pre-trial and even this morning about what the chief will kind of be able to say after this incident last year, that week. Not only did he fire Derek Chauvin and the other officers who were there, he said what happened was murder. That was the word he used, murder. Big word, obviously weighted with legal implications. Obviously Chauvin is now on trial for murder. There has been some back and forth about how he's going to be able to characterize it, how the prosecution is going to be able to ask about his views on it. The judge is allowing the chief to offer essentially, not technically, but essentially expert opinion based on the training and based on the expectations. And it's very clear based on, I think we started at 50,000 feet. We sort of moved to 30,000 feet. And now here in this post-lunch period, we're going to get down to, ground level. That night, Memorial Day last year, did Chauvin violate what he was trained to do? And I think we'll hear strong words from the chief, and you could hear a lot of objections. It'll be interesting to see how often Eric Nelson, the defense lawyer, objects because having, this is such a rare moment to have a chief of police testifying against one of his former officers, even when he fired, to have the chief in uniform sitting there saying this officer did something that was unconscionable will certainly have a huge impact on the jury and will undercut a lot of what the defense hopes to make the centerpiece of their arguments.
Yeah, and James, a follow-up to your points there, I was looking on our site and saw one of our colleagues wrote about the chief's testimony so far, and included was a picture from last summer where the chief and another officer there knelt in front of the casket of George Floyd when it was going through the funeral procession. So this is a chief of police who hasn't really wavered in his stance of believing that George Floyd was the victim in this case, and that Chauvin did apply too much force.
Yeah, and he was out there early saying Black Lives Matter. Even though he's been in the force since 1989, he's had a very tense relationship with some of the the police officers union, and so he's a critical witness, key voice. So much credibility there, but he has been publicly very outspoken. The question this afternoon, what I'm going to be watching for, is how outspoken he'll be in the courtroom.
Well, while we are waiting the chief to resume his testimony, we'll go ahead and play a clip of earlier. One focus of Chauvin's defense has been the actions of bystanders who recorded George Floyd's death. Listen to the prosecution ask the chief of police about when bystanders crossed a line.
As you indicated, the policies and culture of the police department has to change with the times. Is that right?
Yes.
And so in terms of understanding that sometimes bystanders do use their smartphones to take video images of police officers, has the Minneapolis Police Department imparted any training or constructed any policies to prepare officers for people recording them?
Yes, we have. We've imparted policy that really is informing officers that individuals under their First Amendment rights, they have the absolute First Amendment right to record through cell phone video or other types of video officers interacting or engaging with a community member, with the exception that they cannot obstruct the activity of the officers, but they absolutely have the right, barring that, to record us performing our duties.
And what does obstruct mean in this context?
Obstruct would mean interfering, doing something where you are physically placing yourself in a position where you're no longer, or you're prohibiting the officers for carrying out their lawful duties. But barring that, individuals have the right to record our engagement with our community.
Well, Chief, you'd have to acknowledge that a patrol officer may find it irritating to have a civilian recording their activities. True?
Very true.
Is that obstruction?
It is not.
All right, so that's the police chief, Arredondo, there, who took the stand earlier. He's expected to return in just about 2 minutes or so when they come back from their lunch break. While we are waiting, James and Eugene, I want to just ask a quick politics question. We've talked about this trial being an opportunity for state legislatures or local municipalities to start working on police reform, and then we've also talked about it at the federal level too. Eugene, I'll start with you. President Biden hasn't said much about any plans that he specifically has for police reform. Do you think he might be missing an opportunity here during this trial to get Congress or the DOJ or somewhere in his federal realm to work on police reform?
Well, I think what the White House would say based on previous reporting is that just because he hasn't been really vocal on it right now, it doesn't mean that they are not working on it. There's certainly other staff members who have prioritized being in relationship or communication, should I say, with Congress to try to move forward some of the ideas that many people on the left have put forward in terms of needing to reform policing. But I do expect him, or at the very least, Vice President Kamala Harris, to make some type of statement towards the end of this trial, regardless of what the verdict is. And there'll be pressure to make that statement go beyond just something on social media or something presented at a press conference, but in policy. There'll certainly be a desire by many people on the left who helped elect Biden and Harris to make sure that even though Biden was not as vocal right now in this moment, that he uses his voice to put forward their agenda moving forward.
And James, we might only have a few seconds left, but I do want you to weigh in on that as well. Is this a missed opportunity for Biden to bring up the issue of federal police reform?
Well, we'll see how much he leans into it. I think right now he wants to get infrastructure done. That is his top priority, and he is being, I think, very pragmatic and cautious that politics is the art of the possible. What I'm watching closely are not just state governments, but local governments, what big cities like Minneapolis around the country are doing, and we are starting to see some very meaningful criminal justice policy overhauls happening at the municipal level, and that shouldn't be overstated.
All right. And for those who are with us, we are waiting for the courtroom to resume the witness testimony of the chief of police there in Minneapolis. The judge, Peter Cahill, often keeps things, he appears to be running a tight ship there and is usually punctual. So we're just awaiting for signs that he has returned and that they will start back up again. But this is, I think we might see him coming back there. Yeah, here we are. So let's go back to the courtroom.
If you could please display and publish Exhibit 219 again. All right, sir, before the break, we were discussing the de-escalation policy. I'd like to now ask whether the actual de-escalation techniques are embedded within the policy itself. And so I'm drawing your attention to, again, Exhibit 219, which is MPD Policy 5-304. And if you take a look at the section here that's been enlarged, de-escalation tactics include but are not limited to. If you would please just summarize for the jury the different bullets that you see here.
Yes, some of the bullets here for de-escalation tactics.
Sir, one moment. Oh. All right. Thank you. All right. Please resume.
Yes, some of the de-escalation tactics that are noted here include but are not limited to placing barriers between an uncooperative subject and an officer, communication from a safe position intended to gain the subject's compliance using verbal persuasion, advisements, or warnings, using verbal techniques to calm an agitated subject and promote rational decision-making, calling for additional resources to assist, including more officers, CIT officers, and officers equipped with less lethal tools.
And CIT officers are those who've been through the crisis intervention training course, is that correct?
That is correct.
And are Minneapolis police officers then at the training center taught different techniques on how to implement this policy?
That is correct.
Have you personally attended the training?
Yes, I have.
Did you find it useful?
I have.
And then you could remove that. We've talked a little bit then about behavioral crises and identifying behavioral crises. How does the Minneapolis Police Department respond to persons in a behavioral crisis?
One of the first important things is obviously is trying to get as much information prior to the call as possible. But as soon as officers at least have knowledge that this could be a potential situation with that caller, this de-escalation piece should kick in. And that they, while they may not know exactly what they're going to encounter when they arrive on the scene, this body of knowledge that they've been taught should at least be kind of forefront in terms of the different tools that they'll be using possibly to help de-escalate that situation.
What is an EDP? What is that acronym?
The acronym EDP is labeled through our Minneapolis Emergency Communications Center as a emotionally disturbed person. And so when our Minneapolis police officers receive a EDP call, that is prompting them that there's at least initial information that they're going to be responding to someone who may be in crisis.
And that's something that the officer would then be communicated by a dispatcher prior to going to the scene, correct?
That is correct.
However, when if that information is not imparted upon them, they make their own assessment at the scene as to whether the person could potentially be an EDP. Is that correct?
That is correct.
You indicated that the Minneapolis Police Department receives over 100,000 calls a year, calls for service. Is that right?
Yes.
Do you have an idea of how many calls for service involve people in crisis?
I believe in 2019, Minneapolis police officers responded to about 4,500 of those signified as EDP calls. Yes.
Now, in terms of teaching officers how to recognize a person who may potentially be in crisis and therefore unable to comply with commands, you place these different signs into MPD policy.
That is correct.
And I'd like to direct your attention now to Exhibit 231 and ask that to be published. And this is 7-809, the crisis intervention policy. You say it begins here. Oops, sorry. But we'll go ahead and over to page 2. And I'd like to highlight, please, for the jury, the definition of a crisis. And again, in the definition of a crisis under MPD policy, generally speaking, we're talking about some of the same things that we saw before in the de-escalation policy. Is that right?
That is correct.
There can be mental illness. Is that right?
Yes.
Substance abuse can be a crisis or a barrier to communication, correct?
Yes.
And same with various stressors. Is that right?
Yes.
And then further, if you can emphasize the crisis intervention definition. And officers, when they either respond to an EDP call or are aware that the person may be in crisis, and attempt a crisis intervention method. Is that correct?
Yes.
And generally speaking, what is the officer supposed to do to a person in crisis?
It's an attempt to de-escalate that situation.
And the policy then of the Minneapolis Police Department in handling persons in crisis, if we could look at section 3 of the policy, would be the next page. Highlight Roman 3. Okay, in accordance with the Minneapolis Police Departmental policy, what are officers supposed to do? How are they supposed to handle encounters with individuals who are experiencing a crisis?
We really want to, again, we want to meet people where they are. We want to bring our values and our principles to those situations. We recognize that oftentimes people who are experiencing crisis, it is not something that they brought on themselves, but they're dealing with. And so there's a sense of dignity and respect that we should be honoring when we come to those calls. And so, as it's mentioned here, the values of protection, safety, and sanctity of life. Oftentimes, again, we are that first face of government that they're going to see. That may be 3 o'clock in the morning. And so we have to wear many hats, but we want to be respectful in that care that we're trying to provide for that individual.
And sometimes persons might be experiencing some sort of a breakdown that, you know, maybe they did partially bring upon themselves. Is that right?
That is correct.
And are those people still entitled to be treated in accordance with MPD policy?
Yes, they are.
And this policy, again, is imparted in training at the training center by that group. Is that right?
That is correct.
Now, I'd like to, if you could take that down, please, talk to you a little bit about officers' role as first responders in terms of providing basic medical care. All right? And so with that, can you tell the jury, are Minneapolis police officers trained to provide basic medical care?
Yes, we are.
Can you please describe what level? I'm aware there are various different levels of medical care that someone could be trained in.
So most of department members will have at least basic training in terms of first responder, the ABCs, airway, breathing, circulation, the effects of applying direct pressure on wounds to stop bleeding. Many of the things that we will respond to, perhaps just because we're closer to a call than perhaps our EMS or our fire before they get there, and they obviously have a higher degree level of training. But the training that we have and that we receive, it's very vital because those seconds are vital. Our officers carry tourniquets. We respond to situations where members in our community will have gunshot wounds. And matter of fact, a couple of my officers a couple of weeks ago saved a young man who was shot in the femur and was bleeding profusely, but because they got there quickly, knew how to apply that tourniquet. Those are some of the basics. Baby not breathing calls. Our officers have saved the lives of children who've choked or what have you because they've applied or they've been able to help start emergency breathing for them. So those are some of the basic types of first aid that are chest compressions, those types of basic first aid. Yes.
And are officers then, specifically trained at the training center to provide this basic sort of first aid?
That is correct.
And does the Minneapolis Police Department have a policy regarding any duty that an officer would have to apply that training to a real life situation?
Yes. We recognize, again, I mentioned that we are oftentimes going to be the first ones to respond to someone who needs medical attention, and so we absolutely have a duty to render that aid.
And that, of course, is in the policy and procedure manual, is that right?
Yes.
If I can display Exhibit 230, which is MPD Policy 7-350. Emergency medical response. And under Roman 1, you see that the purpose of the policy is to lay out in writing the roles and responsibilities of Minneapolis Police Department employees in incidents involving a medical emergency. Is that right?
Yes.
If we could take a look at the policy itself under Roman 2, does that explain what a Minneapolis police officer is supposed to do when they come upon a medical emergency or a medical emergency develops on a call?
Yes.
What are they supposed to do?
While awaiting EMS, MPD employees assisting an individual having an acute medical crisis shall provide any necessary first aid consistent with our MPD training as soon as practical.
And so then that presumes, of course, they're waiting for EMS or waiting for some kind of emergency services. Is that right?
That is correct.
So would it be fair to say that this policy then is in two parts? The officer has to request EMS or an ambulance, correct?
Yes.
And while waiting for the ambulance, they're required to provide what medical training and skills they have to attempt to save the person.
That is correct.
Are Minneapolis police officers provided naloxone or Narcan kits?
Yes, we are.
What are those?
It is basically a inhaler for community members who we may respond to have overdosed. It is to, if they've overdosed and are out, it is to give them that inhaler injection so that they can hopefully come to. And so it was a few years ago where, for the most part, our Minneapolis Fire Department were the ones that responded to overdose and carried the Narcan. Unfortunately, in our cities across the country saw an uptick in heroin and opioid overdoses. We had to make sure that we were, again, because we were oftentimes the first ones to come across these situations, we wanted to make sure that we were in service to our communities and making sure that if we could save lives, that we were equipping our folks with Narcan.
And a policy developed as a result of this, is that right?
That is correct.
If I can show you Exhibit 229, it's published that. Is this the Narcan policy 7-348?
That is correct, yes.
And our officers provided training in the administration of Narcan?
Yes.
Under appropriate circumstances?
Yes.
Okay. And now I'd like to talk to you a little bit about the use of force. Does Minneapolis have a written policy governing proper and authorized use of force?
Yes, we do.
Okay. And is this generally covered in the 5-300 series of the Policy and Procedure Manual?
Yes, it is.
I'd like to discuss some of that manual with you and the policy with you at this time. If we could pull and display Exhibit 216. Under the purpose of the policy, which is 5-301, can you please read the first sentence under subparagraph A?
Yes. Sanctity of life and the protection of the public shall be the cornerstones of the MPD's use of force policy.
What does that mean?
Of all the things that we do as peace officers for the Minneapolis Police Department, and I mentioned the thousands of calls that our men and women respond to, it is my firm belief that the one singular incident we will be judged forever on will be our use of force. And so while it is absolutely imperative that our officers go home at the end of their shift, we want to make sure and ensure that our community members go home too. And so sanctity of life is absolutely vital, that is the pillar for our use of force.
Has this generally always been the case with Minneapolis use of force policy?
It is not.
When did that change?
We implemented this particular in 2016.
Has the training and use of force and application of use of force policy been imparted, including this philosophy, onto police officers in training at the training center?
It certainly has, yes.
Does the policy itself define force? What is force?
Yes, it does.
If we can take a look at Exhibit 217, I'll publish that. If you'd highlight use of force. Generally speaking, what is force?
It can be any physical contact. It can be with a weapon. It could be with a vehicle. But it's any sort of physical contact that is more likely to render harm or injury to someone.
Is the use of restraint considered force?
That would be considered force.
And what type of force is authorized under departmental policy?
We under 609, we operate under the use of force, the Graham v. Connor statute, objectively reasonable force.
And if I could display Exhibit 217. Let's see. First, go back to 5-303. 5-303 authorizes force, is that right? And you mentioned 60906, state statute authorizing force under certain circumstances, is that right?
Yes.
And the phrase that's used for the authorization of force is what type of force?
Reasonable.
And that force can be authorized under certain circumstances, is that right?
Yes.
All right. So now if you would go to the next page, and let's talk about the circumstances under which a police officer is authorized properly to use force. If you highlight that. What are the circumstances under which an officer is authorized to use force?
An officer is authorized to use force effecting a lawful arrest, executing a legal process, enforcing an order of the court, and any other duties imposed upon that officer.
And that term reasonable force is further delineated in the policy, is that right?
Yes.
If we take a look at Exhibit 217, I believe under the definition, objectively reasonable force. Could you please read that definition?
Yes. The amount and type of force that would be considered rational and logical to an objective officer on the scene, supported by facts and circumstances known to an officer at the time the force was used.
Oh, you discussed a case, the Connor, right? The Connor factors. And I'd like you to, well, first of all, does the policy reference the Connor factors that you just mentioned?
Yes.
If you could display 217, page 2. Okay. And we have 3 bullet points here under the Connor factors. And that is the officer is supposed to look at the totality of the circumstances, right?
Yes.
And the 3 bullets here that the officer is supposed to consider are what?
The officer should consider the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. And
fair to say these 3 different considerations are things that you can attribute to the subject, correct?
Yes.
That's the subject's conduct, not someone else's.
Yes.
And of course, it has to be judged by a reasonable police officer on the scene at the time, correct?
Yes.
Now, do you recall, and obviously you're here talking about what happened on May 25, 2020, involving George Floyd. Do you recall why the officers were responding to cup foods on that date? The original reason for the call?
The original reason for the call was a response regarding a counterfeit situation at the store at the intersection of 38th and Chicago.
And in terms of the deployment of your resources at the Minneapolis Police Department and as chief, how do you rate, I guess, the severity of that offense, the seriousness of that offense?
It would probably not rise to the level of, and particularly in light of last year, the level of violent crime that we've experienced in the city, but We would certainly respond to it, but it would not rise to the level in terms of severity of the crime here.
In looking at the particular type of crime, is that one for which a suspect is typically taken into a custodial arrest?
Typically not.
And why is that?
If it's not a violent felony, we also, in coordination with our jail system and our courts, there's been a shift over the years to make sure that the individuals who are going to jail are those who, from a public safety standpoint, need to be at least in that facility in the Hennepin County Jail. And if we can properly identify and it's not a violent situation, we can always charge via complaint and other things. And so that's one of the reasons why.
You use the phrase, I guess, violent felony. What's the more important part, whether it's violent or whether it's a felony?
Oh, violence.
Why is that?
Well, it can certainly endanger not only the officers but the community.
Where something that's merely labeled a felony may or may not require a full custodial arrest.
That is correct.
And are Minneapolis police officers trained in the use of force?
Yes.
In pre-service, in the academy, and also in post-service at the in-service training?
Yes.
And are officers taught the standard that force must be reasonable at the time it is applied?
Yes.
The entire time it's applied?
Yes.
Are officers taught the need to assess and reassess and reevaluate situations in the field?
Yes, we are.
Are you familiar with Minneapolis Police Department's critical thinking model?
Yes.
How are you familiar with that?
It was something that I wanted to embark and make sure that it was part of our training curriculum that also includes the aspects of procedural justice. And procedural justice is really, it's actually research and evidence-based learning that has shown that if police departments treat people with respect, give them voice, establish neutral engagements, and build areas of trust, our communities are more likely to cooperate with us. We're likely to be seen more as legitimate. It is actually shown that our employees come to work, their wellness is better, and so this is very important work. And so it's part of that procedural justice I just mentioned, is part of that critical thinking in our training.
At this time, I'd ask to display only to the witness exhibit for identification 276. Sir, do you recognize exhibit 276 as being MPD's critical decision-making model?
Yes.
Offer exhibit 276.
Any objection? 276 is received.
Permission to publish. So we heard about the model, now we get to actually see it. And if you could enlarge the graphic, please. All right, so this is what the model looks like. It's sort of a wheel, is that right?
Yes.
And the first stage of the critical thinking model, or decision-making model, is information gathering.
Yes.
Explain that, please.
It's very vital. We rely upon trying to gather as much information as possible so that we can try our best to effectively go in, respond, and manage that situation. Trying to gather as much information at the onset is very important, but we also need to make sure that we're continuing to try to gather as much information as we're dealing with the scene or the call.
I see the arrow points in two directions, and one, it points to the middle of the circle, voice, neutrality, respect, and trust, and the other arrow points to the threat or risk assessment. Let's talk about the middle of the circle first. Right? What is that middle circle supposed to be representing?
Well, that's the principles, really, of what continues to guide us. So, for example, information gathering, while we may associate it specifically with receiving a 911 call, and the dispatcher giving us information, but information gathering could be that officers come across a call that they weren't dispatched to, and they need to talk to a community member. If they don't treat that community member with respect or give them voice, it's likely that they will receive less information that will be less helpful in them resolving that call. So that voice, neutrality, respect, and trust, that has to guide and be a part of all of that critical decision-making model.
So let's go to the next step. The officers gathered some initial information, and now the officer is in a position to need to think about it or assess it. Is that right?
Yes.
And so the next step is the threat or risk assessment. Is there a difference between a threat and a risk?
There can be in terms of what is being played out at the time. And you're constantly evaluating that, and of course the information that you're receiving, which may be fluid, is going to dictate that threat or risk. Yes.
And so then once the officer has made an assessment of a threat or a risk, the next step, authority to act, what does that mean?
That may mean the officer now, based upon that the information that they've received, evaluating that threat or risk, am I going to act? Is this going to be a physical arrest? Am I going to separate parties? Does this require a report? All of these things. So, but it's giving more information for the officer to guide he or she in terms of what is the next appropriate step they need to act and take.
And so if we were to, at least to this point in the model, put a scenario into action, information gathering, the officer perceives that someone is approaching them with a weapon, like a bat, right? And so then they would reflect on that and determine whether or not this is a risk. It's a bat, maybe the person is at a baseball game, or a threat. The bat is being brandished, correct?
Yes.
Then after that, under authority to act, if they've determined that this in fact is a risk and that they're being threatened, they would look at the authority back to the MPD policy and procedural manual. Is that right?
Yes.
Under what is the use of force policy, what tools are available to me to respond here?
Yes.
Right? The next step then, after considering the authority to act, goals and actions. What is that?
The goals. The officer is making an assessment. So with the authority to act, will an arrest resolve this situation? Will separating the two parties be enough? Is taking a report, will that be enough of a goal or an action? It may mean a combination of things. It may mean that I'm going to have to, or the officers are going to have to make an arrest, but we may need additional resources here because the situation is still could have the potential to not be stabilized. And so all of that is part of that goals and action.
And then to review and reassess, assuming that means exactly what it says.
Exactly, yes. And information is going to flow, dynamics can change, and so it can be a constant just review and reassess the situation to make sure that we're trying to get to the best possible outcome in this peacefully and safely.
Because circumstances can change, the situation can change, correct?
Yes.
And force that might be appropriate at one moment might not be appropriate at a different moment, or more force might be needed at yet another point. Is that right?
Yes.
This particular critical thinking model, Exhibit 276, we see examples of this throughout training materials that are provided by the trainers at the facility. Is that right?
Yes.
And why is that?
It's to really embed that knowledge that we don't want to fall susceptible to kind of check the box training. This training is important for all of our officers to have a knowledge and understanding of, and that our community members can expect this to be consistent as they have encounters or engagements with our officers.
All right. If we could take that down, please. And I want to shift a little bit to talk about, we've talked about use of force and the policy. Does Minneapolis Police Department train its officers in specific defensive tactics?
Yes.
And where does that training occur?
That training occurs at our Special Operations Center.
And does the department provide training for officers in handling uncooperative individuals?
Yes.
Does the department provide training for handcuffing reluctant suspects?
Yes.
And when you provide the training, you're assuming you're taking someone into custody. Do you also teach officers their responsibilities, their personal responsibility with respect to the person they've just taken into custody?
Yes, we do.
And what responsibility does an officer have to a person they've taken into custody or restrained?
So the American policing profession, which I believe is the best in the world, and I will tell you why, and it's really two reasons.
Rephrase your question.
Yes, Your Honor. Sir, you have a responsibility, I guess, and that's imparted throughout officers in various forms of training as to what, once someone is in their custody.
Oh, yes. We have a duty of care. And so when someone is in our custody, regardless if they're a suspect, we have an obligation to make sure that we provide for their care.
Does that include people to whom defensive tactics are being applied?
Yes.
Why is that?
They are still in our custody, and they have rights. And the humanity of this profession, we need to make sure that we're taking care of them.
So how often are officers required to participate in defensive tactics training?
It's usually a yearly annual training.
Do you know that, when we're talking about the training and policies in effect on May 25, 2020, were neck restraints and chokeholds taught and authorized by MPD policy at the time?
At that time, yes.
And they were taught pursuant to the defensive tactics training as well?
Yes.
At this time, I'd like to publish Exhibit 224. Exhibit 224 showing MPD policy 5-311, use of restraints, neck restraints and chokeholds. You see a chokehold is considered a deadly force option, is that right?
Yes.
Okay. If you could go to the next page, please. Neck restraint, if you could highlight that portion from that down to unconscious neck restraint. Okay. There are various types of neck restraints that were authorized at the time, is that right?
Yes.
And neck restraint was defined as compressing one or both sides of a person's neck with an arm or a leg, is that right?
Yes.
But without applying any direct pressure to the trachea, the airway that needs to be protected?
Yes.
Right. And there were two types of neck restraints that were authorized: conscious neck restraint and unconscious neck restraint.
Yes.
And the objective of the unconscious neck restraint, the second one, would be to have the person actually pass out.
That is correct.
And under certain circumstances in which the officer was in fear of grave bodily harm or death, that would be authorized. Is that right?
Yes.
And conscious neck restraints were more with the neck restraint with the intent to control but not to render the subject unconscious. Is that right?
Yes.
By applying light to moderate pressure. Is that right?
That is correct, yes.
And if you could go to Roman 2 on the same policy, highlight that. Okay. Conscious neck restraint can be used for someone who is actively resisting, correct?
Yes.
And an unconscious neck restraint could be used for a person who is exhibiting active aggression or to save a person's life. Is that right?
Yes.
Okay. Or in a subject who is exhibiting active resistance if lesser attempts would have or would likely to be ineffective. Is that right?
Yes.
But neck restraints were not to be used against persons who were merely passively resisting, correct?
That is correct.
All right. Now I'd like to draw your attention to May 25, 2020. Can you tell the jury when you first learned of the incident involving the defendant, officers Tao, Lane, and King, and George Floyd?
On Monday evening, around 9 p.m., back on May 25th, 2020, I received a call. I was at my residence, and I received a call from one of my, I believe it was a deputy chief, who had informed me that Minneapolis police officers had responded to 38th in Chicago, and while attempting to take someone into custody, that, which I learned now to be Mr. Floyd, they believed that he would not make it or survive. And so he was being transported via ambulance to, at that time, Hennepin County Medical Center. And while, at least the information I had that evening at 9 p.m., he at that time at least was, I was told, was still alive, I decided to contact the Minnesota Bureau of Criminal Apprehension. And they are a state agency that conducts our critical incidents. I deemed that this would be a critical incident, and it has been our protocol to alert them, and they would conduct that investigation. So I made that call to the BCA to have them start to conduct this critical incident.
Did you then proceed to City Hall?
I should also say that I, right after that call, I notified Minneapolis Mayor Jacob Fry to say that this is a situation we have at least right now, and that I would brief him as I received more information. I then proceeded to leave my residence, and I went directly to my office in City Hall.
When you arrived at City Hall, do you recall seeing any video images or footage of this event?
The first time that I saw a video of the event was after I was notified that Mr. Floyd was now deceased. And so I had asked my deputy chief to pull up what knowing the area really well and knowing that there's usually a camera, a city-owned camera at that location, I asked him to locate that video so that I could review it.
Okay. And that's what we would refer to as the milestone camera or milestone footage?
That is correct.
Okay. Did you watch the footage from the milestone camera that evening?
I did watch that.
Okay. Can you describe for the jury what you saw when you watched the footage?
When I first viewed this milestone video, what I was able to see, and I should just note that it was from a distance from where the officers were with Mr. Floyd, and so all I could really see were the back sides of the officers. There was also no audio to this milestone video, and so I viewed that video in its entirety, and quite frankly, there was really nothing in terms of the actions of at least, again, this non-audio video that really jumped out at me. After a few minutes, it seemed, a paramedics vehicle pulled up to the scene, and it was at that time, for the first time, that I saw a glimpse of Mr. Floyd when paramedics placed his body on the gurney and transported him away from the scene. But that was really my first observation of that incident from that night.
At some point, did you become aware of another video that had been taken by a bystander?
Yes. Probably close to midnight, a community member had contacted me and said, Chief, almost verbatim, but said, Chief, have you seen the video of your officer choking and killing that man at 38th and Chicago? And so once I heard that statement, I just knew it wasn't the same milestone camera video that I had saw. And eventually, within minutes after that, I saw for the first time what is now known as the bystander video.
Fair to say that this was a much closer video and it had audio?
Yes, this I was able to see the occurrence, see the officers involved. I was able to actually see Mr. Floyd. I was actually able to hear what was occurring, and I was also able to get a better understanding of the length of time, the duration of the call, the incident. Yes.
Now, prior to testifying today, have you now reviewed the bystander video, Facebook video in its entirety?
Yes, I have.
You've also reviewed and reviewed milestone footage?
Yes, I have.
And have you reviewed the body-worn camera footage worn by officers Tao, King, Lane, and the defendant?
Yes, I have.
Now, first, I want to show you what's been received as Exhibit 17. Do you recognize Exhibit 17 to be an image taken from the bystander video that you reviewed?
Yes, I do.
Now, sir, based upon your review of all of the information that you just mentioned, do you believe that the defendant followed Departmental Policy 5-304 regarding de-escalation?
I absolutely do not agree with that.
And how so?
That action is not de-escalation. And when we talk about the framework of our sanctity of life, and when we talk about the principles and values that we have, that action goes contrary to what we're taught.
As you reflect on Exhibit 17, I must ask you, is this a trained Minneapolis Police Department defensive tactics technique?
It is not.
Well, we read the departmental policy on neck restraints. Is this a neck restraint?
The conscious neck restraint by policy mentions light to moderate pressure. When I look at Exhibit 17, and when I look at the facial expression of Mr. Floyd, that does not appear in any way, shape, or form that is light to moderate pressure.
So is it your belief then that this particular form of restraint, if that's what we'll call it, in fact violates departmental policy?
I absolutely agree that violates our policy.
Are you aware now that the defendant maintained this position on George Floyd for 9 minutes and 29 seconds?
I am aware of that.
I believe you testified that force has to be reasonable when it's applied at the beginning and through the entire encounter. Is that right?
That is correct.
Is what you see in Exhibit 17, in your opinion, within Minneapolis Police Departmental Policy 5-300, authorizing the use of reasonable force?
It is not.
And why not?
That is it has to be objectively reasonable. We have to take into account the circumstances, information, the threat to the officer, the threat to others, and the severity of that. So that is not part of our policy. That is not what we teach, and that should be condoned.
When do you believe or do you have a belief as to when this restraint, the restraint on the ground that you viewed, should have stopped?
Once Mr. Floyd, and this is based on my viewing of the videos, once Mr. Floyd had stopped resisting, and certainly once he was in distress and trying to verbalize that, that should have stopped. There's an initial reasonableness in trying to just get him under control in the first few seconds, but once there was no longer any resistance, and clearly when Mr. Floyd was no longer responsive and even motionless, to continue to apply that level of force to a person proned out, handcuffed behind their back, that in no way, shape, or form is anything that is by policy. It is not part of our training, and it is certainly not part of our ethics or our values.
Sir, based on your review of the video and based on your own experience and training as an MPD officer, did you see signs during the encounter that Mr. Floyd was exhibiting indicia of being in medical distress?
Yes. Yes.
And you saw at one point, I think you just testified, that Mr. Floyd was unresponsive.
That is correct.
And that officers, were you aware that officers couldn't find a pulse?
Could you repeat that, sir?
And were you aware that officers at the time of the restraint were unable to find a pulse?
Yes, I was aware of that.
And so stated.
I was aware that the officers were not able to find a pulse, yes.
Did you see the defendant or any of the officers attempt to provide first aid to Mr. Floyd?
I did not see any of the defendants try to attempt to provide first aid to Mr. Floyd.
The defendant did not try CPR. He did not start chest compressions.
Objection, argumentative, and leading.
Sustained is leading, rephrase.
Did you see them provide any medical attention?
I did not.
Then based on these observations, do you have an opinion as to whether the defendant violated MPD departmental policy 7-350 by failing to render aid to Mr. Floyd?
I agree that the defendant violated our policy in terms of rendering aid.
Thank you. I have no further questions at this time, Your Honor. If you could please take me.
Mr. Nelson. You may.
Good afternoon, Chief Arredondo.
Good afternoon, Counselor.
Thank you for being here this afternoon and this morning.
Thank you.
A few follow-up questions for you regarding this incident. Your determinations today are in reference to employment policies and Mr. Chauvin's actions violating the departmental employment policies, correct?
That is correct.
Now, as the police chief, I assume that you're not out on the street day-to-day arresting people.
That is correct.
Can you just give me a general sense, when's the last time that you've actually, I don't mean to be dismissive, but actually arrested a suspect?
It's been many years, sir.
Yeah.
Yes.
Your role as the Minneapolis Police Chief is sort of grander in its scope, right? I mean,
it's large in context and the operations of the department, yes.
And part of that job is to be sort of aware of issues in policing, kind of policy changes, use of force changes. All of these things fall under the umbrella of your role as the chief. Agreed?
Yes.
And you're sort of the general in a sense, right? Formulating the plan for your police department.
And delegating some of those to our subject matter experts, yes.
Correct. When you talk about training of a police officer, you would also include the training that the Minneapolis Police Department goes through, but you may go to other trainings out of state, listen to speakers talking about issues that confront policing, right?
Yes.
As well as maybe a homicide detective will get permission to travel to an interviewing a suspect type of a training in some other state or location, right?
Yes.
And so there is a variability within the training depending upon your role as in the police department, right?
Yes.
So that you've got sort of your rank and file basic patrol officers, and they go through all of the trainings that you've described, the defensive tactics, medical assistance or basic medical training, crisis intervention, things that we've been talking about here today, right?
Yes.
And then the investigative type officers, they may go to some they have to go through that training, but they may go through some additional training in terms of how to interview suspects or how to properly collect evidence, etc., unique to their role, right?
Yes.
And then you as the police chief or those who are in the more management or administrative side of the police department, you go to the kind of the big picture training sometimes.
That's correct.
All right. So I want to review with you a few of the policies that we've already talked about today. If we could take this down for the moment, Your Honor. First of all, I'd like to show you what has been introduced as Exhibit 216, which is the use of force policy for the City of Minneapolis Police Department.
Yes.
We've discussed this. And I know that kind of what we did a little earlier is we kind of jumped around from part to part, but I'd like to walk through some of these issues in a little bit more linear fashion, if we could. So you've described under policy 5-301.01 that the Fourth Amendment's reasonableness standard applies to the use of force in Minneapolis, of the Minneapolis Police Department. Agreed?
Yes.
And that goes on to say that MPD employees shall only use the amount of force that is objectively reasonable, and it continues, in light of the facts and circumstances known to that employee at the time the force is used. Correct?
Yes.
So the reasonableness standard, or the objectively reasonable standard, applies to the facts and circumstances that are known by the officer at the time the force is being used. Correct?
Yes.
Now, 5-302 gives some definitions in terms of the use of force, and it differentiates between active aggression and active resistance. Can you describe the difference between active aggression and active resistance?
Active aggression, behavior initiated by the subject that may or may not be in response to police efforts to bring the person into custody or control. The active aggression, when presenting behaviors that constitute an assault, or in the circumstances reasonably indicate that an assault or an injury to any person is likely to occur at any moment. That's for active aggression.
Yep, let me just stop you there. That's active aggression. So that's where a suspect is essentially fighting with a police officer or doing something that is aggressive, behaviorally speaking. Agreed?
Yes.
And that is aggressive in its nature.
Yes.
Now, can you read active resistance?
Active resistance is a response to police efforts to bring a person into custody or control for detainment or arrest. Subject engages in active resistance when engaging in physical actions or verbal behavior reflecting an intention to make it more difficult for officers to achieve actual physical control.
So essentially what we're talking about here is behavior that may or may not be physical in its nature that simply makes it harder for an officer to take a person into custody. Agreed?
Yes.
And sometimes that is maybe not trying to punch the officer, but pulling away or hiding his arms or doing something that just makes it more difficult physically, right?
Yes.
And sometimes it's, you're not going to take me alive, you dirty cop, you know, like they're saying something to prevent the officer from arresting,
yes.
right? So they're using their words, they're using their behaviors. Is it common, based upon your experience, for people to enjoy being taken into custody? Do people like to be arrested?
Typically not.
Right. And in your experience, is it common practice for people whom are being arrested to say things in an effort to try to get the officer to not arrest them?
That certainly occurs, yes.
Right. My mom is homesick, I need to get home to my kids. There may be words that they use to try to convince an officer to not arrest them, right?
Yes.
Now, you would also agree that there is a difference between being arrested and being detained. Agreed?
There can be,
right.
Yes.
So an officer in certain circumstances is permitted to expand the scope of the original intervention. Would you agree with that?
Objection.
You can restate.
Let me try. When an officer approaches a situation, and let's assume it's a relatively minor offense, is it possible that that minor offense can grow in its scope of investigation?
Yes.
And it's actually quite common for that to happen, correct?
Yes.
An officer makes a traffic stop for speeding or something like that, smells drugs in the car, searches the car, finds a large amount of drugs, finds guns, etc., right?
Yes.
So what starts out as a relatively minor incident, a traffic ticket, can turn into a felony arrest, correct?
It could.
And that, again, happens quite regularly.
Yes.
So when an officer, well, let me back up a second. You would agree that being a police officer is a pretty dangerous profession.
There are inherent dangers with it.
I've never had to get in a fight with anybody in my life, in my job, right? But in your job, it's probably more probable that that will happen. Would you agree with that? Now, talking about the use of force, when an officer approaches a motor vehicle, is that considered to be one of the most dangerous initiations of contact between an officer and a citizen?
I don't have the exact statistics on it. It's certainly an encounter that officers are certainly more heightened. I know that domestic response calls can also have a sense of heightened awareness for officers, but it's certainly something, a traffic stop certainly raises an awareness for officers, yes, for their safety.
And that's because that's that suspect's sort of space, right? The officer doesn't know what's in the car or in the apartment during a domestic situation. You're walking into someone else's territory, so to speak, right?
Yes.
Right. And so there could be guns, there could be knives, there could be any number of instruments that could bring harm to a police officer, right?
There's that potential.
Now, obviously, there's tens of thousands of traffic stops, and there's not every traffic stop turns violent. I'm not suggesting that, but that does happen regularly. Agreed? That traffic stops turn violent.
Yes, they can.
So, when we're talking about the use of force policy under 5-301.01, the last sentence that wasn't read before is the force used shall be consistent with current MPD training. Agreed?
Yes.
Now there's a difference between a policy change and like a best practice change. Would you agree with that?
Can you clarify?
Sure. So there are certain times where the policy, it's with respect to the use of force, may specifically change to prohibit a particular style or use of force, right?
Yes.
So thinking about in the old days, officers used to wear like weighted gloves to make their punches more effective, right?
Yes.
The policy changed and prohibited that, correct?
Yes.
And then there's a difference between, say, the evolution of defensive tactics. Would you agree with that? I mean, the defensive tactics training you received in 1989 is much different than the defensive tactics training that's taught now, right?
Yes.
And I believe it was maybe 15 years ago that the Minneapolis Police Department started moving towards more body weight control, sort of this jujitsu training, as opposed to physically striking people to gain compliance.
And are you referencing policy or training?
Training.
I believe so.
About 10, 15 years ago, agreed?
Yes.
And that was sort of highlighting the evolution, as you kind of described it in your direct examination, of policing since you've become a police officer. That's
Yes.
one way it's evolved.
Yes.
And when something changes per policy, can't wear weighted gloves anymore, for example, that's it, no more. Agreed?
Yes, I agree, yes.
But if the policy, if training, for example, evolves into a best practice, it doesn't prevent an officer from learning a technique he learned earlier in his career. It just may not be the best practice anymore.
So I pause just to, when you say that they're learning something, but if it's not in alignment with our policy, then that would not be prohibited, if I'm hearing you correctly.
Let me try to explain. Like, so if an officer was trained in a particular handcuffing technique, and then they go to their defensive tactics training and they say, this is a better way to handcuff a suspect, it's not a policy change, it's just a best practice change. And they can still use the old way they did it.
It would, Counselor, it would have to be something that the training staff would have to, not just an officer saying, I want to do it this way, and I mean, it's something that would have to be authorized through our training staff. Yes.
So we could talk about that kind of thing with the training, the use of force defensive tactics training, right? That would be the better place to talk, better people to talk to about that?
Yes, yes.
Okay. All right. Now, when we're talking about active aggression and active resistance, sometimes those two things are happening simultaneously. Agreed?
It can be, yes.
Go back to... So now we were talking then about, again, the Graham versus Connor case and how that is incorporated into the Minneapolis Police Department policy. And I'm showing you Exhibit 217 now. It should be up in front of you. What we're basically talking about was a United States Supreme Court decision that outlined the objectively reasonable use of force standard, right?
Yes.
And Graham versus Connor is not limited to those three factors that you were read before, right? The Graham versus Connor analysis.
Yes, correct.
Those are three that are kind of listed, but ultimately it's not an all-inclusive list of considerations for the reasonableness of the use of force. Agreed?
That would be my understanding, yes.
And in fact, what the policy reads is that the reasonableness of a particular use of force must be judged from the perspective of the reasonable officer on the scene rather than with the 2020 vision of hindsight, right?
Yes.
So we're looking at it in the instant and the moment based upon the objective standard, right?
Yes.
Now the policy also includes that the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation, right?
Yes.
And that's because when officers go to a situation, kind of like what we talked about before, what can be initially very minor can grow into something major. Agreed?
Yes.
Now to show you Exhibit 219. You read a part of 5-304, which is threatening the use of force and de-escalation. And I want to talk to you a little bit about de-escalation. Have you heard the term, sometimes you have to escalate to de-escalate? You ever heard that phrase?
I have not heard that.
Okay. So in here you talk about, or the policy talks about, that officers shall consider verbally announcing their intent to use force, including displaying an authorized weapon as a threat of force, right? So sometimes an officer has to take out his gun, say, hey, I mean, that's a use of force in that instance, right?
Yes.
And if you don't listen to me, I'm going to use force. It's a pretty clear indication that force could be used when you have a gun pointing at you. Would you agree with that?
Yes.
But other things such as chemical irritants or tasers, it's not limited to just a firearm, right?
Yes.
And so sometimes what an officer has to do is command the presence, right? They have to take control of the situation.
Yes.
And sometimes that's not particularly attractive, is it?
Could you explain?
Sure. The use of force is not something that people like to watch generally, right?
Objection, speculation, and argument.
Sustained.
Would you agree that the use of force is not an attractive notion?
I would say that use of force is something that most officers would rather not use. Yes.
Right. And you described in your direct examination how the single greatest way that the Minneapolis Police Department could be judged is based upon how the public perceives its use of force.
Yes.
Right? So it has a tendency to garner a lot of attention.
It can.
So much so that citizens have become more prone to record observed interactions with police, right?
Yes.
Something that you didn't have to deal with back in 1989, right?
Yes.
So essentially what this policy 5-304 in terms of threatening the use of force, it's contained within this de-escalation concept, right? So sometimes you have to display a weapon to gain command so that you can de-escalate, right?
Yes.
Now, when we're talking about, is it fair to say that pretty much every single one of these use of force of policies contains some phrase, if reasonable or if practical? There's limitations on the use of force, right?
Yes, there are limitations, yes.
And it's situation by situation, right?
Yes.
And then again, if we go back and look at the language of the Graham versus Connor and the policy that's contained by Minneapolis Police Department, it's the use of force has no precise, objective, singular rule. It's different in every case.
Yes.
So for example, in the de-escalation policy 5-304B1, de-escalation is advisable when it is safe and feasible, correct?
Yes.
And sometimes de-escalation, again, includes the use of force, right? The use of force can be a de-escalation tactic.
Counselor, I was thinking of your example of displaying your weapon. And so I don't have a lot of knowledge in terms of physical force being used to actually de-escalate a situation. But the threatening use of force or threatening verbally, I'm more familiar with that.
Okay.
Yeah.
So again, if we were to talk to the use of force or defensive tactics,
Objection, argumentative.
Overruled.
they would be the best source of that.
Objection, argument.
Overruled.
Yes.
But the purpose of de-escalation, agreed, is to attempt to slow down or stabilize the situation so that more time, options, and resources become available to the officer.
Yes.
Basically, slow down, everybody kind of calm down, let's try to relax, right?
Yes.
But it's a lot more, the process of de-escalation is not just trying to talk somebody out of doing something. There are actions that are important, there may be reactions that are important, and the de-escalation policy includes some examples of those things, right?
Yes.
Such as placing barriers between an uncooperative subject and an officer.
Yes.
And sometimes those barriers are another officer, right?
Yes.
Containing a threat, right? I mean, that's one of the examples in policy.
Yes.
By containing a threat, that can include physically restraining someone so that they don't upset another person, right?
Yes.
Or cause another person to have a violent reaction towards them or officers, right?
Yes.
Moving from a position that exposes officers to potential threats to a safer position, right? So kind of retreating in certain circumstances.
Yes.
Reducing exposure to a potential threat using distance, cover, or concealment, right? So hiding, say, behind a squad car, right?
Yes.
Avoiding physical confrontation. That's probably a pretty big one, right?
Yes.
And using verbal techniques to calm an agitated subject or promote rational decision making. That's kind of down towards the end.
Yes.
And lastly, calling additional resources. Right?
Yes.
And we talked about Exhibit 230. Showing you Exhibit 230, which is the emergency medical response. You'd agree that the policy requires Minneapolis police employees to request an emergency medical service as soon as practical, right?
Yes.
If a person comes into contact having an acute medical crisis, and any delay in treatment could potentially aggravate the severity of the medical crisis, right?
Yes.
So sometimes officers will call for EMS, not thinking it's a major issue. When suddenly it becomes apparent, they can step up or request a quicker response from EMS, right?
Yes.
And that is something that an officer can do to ensure the medical treatment of the suspect that they have or the person that they're in contact with, right?
Counselor, to ensure,
sorry, it's been a long week. To ensure the medical condition of the suspect, to help with them.
Yes.
Right. Get EMS there as quickly as is possible. Right?
Yes.
Now we didn't talk about the maximal restraint technique. You're familiar with the policy surrounding that?
Yes.
to show to you what's been admitted as Exhibit 225. Can you describe what the maximal restraint technique is?
Yes, Counselor, the maximal restraint technique is, has often been referred to as the hobble. And that is it's a method of, if officers are dealing with typically a combative or aggressive person, in order to protect them or even property, it's placing, basically attaching a cord of the legs to the waist, so that the person, the individual, does not have free movement of their legs. So it's securing them, again, usually by their ankles. If you're prone, bringing that up to your waist and securing it. The maximal restraint technique, or the hobble, though, if it's used, a supervisor has to respond to the scene. You cannot transport anyone prone in that position due to the risks of the breathing. But that is the, Counselor, that would be my understanding of the MRT, or the maximal restraint technique.
So you talked a little bit in terms of the use of force, how officers are kind of reevaluating their use of force from time to time, right? They
Yes.
should be, at least, right? And so if officers decide to use the maximal restraint technique and then decide, hey, we know, and then later decide not to use it, right? That is kind of adjusting that use of force.
I would, Counselor, with some clarity, I don't know if that, what I mean by that is, if you were to have a person handcuffed and prone on their stomach on the ground and pavement, and you had two officers, let's say, securing their legs to the back of the waist, you in a way are still employing what that technique is about anyway. So there can be some variances to that.
Sure.
If that makes sense.
It does. So let's assume that you've got two officers pulling the legs forward, essentially employing that aversion, so to speak, of the maximal restraint. But then they release and they say, we're not gonna hobble this person. We're not gonna employ the MRT. You're going from a decision to employ that technique backwards down the continuum in terms of the use of force. Would you agree with that?
And Counselor, I just because these types of uses of force can be problematic in terms of there's a high risk to them. So meaning that if you're going to take that initiative to do that alternative version in the first place, you'd want to get a hold of a supervisor, because something could happen in terms of that person. And so
I'm not
yeah.
I'm not asking in terms of the policy. I'm asking in terms of sort of the use of force and the critical decision-making model, right? You described how the use of force, you have to go through this critical decision-making model. How much force am I going to use? And sometimes you have to back off the use of force. Agreed?
Yes.
And sometimes you have to go forward with the use of force, meaning you use even more force.
Yes.
Right? And it's this constant reevaluation. Agreed?
Yes.
And so when you have officers who make a decision that the facts and circumstances would warrant using the hobble device, but then later decide not to employ that device, that is that critical decision-making model in action. Agreed?
Yes.
And it would be a reduction in the use of force. It may still require supervisors to be on scene, policy-wise, but it is a reduction in the use of force. Agreed?
And Counselor, are we talking specifically the events of May 25th?
I'm talking generally.
In general, yes.
But you would agree ultimately that all of the Minneapolis Police Department policies relevant to the use of force, emergency medical response, emergency medical treatment, all of these policies are, by their very language, are situationally dependent. right? They all say, if the circumstances allow, if time permits, if it's safe. They have a qualifier to them. Agree?
Yes, I would agree with that.
I'm going to show you Exhibit 231. Which is at the bottom of Exhibit 231 is the crisis intervention policy, and the second page includes the definition. Could you read the entire definition of what a crisis is?
Yes. An event or situation where an individual's safety and health are threatened by behavioral health challenges to include mental illness, developmental disabilities, substance use, or overwhelming stressors. A crisis can involve an individual's perception or experience of an event or situation as an intolerable difficulty that exceeds the individual's current resources and coping mechanisms, and may include unusual stress in his or her life that renders him or her unable to function as he or she normally would. The crisis may, but not necessarily, result in an upward trajectory or intensity culminating in thoughts or acts that are possibly dangerous to himself, herself, and or others.
All right. So generally speaking, again, not relevant to the May 25th of 2020 incident. We'll get there in a minute. But when we talk about a general police response, sometimes the police may respond to something and the person they're dealing with is not in a crisis. Agreed?
Yes.
But other people may be perceiving what is happening, and it could become a crisis to that person.
Objection.
If you could rephrase.
Sure. People who observe, would you say that people who observe police interactions with people, especially the more physical or use of force types, that could turn into a crisis for an observer?
Objection irrelevant.
Involve an individual's perception or experience of an event or situation as an intolerable difficulty that exceeds that individual's current resources and coping mechanisms, right?
Yes.
That doesn't necessarily mean that you are the person with whom you are arresting or having contact with is going to be the person who will experience the crisis. Agreed?
Objection irrelevant.
Overruled.
And Counselor, just respectfully, so you're saying that the person who's witnessing a situation with the officers, that situation may cause them to be in crisis?
Correct.
Could potentially.
Right. And the crisis may, but not necessarily, result in an upward trajectory or intensity culminating in thoughts or acts that are possibly dangerous to him, her, or others, right?
And Counselor, just this is the person who's watching this?
Right.
It could?
Right. So people are watching something that they appear to believe or they believe is wrong or contrary to police policy that may cause them to get upset, and that level of upsetness or that level of volatility may grow throughout the course of the interaction.
Objection irrelevant. Calls for speculation and beyond the scope.
Overruled. It's within the scope.
It could.
Right. Because ultimately part of the training that Minneapolis police officers have to go through is how to deal with crowds who observe police interactions, right?
Yes.
Crowds that may be upset with police interaction, right?
Yes.
I mean, there are classes through the training academy, there are classes through in-service specifically dealing with how to deal with crowd control, right?
Yes.
And all of this is to revert in part back to that de-escalation process as well, right?
Yes.
So part of it, as a crowd grows or becomes more upset, part of it is to try to de-escalate, which can involve trying to avoid a physical confrontation, right?
Yes, it could. Yes.
Trying to stay safe, concealed, and covered, right?
Yes.
Not yelling back at somebody, not engaging with them verbally, right?
Yes.
And sometimes when an officer tries to de-escalate a situation and someone is so upset, right? Sometimes they don't hear what the officer tells them. Would you agree with that?
Objection, speculation.
That calls for speculation. It is sustained.
Is it possible, generally speaking, that someone's own crisis may prevent them from hearing what an officer is telling them?
That could happen.
Hold on. The objection is sustained. The answer will be stricken.
So you testified that you've watched the body cameras, correct?
Yes.
Going to show you, I don't know, Mr. Slisher, this is exhibit 1008, which is a 10-second, approximately 5-second clip of Alexander King's body-worn camera that's already and I gave you a copy of it.
Is this in evidence?
Not yet, no. I'm just telling you, first and foremost, that's what it is. I'm going to show you on your screen a short clip of a video to see if this would be contained in what you've watched. And I need to... You would agree that that appears to be taken from one of the officer's body cameras, May 25th, 2020, at approximately 20:25 and 33 seconds.
Yes.
In, again, watching it without sound. Do you, at this point, did you see what appeared to be a reflection in the back of the squad car there?
Counselor, I did not.
Okay.
And it might just be because of the brevity of the video, but.
Yeah, it's unfortunate. If you look in the upper left-hand corner at the bumper of the squad video.
The cursor to circle it for him.
I'm sorry?
Use the cursor, the stylus to...
Oh, sure. Sorry. Forgot all this fancy technology here. You see the legs of someone reflecting?
Yes.
And so you would agree that this appears to be a short clip from one of the officer's body-worn cameras on May 25th of 2020?
Yes.
You've seen these before. You see what appears to be Mr. Floyd's arm there by the back of the squad car, right?
Yes.
So I would offer Exhibit 1008.
Any objection?
No objection.
1008 is received.
And if I may publish.
Oh, come over here.
Up on the sidewalk.
Yeah, we need you to keep some distance. Everyone's coming.
Sorry, didn't mean to reply. Do you hear a voice say we've got an ambulance coming?
Yes.
Oops, sorry, if we could take that down. Now, policy 5-311. Let's talk a little bit about 5-311, which is the neck restraint policy. This.
Counsel, would you stay there for a second?
Sure.
So we are in a sidebar right now where, well, it looks like they may be finishing up that sidebar.
Break. We'll reconvene around 3:20. Thank you.
All right, we are at a break now in the trial of Derek Chauvin. The city's chief of police was a highly anticipated witness and gave us a lot to talk about. With me now, Eugene Scott, reporter for The Fix, and James Homan, Washington Post columnist. So, James and Eugene, the first part of the post-lunch segment here, we heard the prosecution finish up their questioning, and we learned how the chief of police learned about the George Floyd killing. He was called, he was at home. He also reported it to a bureau where they have to report things like this, so he was following protocol. But he also said that a community member called him and said, have you seen the viral video of one of your officers choking George Floyd and killing him? So he watched it, and then the prosecution asked him his thoughts on what happened, and he said, as we were expecting him to say, that Derek Chauvin did not follow protocol, that
All right, let me ask you guys a question real quick. And think about your answer before you answer me. Don't you think that if the defense doesn't prove, put this case aside, if the defense doesn't prove that each individual situation can alter the rules, if they cannot prove that, what happens to all the thugs that are 15 times worse than Floyd ever was, and use that against this, and use that against Floyd? I mean, use that against the cops and use it to kill the cops because they know cops will be scared to do anything. Don't you think that there's going to be a rise in those? Because again, I know that he was not the perfect citizen, but he wasn't so horrible. There's a lot worse than him. So I want to know what you guys think of
that. Chauvin did was inappropriate and excessive. It's been quite interesting watching Nelson try to convince, or I guess try to convince the jury essentially, that the chief doesn't know much about policing. That was pretty fascinating to watch.
Yeah, I agree. I was thinking that too, that it sort of feels like Nelson, who is not an expert, of course, he's a lawyer, he's not an expert in policing, but he's also questioning someone who has had nearly 40 years on this particular force. He also has a master's degree. He also served in the part of the department where they oversaw misconduct reporting. So we learned that earlier as a part of his resume. So it is interesting to hear the defense ask him questions about policing. And try, of course, to perhaps trip him up in some of what he told the defense. James, what stood out to you in this last part?
A lot, Rhonda. This is the hugely consequential testimony, and so far I don't think Eric Nelson has laid much of a glove on the idea, other than kind of trying to put him outside of the street patrol. I thought one of the most interesting moments came when he was talking about going through watching the body camera footage toward the end of the prosecution questioning, when he said there was an initial reasonableness for the first few seconds. So remember, Derek Chauvin's knee is on George Floyd's neck for 9.5 minutes. He says, basically the chief said it would have been reasonable for a few seconds. The first few seconds of the takedown, it would fall under these various policies, would be allowed. Use of force is sometimes necessary. But then, we've talked about when that threshold gets passed. At some point in that 9.5 minutes, it almost certainly gets passed. And then, he said, this isn't just a violation of what we teach and our formalized policies on use of force, on the duty to care for someone when they're in danger. But he also went out of his way to explain that this is against our principles as a police department, was how he put it, against our ethics and our values, he said at another point. And that seems striking because it really did feel, especially in the period right after lunch, like the audience was as much the city of Minneapolis and the community they're trying to police as the jury.
In a striking impeachment of Derek Chauvin's actions, the police chief of Minneapolis said that Chauvin's actions contradicted the department's policy. So let's take a listen to that.
As you reflect on Exhibit 17, I must ask you, is this a trained Minneapolis Police Department defensive tactics technique?
It is not.
Well, we read the departmental policy on neck restraints. Is this a neck restraint?
The conscious neck restraint by policy mentions light to moderate pressure. When I look at Exhibit 17, and when I look at the facial expression of Mr. Floyd, that does not appear in any way, shape, or form that that is light to moderate pressure.
So is it your belief then that this particular form of restraint, if that's what we'll call it, in fact violates departmental policy?
I absolutely agree that violates our policy.
Eugene, did you find it striking at all that this police chief isn't mincing words? He isn't trying to kind of bridge between being the former boss of Derek Chauvin to now testifying against him. He is clearly saying that this is against policy.
It's not that surprising because, as you noted previously, he was very vocal very early regarding this incident, speaking out against Chauvin's use of force or how he handled this interaction, making the statement that this was not something that Minneapolis police are trained to do, or that is consistent with how they want to engage individuals who are suspected of a crime. And so he's been pretty consistent, but I think one of the reasons it's important to I guess know that his response has been shaped by the fact that he acknowledged that he was made aware almost immediately of just how well known and viral this video had become shortly after it actually had happened. He was aware that there was going to be some type of community pressure and concern in response to this killing in ways that weren't always the case with some other killings where things became public or videotapes were released much later. And so I think he made the decision that it was important that he make a stand and he take one as quickly as possible, and that he double down on it and be clear on what it is that he thought was in the best interest of the community, but the police department as a whole.
Yeah, and James, did it stand out to you any that we spent a really long time with the prosecution asking the chief of police about his resume, about his education, about the police's their approach to the community and ethics, and how he felt so strongly about that. But then the key part that we had all been waiting for only lasted a few minutes, which was that last clip that we played there.
Yeah, it's not that surprising. I think it is pretty typical in these sorts of trial situations, Rhonda, to have a wind-up to introduce this gentleman, to establish his credibility, to explain sort of the culture of the department, the expectation of what they want from officers. Obviously, there's a huge gulf between these mottos, like talking about respect and in earning the trust of the community, and treating, basically following the golden rule, for lack of a better term, and then the reality of what a lot of people experience in their day-to-day interactions with the police. But it was very important for the prosecution to establish that this is not what is law enforcement is supposed to be. And this really is just the very act of having a police chief on the stand testifying against a former officer is in and of itself so rare in a court of law, and so I think that the long windup was kind of necessary for him to then be able to say very definitively, no, this is not what we teach, this is not policy, this is not the departmental values or ethics.
All right, I want to play another clip of what we just saw with the chief of police. He testified that Derek Chauvin's actions violated the training, policy, and values of the Minneapolis Police Department. Watch the prosecution ask the chief about the length of time that Derek Chauvin's knee remained on George Floyd's neck.
Do you have a belief as to when this restraint, the restraint on the ground that you viewed, should have stopped?
once Mr. Floyd, and this is based on my viewing of the videos, once Mr. Floyd had stopped resisting, and certainly once he was in distress and trying to verbalize that, that should have stopped. There's an initial reasonableness in trying to just get him under control in the first few seconds, but once there was no longer any resistance, and clearly when Mr. Floyd was no longer responsive and even motionless, to continue to apply that level of force to a person proned out, handcuffed behind their back, that in no way, shape, or form is anything that is by policy, it is not part of our training, and it is certainly not part of our ethics or our values.
Now, Eugene, I know we don't have a crystal ball of what the end of the day looks like, but that clip right there, do you think that's going to be really the headline out of today?
It certainly will be one of them. And on social media, you know, I've been here the whole time, so I haven't been able to talk to folks outside of that. That certainly seems to be something that people paying attention are grabbing. And this is something also that if we look back on last week, many of the witnesses who were right there were stating that whatever amount of pressure was even within the realm of legality and acceptability, Chauvin had gone beyond that. And there was a point where it became very clear that Floyd was no longer resisting arrest, and he was not a threat to Chauvin to the degree that required the response from Chauvin that he delivered. And he could have changed his actions if he had been more observant and aware of Floyd and noticed that Floyd wasn't behaving in a way that required that level of force.
Mm. Well, since the death of George Floyd, many have asked whether police departments can be reformed. But the history of policing in this country shows how hard that task may be. National video reporter Hannah Jewell has more. Hannah?
Hi, Rhonda. So in questioning the Minneapolis police chief today, the prosecution was trying to make the case, as Eugene was just explaining, that Chauvin's the norms and the expectations for the use of force in policing, and that his behavior was abnormal in policing generally. But in the summer, many racial
Okay, it sounds like we lost Hannah Jewell there. Hopefully she can join us again. And she's been looking into how incredibly important police unions are when it comes to protecting officers. So hopefully Hannah can join us again. James, what Hannah was starting to say is that if you look at the history of policing in the United States, it does suggest that, you know, Chauvin is getting lawyers from the fact that he was an officer and has paid into the union, and that police officers are well insulated, and historically they have been well insulated. What are your thoughts about that?
Yeah, absolutely. That has been the story of, you know, the last several decades. It's why accountability is so incredibly rare. It's why it's so significant that not only did all 4 officers, not just Chauvin, but all 4 officers on the scene get fired, you know, within a day, really 2 days. They were also charged with very serious crimes. You know, the prosecution is really throwing the book at all 4 of these gentlemen, and it is going to be interesting. You know, I'm really fascinated to watch the rest of the cross-examination from Eric Nelson, because one of the themes he has not gotten to yet is what sort of political pressure came into play. You know, right away in the aftermath, obviously a member of the community called the chief at home at midnight, and that's what prompted him to watch the video. But you know, he's saying that they violated the policies. He's saying that they had to fire Chauvin. But I would expect Nelson to argue that some of that was a kind of political calculus, that, you know, they could argue that it was that they're saying he violated all these policies, you know, because of political pressure. That hasn't come yet. It may not come up because they might decide that's not a particularly productive legal argument. But I wouldn't be surprised if that sort of line of questioning emerged when we come back from this short recess.
Yeah, I think we might have Hannah Jewell back with us. Hannah, are you there? Okay, great.
I hope so. I was just about to get into my favorite subject of history, but my internet had other ideas. But as I was saying, so we have the jury who have been instructed from the very beginning of this to focus only on Derek Chauvin only, not the protests of this summer, not the issue of police violence more generally, or the role of policing in American society and history. But we as viewers are obviously thinking about this stuff a lot because of the enormous significance of this case to politics and all of our lives. And this is a historic trial because of what it might mean about the state of policing in this country and what justice is or isn't available to victims of alleged police misconduct. So last summer, I wanted to learn more about this and about the deeper history of policing and police violence in this country. So I spoke to two professors, Chenjerai Kumanyika from Rutgers and Harvard's Khalil Gibran Muhammad, and let's take a look at part of my interviews with them.
It seems really trite to say if you don't study history, you're doomed to repeat it, but nothing illustrates that more than the history of policing.
Policing, in one form or another, has existed since colonial days. In the form of night watches, local sheriffs, and militias. But it wasn't until the 19th century that northern cities such as Boston created modern police departments as we would recognize them today. These northern departments were not the first example of a uniformed, publicly funded law enforcement institution in America.
By the time the northern colonies were afoot in the 17th century, the idea of keeping track of the most valuable asset in the United States, that is, enslaved Africans, animated much of what we'd recognize today as law enforcement.
So Rhonda, while the jury has been instructed not to think about these wider issues or to think necessarily explicitly about race in policing, what the history shows us is that police forces were originally created in this country, not necessarily to enforce a general sense of public safety, as Minneapolis's police chief has been talking about today as being the fundamental goal of his department, but rather law enforcement as a concept was created in the first place to capture escaped enslaved people in the South, and also in the North to break strikes and to put down labor movements in the interest of wealthy business people and factory owners at the turn of the century of the 19th century, rather, when or the 19th to 20th century turn, as people were immigrating in large numbers to the United States, and there was a lot of labor unrest. So there's a small irony in that, because police unions today, as we've been discussing, are some of the most powerful unions that there are in this country in a time of overall diminished labor power for most workers. And today we see how Chauvin benefits from having a strong union, and that his defense is being funded entirely by his union even after his firing. So in any case, this is a difficult history to think about, but an important one to bear in mind while we're thinking and talking about policing and race today. And if anyone wants to see the rest of my interviews with those professors, you can search for the Origins of Policing in America on YouTube or on thewashingtonpost.com. Rhonda?
All right, thank you so much, Hannah, for that insight and that history. We're a few minutes away from the courtroom resuming today's testimony. Eugene, I want to get your take on some of the things Hannah said. What we are witnessing now is actually a part of a very long progression and long history of policing and who policing has focused on since slavery. So what were your thoughts when she pointed out that history?
Well, it was a reminder that this isn't just about Minneapolis, and regardless of what may have been permissible in this case and what hasn't, people across the country are paying attention because there have been concerns about the relationship between law enforcement and Black Americans nationwide and for decades, literally for decades, arguably centuries. And one covering all of these cases, as you and I have often come across people who may say, where did this issue come from? I've never heard about this growing up, or why is it just getting so much attention now? And the truth is, we just live in a completely different time, a completely different moment, where social media has really de-centered the narratives and the power of the individuals who historically have told stories about Black communities and the policing of them to people in general.
It looks like the judge is back in his seat. Let's go ahead.
The use of neck restraints and the policies that permitted neck restraints. That is Minneapolis Police Policy 5-311, correct?
Yes.
Exhibit 224. You have that in front of you there?
Yes.
So there are, is a difference, the policy draws a difference between a chokehold and a neck restraint, correct?
Yes.
A chokehold is actually from the front obstructing or occluding the trachea and airway of the suspect, correct?
Yes.
And per Minneapolis policy, that's considered a lethal use of force or a deadly use of force, right?
Yes.
And that's because it has a high rate of death associated with it, right?
That is correct.
It's more dangerous to from the front.
Yes.
It also differentiates between a chokehold and a neck restraint. Agreed?
Yes.
And a neck restraint is specifically defined as compressing one or both sides of a person's neck with an arm or leg without applying direct pressure to the trachea or airway. Agreed?
Based upon the policy, I think it's important to note, Counselor, that the light to moderate pressure.
Right. Understood. Light to moderate pressure.
Yes.
And I'm assuming that you don't have a degree in physics.
I do not, Counselor.
Okay. And in terms of the amount of pressure or force that was actually applied to Mr. Floyd, you would not be qualified to speak to that. Agreed?
Agreed.
But then it also differentiates between a conscious and an unconscious neck restraint, right?
Yes.
And a conscious neck restraint is where you have someone who is resisting you and you apply that neck restraint in an effort to simply gain control of that person, but they stay conscious, correct?
Yes.
And an unconscious neck restraint is where you actually render the subject unconscious, right?
Yes.
Both were permitted under Minneapolis Police Policy on May 25th of 2020. Agreed?
Yes.
And ultimately, you have, if I understand what you have, the opinion that you have formed the opinion that this was a neck restraint that was being employed.
Yes.
And you have also formed the opinion that this was an unconscious neck restraint. Is that correct? Or excuse me, a conscious neck restraint.
Yes.
Okay. You're familiar, you testified on direct examination that it is contrary to the training that you've received to place your neck or your knee on a subject's neck.
Counselor, if I can clarify, it is contrary to our training to indefinitely place your knee on a prone, handcuffed individual for an indefinite period of time.
So the issue that you take with it is the length of time?
Counselor, there's a couple of issues, and one of those, again, is, as you noted, receiving the information. Is the person a threat to the officers or others? What is the severity of the crime? Are you reevaluating and assessing the person's medical condition? So all of that critical thinking, that's really key for me in terms of why I vehemently disagree that that was the appropriate use of force for that situation on May 25th.
Now, when we talk about that critical decision-making model, that critical decision-making model doesn't only apply to the specific subject that you have under your control, correct?
And Counselor, so we're talking about, is this the bystanders?
Would you mind moving the microphone back just a little?
Your Honor, my apologies.
No problem.
I think we just got a loud voice. Sorry. Well, I'm talking about bystanders. I'm talking about other officers. I'm talking about other things that come into play in terms of the officer's critical decision making.
And I apologize, Counselor, if you could just rephrase that question again.
When an officer is engaged in the use of force, and I'll just phrase it as a yes or no, their attention is not exclusively necessarily focused on the subject of whom they have in custody. Agreed or disagree?
The officer that is engaging in the use of force may be viewing other matters?
Correct.
That would be yes.
Right, and in fact, that's what the de-escalation model talks about, is looking at things from a tactical advantage or disadvantage. Agreed?
It's one of the portions of it.
Right. Specifically in the policy, de-escalation has to be applied, assuming that it's safe to do so, right?
Yes.
And all other tactical considerations. Agreed? That's what the policy says.
Yes.
And in terms of those decision making, an officer, it's not a singular decision making process that's happening in the course of an arrest. Agreed?
Yes.
So an officer has to be concerned about other things that are known to him at that time. Agreed?
Yes.
So some of those things would be, what just happened between me and this subject a few minutes ago, right?
Yes.
I just fought with this subject a few minutes ago. I'm talking generally here. I just fought with this person generally a few minutes ago. He now seems to be not resisting, but that doesn't mean he can't resist again, right?
Yes.
Even if he's handcuffed, right?
Yes.
And so even if he's handcuffed, someone can still, they're not threatless if they're handcuffed. Agreed?
And Counselor, this is just a general hypothetical.
Right.
Yes.
Right. Someone who is handcuffed can be equally as a threat to an officer as someone who's not handcuffed.
Yes.
They can kick, and they could bite, they can spit, they can do all sorts of things. Agreed?
Yes.
Now, in terms of the use, so I just want to make sure you form the opinion that this was an unconscious neck restraint, right?
Counselor?
On May 25th of 2020.
That it was a conscious neck restraint?
Conscious neck restraint.
Yes.
Okay. Now, again, in this whole de-escalation, officers have to take into consideration the safety of the crowd, right?
Yes.
They have to take into account the reactions of the crowd, whether they're angry or hostile or just simply watching, right?
Yes.
That's all part of this critical decision-making model, right?
Yes.
They have to be aware of their surroundings, right? Generally
Yes.
speaking. Being on a busy street versus being in a park, right?
Yes.
Different decisions go into that, right?
Yes.
Knowing that I have other officers that are in place and may be at risk as well, right?
Yes.
So there's lots of, the critical decision-making model is not singular in its application.
That's correct.
Lots of information coming in very rapidly, right?
Yes.
So I'm going to show you first, and I believe by stipulation, or at least without objection, I'm going to play a few minutes, or excuse me, a few seconds of Miss Frazier's Facebook video. So at this time, I'd offer Exhibit 1018.
No objection.
Permission to publish.
1018 is received. You may publish.
I'm going to pause it here, sorry. This appears to be sort of that time, that picture that was shown to you earlier, Exhibit 19. This is that general time frame that picture appears to be taken from.
Counselor, yes. I'm sorry. Was that here for this? A question? I'm sorry.
Oh, yeah. This appears to be that image you were shown on direct examination, that static Exhibit 19, right?
Yes.
Shows Officer Chauvin, shows Mr. Floyd, it shows Officer Tao.
Yes.
And it shows the perspective of the Miss Frazier's phone. Chief, are you familiar with the concept of camera perspective bias?
I am not, Counselor.
Okay. Now again, if I may take that down, by stipulation, I'm going to show that same time frame, exhibit 1019, that same perspective from Mr. King's body camera. And I'd offer 1019. 1019.
Any objection? 1019 is received.
Wish to publish, Your Honor. Agree it appears to be the same time frame?
Yes.
All right. Now lastly, Chief, I'm going to show you one last video. We can take this down, Your Honor. I would offer exhibit 1020, which is a side-by-side of the two.
Any objection?
No objection.
1020 is received.
And permission to publish. Pardon? Oh. I just started it over, if that's okay. You would agree, Chief, that from the perspective of Miss Frazier's camera, it appears that Officer Chauvin's knee is on the neck of Mr. Floyd.
Yes.
Sorry, I didn't mean to do that. Would you agree that from the perspective of Officer King's body camera, it appears that Officer Chauvin's knee was more on Mr. Floyd's shoulder blade?
Yes.
I have no further questions.
Mr. Slusher.
Thank you, Your Honor. Chief, let's start with what you just saw, and you testified that the particular moment in time that you were viewing Officer King or former Officer King's body-worn camera, it appeared at that moment in time that the knee of the defendant was more towards the shoulder blade. Is that right?
That is correct.
That was at a time where the ambulance had already arrived?
Yes.
Very shortly before they loaded Mr. Floyd onto the gurney. Is that right?
That is correct.
And in your view of the body-worn camera footage and everything you reviewed prior to testifying today, did you see the defendant's knee anywhere but the neck of Mr. Floyd up until that time?
That is correct.
And so the knee of the defendant was on Mr. Floyd's neck up until the time you just pointed out.
Yes, when I viewed that video portion, that is the first time that I'd seen the knee of the defendant on the shoulder blade area.
And that was right before the paramedic came?
That is correct.
Now, looking at and talking about the neck restraint policy, if you could show Exhibit 17, please. Oh. Looking at Exhibit 17, was it your testimony that Exhibit 17 is not a trained MPD neck restraint?
Correct, that is my testimony.
And I'd like you to reflect on the exhibits that you were shown by defense counsel, exhibits 1008, 1019, and 1020, the 10-second clip. Okay. During that period of time, which is much later than the point in time we see here, did you see any indication that Mr. Floyd was actively resisting, as that term is defined in Minneapolis Police Department policy?
I did not observe Mr. Floyd to be actively resisting during that time.
Did you see, same question, same time period, any indication that Mr. Floyd was being actively aggressive during that 10-second clip that you were just shown?
No, I did not observe Mr. Floyd to be actively aggressive during that short video.
Could you even say that he was passively resisting at that time that you were shown those exhibits?
No. As a matter of fact, as I saw that video, I didn't even know if Mr. Floyd was alive at that time.
I want to revisit a little bit of the testimony on cross-examination about the use of the MRT or the hobble, right? And if I'm to understand your testimony, you indicated that a hobble is a strap that's used to connect a handcuffed person, their waist, the arms, and the legs to restrain them. Is that right?
Yes, that is correct.
And what I thought I heard you saying in response to questioning by counsel was that you can do an MRT effectively, right, without using a hobble when you're doing the same thing but with your hands.
Yes, that is correct.
And did I understand your testimony to essentially be that that's what these officers were doing, was essentially using the maximal restraint technique but not using the hobble?
That is correct.
And pursuant to departmental policy, the hobble is the only authorized way to employ the maximal restraint technique. Is that right?
That is correct.
Are you aware that the use of the actual hobble requires a supervisor to report to the scene and do a force report?
Yes, the supervisor must arrive at the scene and do a report.
But that would be avoided if the hobble itself wasn't used, or?
No, if you're still employing that sort of technique, again, with a prone individual handcuffed, and you're basically doing that maneuver, and because of the severity of risk to, and certainly that would have been to Mr. Floyd, you would have contacted a supervisor.
And aside from that, I mean, if you're using an MRT, you are supposed to adhere to departmental policy. Is that right?
That is correct.
And the Minneapolis departmental policy for the use of the MRT requires an officer to do what as soon as the MRT is applied?
again, because of the severe nature of making sure that that individual can breathe, we have to get that individual into a side recovery position to make sure that their airway is not obstructed. And so that's paramount.
So, and that's required by policy, and the side recovery position is supposed to be instant, is that right?
Immediate.
And you indicated that it has to do with breathing. You're familiar with the term positional asphyxia?
I am.
Is that one of the dangers of leaving somebody in a prone, handcuffed position for too long?
Yes, positional asphyxia. We again, as I mentioned, we cannot transport people in that position if they're prone to handcuffed and there's pressure around their airways or on their back. The risk and potential for them and us killing them goes up substantially. So that side recovery position is very critically important.
I want to follow up on some of the questions about your own personal training and that of different officers in different roles within the Minneapolis Police Department. Different officers can attend other types of training, is that right?
Yes.
But everybody's required to do in-service training, is that true?
That is correct.
And regardless of where somebody trains, I mean, the rules are the rules, right?
Yes.
And the policy applies to all MPD officers.
Yes.
The question was posed regarding the critical decision-making model and the need to take in information. And that's true, correct?
Yes.
When we're looking at the proper and authorized use of force under departmental policy, is it fair to say that the amount of force an officer can use depends upon the conduct of the subject, the person upon whom the force is being used?
Yes, it's fair to say that.
So, for example, if you had me in, let's say, a dangerous hold, right, would you be able to continue to keep me in a dangerous hold based on something somebody else is doing?
I'm sorry, if you could explain that, I'm sorry.
So, for example, if you found the need to place me in some sort of a hold that's dangerous.
Yes.
But something that you see, say the judge is starting to pick something up to throw at me, would that justify you using more force on me?
No.
And in terms of de-escalating the crowd, you indicated that there's some potential need to de-escalate a crowd, a group of people. Is that right?
Yes.
Because a group of people can experience something that they find shocking or upsetting, and that can, place them in some kind of an emotional state. Is that right?
That's correct.
And you may need to turn your attention to and de-escalate the crowd.
Yes.
Would one way, if we can show Exhibit 17, would one way to de-escalate the crowd who's experiencing something shocking to stop doing the thing that's shocking them?
Absolutely.
I have nothing further.
Any recross?
Thank you. Very briefly, just one question. There are certain circumstances where an officer has to kind of freeze the situation, evaluate, hold the person until he or she can decide what's the safest way to move forward. Agreed?
Agreed.
Sometimes you just have to kind of hold the person, correct?
Yes.
And that's something that happens fairly frequently. Agreed?
Yes.
And so one other question with respect to the policy regarding the maximal restraint technique and putting a person in the recovery position or the side recovery position, you said it was immediate. Agreed?
As soon as you're able to do so, yes.
And that's actually what the policy says, is as soon as you're able to do so, right?
Yes.
And there are certain circumstances under which you may be using force where the force has to be dealt with before you can turn your attention to rendering medical aid, right?
And Counselor, just so that, are we still talking about someone in the recovery position or the hobble?
Just generally.
Can you repeat that? I'm sorry.
Sure. There are certain circumstances where a use of force needs to be continued for some reason to deal with something else before you can deal or render medical aid. Let me give you an example. We're in a gun battle, right? You and I are shooting at each other. I'm the cop, you're the bad guy, and you hit my partner. I'm going to continue to use my force against you before I can go render medical aid.
Counselor, in that hypothetical, yes.
Thank you.
Briefly.
Sometimes it's necessary to freeze a scene and to hold an individual, correct?
Yes.
But you have to do so safely. You have to hold the person safely. Isn't that correct?
That is correct.
Nothing further.
All right, thank you, Chief. You're
Your Honor,
excused.
thank you so much.
Next witness. All right.
All right, it looks like they are in a sidebar right now. We've just seen the Chief of Police finish his testimony today. That was a key witness that a lot of people were looking to hear from today. What we've learned is he said pretty much unequivocally that Chauvin, the type of restraint that he used was not a part of protocol, and it also wasn't a part of the ethics that they are trained to abide by. So he has just concluded the cross-examination process as well after being questioned by Eric Nelson, the lead attorney on the defense, and it looks like they're back.
Thank you, Your Honor. The state calls Katie Blackwell.
You swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
I do.
And if you don't mind taking off your mask, great. Let's begin by having you state your full name and spell each of your names.
Okay. Katie, K-A-T-I-E, Marie, M-A-R-I-E, Blackwell, B-L-A-C-K-W-E-L-L.
Mr. Slisher.
Thank you, Your Honor. Good afternoon.
Good afternoon.
How are you employed?
Through the Minneapolis Police Department.
What is your current position?
My current position is the inspector of the 5th Precinct.
Right. How long have you been the inspector of the 5th Precinct?
Since January 31st this year.
What was your immediate rank and assignment prior to that?
The commander of the training division.
Now, I'd like you to tell the jury a little bit about yourself. First, could you tell us about your educational background in law enforcement?
Sure. So my 2-year associate's degree is in law enforcement through Minneapolis Community and Technical College. My 4-year bachelor degree is in police science through St. Mary's University. My master's degree is in public safety administration from St. Mary's University. I'm a graduate of the Northwestern Police Staff and Command, and I'm just about to complete a 2-year course in United States Army Sergeant Major's Academy, which is equivalent to a master's in leader.
So in addition to being a police officer, you're also in the Minnesota National Guard, is that right?
I am.
At what rank?
E9 Sergeant Major.
Okay. And just for the uninitiated, can you describe where that falls within the ranks of the enlisted?
That is the top enlisted rank that you can achieve.
How long have you been in the Minnesota National Guard?
Over 23 years.
Have you ever deployed?
I have.
Where?
To Bosnia on a peacekeeping mission, and then to Iraq for almost 2 years on a Operation Iraqi Freedom.
Thank you. Can you please tell the jury when you began your law enforcement career with the Minneapolis Police Department?
Sure. So in 1999, I worked with the 2nd Precinct Community Response Team in the neighborhood I grew up in, Northeast Minneapolis. And we basically worked on nuisance livability crimes, narcotics related, alcohol related. And then in 2000, I became a community service officer. I was assigned to the 4th Precinct and the SWAT team. In 2002, I became a police officer, and I worked the 1st Precincts, 2nd Precinct, and 3rd Precinct, mostly 911 response patrol. I did work for 1st Precinct and 3rd Precinct's community response team, which is, I did a lot of ICE work and narcotics-related investigations. And then I did a little time in Violent Offender Task Force, which is known as Safe Streets. That's high felony violent crimes that we worked. In 2012, I was promoted to sergeant, where I worked sex crimes investigations, and then 4th Precinct Patrol supervisor, and then 1st Precinct Patrol supervisor, mostly overseeing 911 response, and then our community response teams, and foot patrol. And then I went to the assault unit to do investigations, and then violent criminal investigation team, which was primarily investigating shootings, and then cold case homicide and homicide detective. I was then promoted in December 2019 to the rank of lieutenant. And I should say during that time, I led the SWAT crisis negotiator team for 5 out of the 7 years. When I became a lieutenant, I was assigned to the training division to create leadership and professional development programs for the department. And then I took on the field training officer program. I was promoted to commander of training in April 14th, 2019, where I oversaw the Police Athletic League, Police Explorers, community service officers, the academy, police academies, the in-service training, overseeing the subject matter experts, the medical support team, range patrol operations, the crisis intervention team, and the use of force team, as well as recruitment, hiring background, the 911 call center, court liaison, and adult and vulnerable homeless population.
Thank you. And as a person who was in command of the training center, are you familiar with the basic curriculum that was offered at that center during the time period you oversaw the operations?
I was.
And were you also familiar with the various staff and components who provided training at that center?
Yes.
Before we get into a more thorough description of the training center, I need to ask if you're familiar with an individual by the name of Derek Chauvin.
I am.
How are you familiar with that person?
We worked on the same shift. We were community service officers together.
Back prior to becoming a police officer?
Correct.
So you've known this person for approximately how long?
Almost 20 years.
Do you recognize Derek Chauvin in the courtroom today?
I do.
Would you please point to him and describe what he's wearing?
I was sitting over there in a navy blue suit.
May the record reflect the witness has identified the defendant.
It will.
So you and the defendant have worked for the Minneapolis Police Department contemporaneously for nearly 20 years?
Correct.
When you came into the police department, did you go through academy training?
I did.
Describe that process.
It was a 16-week police academy that we went through. Everything from, we learned policy, procedure, investigations, defensive tactics, use of force. We did a lot of scenarios at the end that we had to pass. So it was just a wide curriculum of things, report writing, basically anything that pertained to the job.
Okay. And after completing the classroom and practical portion of the academy, when you took it, what was the next step?
Sorry?
What was the next step after completing the practical exercises at the academy and the classroom training?
Oh, so it's a field training program. It's approximately 5 to 6 months long that you would ride with a field training officer.
And then after you completed that, you were able to get your first assignment.
Correct.
Well, I'd like you to please describe first generally the training center. Where is it located within Minneapolis?
Sure. So it's our training center is a former elementary school that's located on the north side of Minneapolis. And it's just several classrooms that we use for training, as well as auditorium and a gym if we have to do hands-on or practical exercises.
And it was supervised at the commander level, or is supervised at the commander level?
It is.
Can you then describe, currently, or at least at the time, say 2020, when you were overseeing it, how is it staffed, or the different positions at the training center?
So there's multiple units out of the Special Operations Center is the training facility. For training, we had full-time instructors, our use of force instructors, our patrol operations, our medical support team, our civilian support staff. We have 2 civilian support staff members. I don't know if you want me to go through the rank structure, but
I do. How many lieutenants were under you?
At the time, there was 3 lieutenants.
In what areas?
So one oversaw pre-service, so your academies, and then another one oversaw the use of force program and our range. And then the other one oversaw our leadership professional development programs and assessment center type of things. So they each had individual kind of specialty things that they oversaw.
And who was the lieutenant over the defensive tactics training?
At the time was Lieutenant John Mersil. Sorry? Lieutenant Johnny Mersil.
What happens during pre-service training now?
So pre-service is our police academies. We have 2 different types of police academies, a recruit and a cadet program. So they will, currently it's changed a little bit since last year, but the time I was a commander, it was 18 and 19 week police academy that they would go through, that they had to pass before they could enter into their field training officer program. So they endure a lot of use of force and defensive tactics. They train on investigations, they do scenarios, de-escalation, crisis intervention, medical, and heavy emphasis on the policy, manual, and patrol operations.
Okay. And the training that's provided, say, for example, with defensive tactics, is that different in pre-service than the training that's provided during in-service training?
It is not different. It's just longer. They get more of it in the academy.
If you, one moment, Your Honor, if I may. Thank you, Your Honor. Right, and so fair to say that the training that's offered up at the academy, it's just an extended version, a more thorough version of what's offered at in-service.
Correct.
In-service would focus more on classroom training, and there's a curriculum that's been developed by the defensive tactics instructors and teams, is that right?
Yes.
They typically show some kind of a PowerPoint presentation going over the rules and Minneapolis Police Departmental policy, is that right?
Correct.
For in-service, whereas the academy, they're going to go through that same, some of the same concepts and materials, but in a more extended way.
Yes.
Right. Now, you've also mentioned a field training program, and in order to have the field training program work, you have field training officers, is that right?
Correct.
And sometimes, the field training officers need to be aware of what the people in pre-service are doing as far as what they're learning in defensive tactics, is that right?
Yes.
And so is it true that sometimes field training officers will receive instruction in defensive tactics, for example, just the same as someone in pre-service training?
Correct.
And what is the purpose of making sure that the field training officers are aware of what the training is in pre-service?
So there's consistency of how we grade and how we evaluate recruit officers on the street.
And was the defendant a field training officer?
He was.
Do you know how long he was a field training officer?
I do not know off the top of my head.
Did you select him as a field training officer?
I did.
Now, you've mentioned a variety of different courses that are taken and training that's provided at the Workforce Center. Is it important to keep records of that training?
It's very important.
And why is that?
Because Minnesota Post Board, which is our peace officer standards and training, require us to complete so much training each year. Part of that is the 48 hours of continuing education over the course of 3 years. And with that training has to be annual use of force, weapons qualifications, mental health crises, procedural justice. So a third of that training, 16 hours roughly out of that 48 hours, has to be in compliance with the Minnesota Post Board. And so keeping those records are critical to make sure we can, when we bring them to Post Board, they can do an audit on them.
And you rely on those records in order to, in fact, make these reportings to the Post Board so that you have qualified officers on your staff. Is that right?
Correct.
They're kept in the ordinary course of your business, I guess, in the police department?
They are.
This time I'd like to show the witness only, Exhibit 203 for identification. All right, Inspector, you take a look at Exhibit 203 and I'll ask you to just rotate through some of the pages so the witness can examine. You familiar with these records?
I am.
How are you familiar with them?
So these are training records that we track in our workforce director system. We maintain these records. Each officer has to sign in at training, usually in the morning and the afternoon. And then our civilian coordinator will upload these into the officer's file so we can keep track of the training, or if somebody didn't make the training, who needs to make it up. And it's in-service training and any additional training that they had on duty.
And I'd like you to go to the back page to show the last page of the witness. Right, and you see that this particular workforce record goes back to 2003. Why is that?
That's when workforce director started, I believe.
Prior to that, there was some different system?
Just paper
system. And how long are those records retained?
So in workforce director or in our...
How long does MPD retain the training records pre-workforce director?
So the city retains records for 7 years. So once we have them, we'll keep this in our workforce director. And some training syllabuses and itineraries are put on an M drive. Paper copies are generally archived at some point. They're brought down to a central location within the city.
But for 7 years?
Correct.
Okay. So these are the records that we have available for this particular individual, going back to 2003. Is that
yes.
Right? Okay. Is Exhibit 203 the defendant's training records? Exhibit 203, is this
yes.
the training records of the defendant?
Yes, it is.
I'll offer Exhibit 203.
Any objection? No objection. 203 is received.
Permission to publish. And so I'd like to just, if you could scroll up and highlight this first record entry here. You can see these records are organized in a way that just generally labels the course, and it gives various dates, and then there's a start date and an end date for the participant. Is that right?
Correct.
And then a total number of continuing education credits that are logged. Is that right?
Yes.
Okay. Now I want to back up through these records. If you could bring it out again. If you could slide it down, please. All right, so just for example, we can take a look at what's labeled here in the 2019 annual training, that section there. All right, and so you see with these records, it's listed as a 2019 annual in-service training, and it refers to a phase 3. Right. What is the annual in-service training?
So our annual in-service training usually consists of 3 phases of training. The first phase will have 2 days of in-service training for officers, so approximately 14 to 16 hours from January to roughly April. And then phase 2 will roll into our shotgun qualifications or medical training, depending on the curriculum that year, what's in that. And that's usually kind of the beginning of the summer months and the end of the summer months. And then phase 3 is our fall in-service training. And the same thing, it's usually 2 days of different curriculum that we're mandated to do, or that maybe the chief wants us to do, or that we're trying to do professional development courses.
And so regardless of the specific trainer, if an individual from MPD is taking phase 3 2019 annual in-service training, should they be learning the same thing on that particular day as anyone else in MPD taking phase 3 training?
Yes, they should.
If you could zoom out again, go down to 2018 FTO, next page. Oops. Okay, here you see what's marked as a 2018 FTO training program. FTO is Field Training Officer, correct?
Yes.
And so is this a train the trainer program?
Yes, from the FTO coordinator and myself as the FTO lieutenant at the time put on that training, where we brought in a variety of different instructors to teach at that class.
And what is taught at FTO training?
So that was a almost 40-hour course, and we taught, it was a primary emphasis on leadership, the critical decision-making model, effective it's a recruit observation, performance evaluation report, really. So the FTOs are taught the FTO manual, and then they're giving tips on train the adult learner. And we do some scenarios in there where they debrief using the critical decision-making model. They had defensive tactics. They had a component of human resources that came in to explain what the dues and other jobs are as a field training officer. It's basically, we were trying to make sure that they understood what the recruits were being taught, because they're going to evaluate them out there, and they're the closest thing to a supervisor that young recruit officer has.
And if I understood your prior testimony, defensive tactics and use of force is something that's trained every year during the regular in-service, is that right?
Correct.
So, for example, in 2018, the defendant would have been instructed in defensive tactics and proper use of force at least twice, right? Once during this 2018 FTO training program, and once during the regular in-service.
Correct.
And if we can, I'd like to, at this time, just to the witness, display Exhibit 275. At Exhibit 275, does that appear to be handwritten records, like a sign-in roster for a particular course?
It is.
The particular course includes patrol ops, and there's a parenthesis, as taught in the academy, and defensive tactics as taught in the academy. Is that right?
Correct.
And the second name on this list, does that appear to be the name of the defendant?
It is.
Right, and so does Exhibit 275 indicate that the defendant did receive on November 30, 2018, a block of defensive tactics training as taught in the academy?
Yes.
Offer Exhibit 275.
No. 275 is received.
Permission to publish?
Yeah.
And if you could highlight this portion. And you can see the number of training hours here was 8, is that right?
Correct.
And so that would have been divided between patrol ops and defensive tactics as taught in the academy.
Yes.
And again, the purpose is so that a person can be an effective field training officer and know what the trainees or the cadets and recruits are being taught in pre-service. Is that right?
Yes.
We could go back then to 203. She'll go to the second page, page 2 of 7, and where it says 2018, this one. If you could highlight that, please. Oh. It's up for me. Is it just quit?
You want to publish?
Oh, I did. I'm sorry. Permission to publish. You highlight that section, please. And just to define some terms here, you see it says 2018 shotgun and CIT training. Is that right?
Yes.
It's a 7-hour block.
Yes.
Correct. And CIT, what does that stand for?
That is crisis intervention training, so de-escalation and mental health awareness.
You also see there's a training indicated for procedural justice and Narcan training in 2018, correct?
Yes.
And on the crisis intervention training, this one is a fairly short crisis intervention training block, is that right?
Correct. They switched days, so one group would go to qualify with shotguns and the other group would be in CIT, and they'd flip-flop after lunch.
But the original crisis intervention training block or model that's taught to MPD officers, it's much longer than 7 hours or even splitting 7 hours. Is that right?
Yes, it's 40 hours, and this is just a refresher.
Okay. And so then if you could move to the next page, please. And highlight that portion. The one above it too, where it starts at CIT 2016. All right. And so here you see on the defendant's training records, it indicates multiple 8-hour blocks of instruction occurring in November of 2016. Is that right?
Yes.
And is that show where the defendant attended paid crisis intervention training in 2016, the approximate 40-hour course?
It does.
In addition to, if you can take that down, please. In addition to the defensive tactics and use of force training, does in-service training require regular medical or kind of combat lifesaver training?
Yes, we generally do a medical component.
Okay. Can you just please describe what that training entails?
Sure. So our medical support team consists of a full-time trainer, and they have part-time trainers that are certified EMTs or paramedics. They're also police officers. So they will perform, they'll conduct CPR training, Narcan, tourniquet, chest seals, just life-saving measures, they cover positional asphyxia. Sometimes they cover excited delirium, opioids, things that relate to our job when we respond to a call, so they can better assess the situation when they get there and be able to render first aid.
Now, you mentioned the term positional asphyxia. You're familiar with what that is?
Yes.
What is your understanding of positional asphyxia?
So positional asphyxia is if you're in a position where you're not able to adequately breathe. Something is interfering with your airway.
And if an individual is in a prone handcuffed position, for example, face down, that could inhibit their ability to breathe.
Yes.
And cause positional asphyxia.
Yes.
And what are officers trained to do or supposed to do to prevent positional asphyxia?
They're supposed to put them on the side recovery position, which is they're going from prone and just putting them on their side or upright position.
How soon are they supposed to do that prior to or after getting the person under control in the prone position?
As soon as possible.
How long have you known about the potential dangers of positional asphyxia?
We were taught positional asphyxia all the way back to my academy.
At the Minneapolis Police Department?
Yes.
The dangers of positional asphyxia been known throughout the department at least as long as you've been employed there?
Correct.
And your employment overlaps, with the defendants, is that correct?
Yes.
As part of the medical training, do you, in addition to the actual how-to of providing emergency medical care, are officers taught their obligations to provide and render emergency assistance when the circumstances arise?
Yes, it's in policy as well as training.
You're familiar with the Minneapolis critical decision-making model?
I am.
And that model, you've seen the circle, we've all seen the circle now a few times, that model is infused throughout different portions of the training materials at MPD, is that right?
It is.
Why is that?
We wanted to ensure the officers, a lot of experienced officers understand that critical decision-making model. The more experience you have, the more you can walk through it. But we found it critical that recruits learn it early on. It was helping them connect the dots better with information they were receiving on the scene and working through that wheel, constantly reassessing, and then using the pillars of procedural justice in the middle. And so we wanted it consistent with our field training officer program to debrief them, the recruits, and then in our in-service so that officers out there could constantly reassess situations when they're on a scene.
You said that the critical decision-making model was used to reassess people who are going through the FTO process?
Yes, in the field training officer program, we had scenarios where we had the field training officer debrief. At the time, we used community service officers as role players, so we had them debrief using that after a scenario.
So going through the steps of taking in information, assessing risk, assessing threats, reassessing, evaluating goals, and then relating that to the pillars of procedural justice, that's something that any field training officer would be required to do with the people that they're evaluating, correct?
Correct.
In your defensive tactics training, you are not only showing or having officers learn sort of the nuts and bolts of defensive tactics, but also the rules of engagement. Is that right?
Correct.
And those are contained in the Minneapolis Police Departmental policies. Is that right?
Yes.
And the rules are the rules. They apply to everyone. They apply to you.
Yes.
They apply to recruits. They apply to cadets. They apply to people on field training and experienced officers as well. Is that right?
Correct.
All right. I'd like to show you what's been received as Exhibit 17. I need to ask you, officer, as you look at Exhibit 17, is this a trained technique that's by the Minneapolis Police Department when you were overseeing the training unit?
It is not.
And why not?
Well, use of force according to policy has to be consistent with MPD training. And what we train are neck restraints, the conscious and unconscious neck restraint. So per policy, a neck restraint is compressing one or both sides of the neck using an arm or leg. But what we train is using one arm or two arm to do a neck restraint.
And how does this differ?
I don't know what kind of improvised position that is. So that's not what we train.
All right.
Yeah.
You can take that down. Thank you. I have no further questions.
You may.
Okay, we've just seen right there the prosecutor question Officer Katie Blackwell. She is an officer with the MPD. She handled training. So the prosecutor went over training logs and workshops that Chauvin would have attended that dealt with use of force and also applying medical care as well. So the last part of her testimony, she was shown I believe it's Exhibit 17, and we've all become familiar with that one. That is the still photograph of Chauvin with his knee on George Floyd's neck. And she said she did not know what type of improvised move that was. It was not anything that was a part of the protocol that they learn in training. So yeah, that again is Katie Blackwell, an officer with the MPD. We saw Eric Nelson, the lead attorney on Chauvin's defense, walk up to the prosecutor and begin questioning him. He asked the judge if he could do that, and they appear to have walked off to further discuss or go somewhere off camera there. So we're just awaiting for potentially Nelson to come up and do a cross-examination of this witness. But this is a part of a long line of answers we've heard all day today from witnesses who worked with Derek Chauvin. We've heard from the chief of police and this woman as well, who have said pretty clearly that this was not a part of the protocol that they use in the police department. We also heard from the doctor who pronounced George Floyd dead back on that day, and he went over his medical analysis of the situation. He said that George Floyd, in his opinion, died of lack of oxygen. So that was another headline out of today, and it has certainly been a lengthy day. The courtroom started off with going over decisions of what questions to ask, who should be on the stand today. It looks like the two attorneys are back. Let's see if they start up again.
Yeah.
Good afternoon.
Good afternoon, sir.
Just want a few follow-up questions. In terms of any in-service, you see, when we look at the exhibit, you see 2020 defensive tactics in service, and it's worth 8 hours of time. Agreed?
Correct.
Now, in that course of that 8 hours, officers may go through multiple trainings during that 8 hour time, right?
Correct. They rotate through things.
I'm sorry?
They can rotate through different.
Right. So within that 8 hour time frame, they may get a class or an hour-long class on, say, the human factors of force, or they may get an hour-long course on handcuffing techniques. It varies within each of those 8 hour time frames, right?
Correct.
Now, have you maintained a list that shows 2020, these are the classes that occurred during those 8 hours?
We have.
Okay. And have you provided that list to in response to the search warrant that was executed at the police department?
Yes.
Okay. Now, in terms of the defensive training tactics or any of these continuing education classes, there are other officers that actually train these classes, and multiple officers may appear during that 8 hour time, multiple trainers, right?
Yes, we have part-time trainers.
So there would be maybe one person will teach the human factors of force, someone else may train on crisis intervention, and there'll be multiple instructors, right?
Correct.
But a lot of the instructors will use materials from past instructors, or they'll take combinations of things and they'll just represent it in a slightly different format, right?
At times, yes.
Right. And I just, for the record, I want to ask you, you were served, or the Minneapolis Police Department was served with a search warrant requesting all of the training materials for the four involved officers in this case, right?
Correct.
And so this would be materials that were from, some materials that were from the police academy, some materials that were from in service, just a variety of different records, right?
Correct.
Some 30,000 pages perhaps?
Thousands, yeah.
Okay. I have no further questions.
Any redirect?
No, Your Honor.
Right. Thank you, Inspector. You are excused. Here's the jury. We're going to take our break for the day. We have a hearing we have to do at 8:30, but I'm still hoping that we can get started by 9:15. So same arrangement as today. Thank you. Just a reminder, don't talk to anybody about the case. Don't read in the media. Appreciate your patience. Thank you.
That wraps up a big day for the prosecution with key testimony from a doctor about the likely cause of George Floyd's death and a vehement impeachment of Derek Chauvin's actions by the Minneapolis Chief of Police. You are watching a special report from the newsroom of the Washington Post. I'm Rhonda Colvin. With me this evening, Eugene Scott, reporter for The Fix, and James Homan, Washington Post columnist. So we just wrapped up with Inspector Katie Blackwell, who gave a brief testimony there, mainly questioned by the prosecution about the training that Chauvin attended. It was both training that dealt with use of force, also training that dealt with giving a medical attention when you are arresting someone and what the protocol is there. And she seemed to match what we've heard from some of the other officers who have said they basically don't recognize that force that Derek Chauvin put on George Floyd, that's not anything in their protocol. She even discussed how usually they might use both hands to restrain, but he used his knee, and she did not recognize what that was, she said. James, first with you, what was your takeaway of this last segment today?
Yeah, Rhonda, it's significant and it's important. You saw Eric Nelson there at the end with very brief cross-examination, basically try to get at the idea that maybe they didn't cover everything every time, and we don't know exactly what training Derek Chauvin got and that it might have been slightly different. But you didn't see him do what he did with the chief earlier, which we discussed during their last break, which was to say, you know, when was the last time you actually arrested someone? Have you been in the field? Because this is a field commander. I mean, this is someone who's on the streets. This is a precinct leader who's spent decades in SWAT, as a decorated Minnesota National Guard sergeant major, and she kind of cumulatively built on what we've heard, and it is significant seeing someone who's a senior official in the police department, a uniformed official there, testifying against one of their own. She was less firm, in terms of the language that she used than the three other officers that we saw, but some of that was based on what the judge said earlier this morning when there were all those motions at the start of the day, and the judge basically didn't want the prosecution asking her to give her personal opinion about whether what Officer Chauvin did was right or wrong.
Yeah, that's a good point, James. That's how we started off this morning, is the defense and the prosecution trying to figure out if Ms. Blackwell, as well as other people who are expected perhaps tomorrow or later this week, could weigh in here and give testimony. That was actually a lengthy part of the morning and caused a bit of a delay. Eugene, what was your takeaway in that last moment?
Well, I think it was very clear from the testimony that Derek Chauvin was operating and acting in a way that was just inconsistent with the training that law enforcement in the Minneapolis Police Department have received. And I think what that does is put him in a position to really try to make the case, obviously his team, that what he did was necessary, considering that no one who would have gone through his training or been over him would have recommended that he behave the way he did, considering that that just wasn't consistent with what is, protocol. Also, concerns about his lack of attentiveness to Floyd's health care and well-being continue to surface and draw attention to one of the main points that so many of the witnesses that spoke last week tried to nail down, that this was a law enforcement officer who did not seem concerned about the safety and the well-being of someone under his care, which appears to be in direct violation with the oath that he took when he decided to serve his community as a policeman.
Let's watch some of Eric Nelson's cross-examination of Chief Arredondo. He is the chief of police of Minneapolis, and he came before the witness that we just saw. And here's a clip of what he had to say.
You testified on direct examination that it is contrary to the training that you've received to place your neck or your knee on a subject's neck.
Counselor, if I can clarify. It is contrary to our training to indefinitely place your knee on a prone, handcuffed individual for an indefinite period of time.
So the issue that you take with it is the length of time?
Counselor, there's a couple of issues, and one of those, again, is, as you noted, receiving the information. Is the person a threat to the officers or others? What is the severity of the crime? Are you reevaluating and assessing the person's medical condition? So all of that critical thinking, that's really key for me in terms of why I vehemently disagree that that was the appropriate use of force for that situation on May 25th.
James, we are starting to see more of the defense's case. What do you make of Eric Nelson's strategy today?
Well, you saw him try to pick holes there, and then the chief saying he vehemently disagrees. Strong language from a chief of police. And their strategy clearly is to show that, you have to improvise, you have to adjust, only the officer really understands the full context of the situation, that the police should be given the benefit of the doubt. And if they were, if the police or policing itself is on trial, the chief really, and the inspector that we just heard from, really acted as the defense for those institutions, and in many ways sort of tried to disown Chauvin. But what Eric Nelson is trying to do is to say, no, what he was doing is very consistent with what an officer could be reasonably expected, the key legal threshold, reasonably expected to do if you had someone who was resisting arrest and you couldn't get under control, that you would do that. And then you heard in that clip, which was really a great synthesis of the back and forth, was the chief's issue how long it was, that it was the 9.5 minutes, and the chief kind of he didn't backpedal, but he clarified it's that for sure, but it's also the whole host of other things and not considering everything around. One of the interesting exchanges that came a few minutes after that clip we just saw was on redirect when the prosecutor asked the chief, hey, but wouldn't one way to reduce tensions and to get things under control to be to listen to the angry crowd rather than antagonize them more? And the chief said, absolutely. And that was the end of the prosecution questioning the chief. So, but you're absolutely right. This is a window into where they're going to be taking us, which is to show or to make the case that Chauvin was very much in league with what other officers would have done in a similar situation.
Yeah, and here's another clip as well that gets at the heart of that. Watch Derek Chauvin's attorney, Eric Nelson, use the words objectively reasonable in his cross-examination of the chief of police.
What we're basically talking about was a United States Supreme Court decision that outlined the objectively reasonable use of force standard, right?
Yes.
And Graham versus Connor is not limited to those three factors that you were read before, right? The Graham versus Connor analysis.
Yes, correct.
Those are three that are kind of listed, but ultimately it's not an all-inclusive list of considerations for the reasonableness of the use of force. Agreed?
That would be my understanding, yes.
And in fact, what the policy reads is that the reasonableness of a particular use of force must be judged from the perspective of the reasonable officer on the scene rather than with the 20/20 vision of hindsight, right?
Yes.
So we're looking at it in the instant and the moment based upon the objective standard, right?
Yes.
Now the policy also includes that the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation, right? Yes. And that's because when officers go to a situation, kind of like what we talked about before, what can be initially very minor can grow into something major. Agreed?
Yes. Our colleague Mark Berman points out that this defense stems from the Supreme Court's Graham versus Connor decision in 1989, which established that a police officer's actions must be judged against what another reasonable officer would do when facing the same scene. The reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with 20/20 vision of hindsight, the court ruled. So, you know, Eugene and James, I think we are getting a lot of education here on policing, on precedents, on what could be determined as Chauvin's frame of mind while he was restraining Mr. Floyd. We've talked about so many times about how important this trial is. Eugene, is this educational component one of the reasons why this is something everybody should be watching?
Absolutely. I think there are questions that many people who are policed have about what goes into policing. And I think in Minneapolis, at the very least, today it's provided some insight, at least from those in management, in terms of what is acceptable and what is not, what goes into training, how law enforcement officers are expected to respond when they witness healthcare concerns, and also even how they should perhaps interact with the community and onlookers who are expressing some concern. But I think another highlight from this moment today that many of us will take away from is the attempt, at the very least, from Nelson to cause some distance between law enforcement that's in management and law enforcement that's on the ground and in the streets, and trying to suggest that perhaps what's on the books and policy perhaps may not be in the best interest for those who are actually interacting with the people that they are serving.
Yeah, and James, in talking about the education that people can learn by just following this, I think one of the things that we learned a lot about today is that officers are tasked with considering the health care of the person that they are arresting. That we've been talking about how this trial is about the use of force, but there is another side of the coin, that even when you utilize a certain form of force, you are also tasked with making sure that person has had CPR if they need it, is being attended to, and that goes back to what the witnesses last week said when they were calling out for Chauvin and the other officers to check the pulse of George Floyd.
Yeah, Rhonda, the duty to care is a legal term, and it is absolutely applicable. And that was one of the reasons that the EMT, the off-duty firefighter we heard from, Genevieve Hansen, last week, was so damning for Chauvin, because she's standing there, and that's going to end up being huge at Officer Tao's trial in August. But basically trying to help, doing what she actually, her duty as a trained firefighter and EMT is to help, and so she's trying to get these other officers to let her help, and was obviously despondent and angry that they wouldn't let her. And one of the things that becomes important, and you explained the Supreme Court case, and ultimately it's going to be up to the jury. There's obviously criteria that have been laid out by the Supreme Court, and there's other case law, but ultimately it'll be up to the jury to weigh whether a reasonable officer would have kept kneeling on George Floyd's neck for 9.5 minutes. But there's a distinction between whether Chauvin violated department policy, which he clearly did. We saw the policy written down, black and white. He signed that he, agreed to it. We heard just now from the inspector that he received this training. But there's a difference between violating department policy and violating the law. You can violate department policy and get terminated, but not have broken the law. And so that was part of what Nelson was also previewing, which is, sure, they may even grant that he violated some of these policies, but that's not what he's on trial for. What he's on trial for is murder. And there are some legal definitions and terms that he's going to lean on very hard as part of his defense once the prosecution rests.
All right, and I want to get final thoughts from both of you. We have about 2 minutes left. Eugene, we heard first from the doctor who pronounced George Floyd dead. We heard from the chief of police, and then we heard from the last person who was the inspector and in the department and overtraining. Out of those three people, what stood out to you today?
Well, I can't help but to keep thinking about what we learned about the responsibility of law enforcement to care for those that they are detaining. I think many people who interact with law enforcement, especially from Black communities, definitely don't feel cared for, and would definitely like to see law enforcement improve and make strides in that area based on what they've heard today.
And James, to you, out of those three people that we heard from, it was a lengthy day, but three witnesses. Who stood out to you?
The chief. I mean, the chief of police is just such a huge moment to have the head of the force who's been an officer since 1989.